Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
As the agent for Peyton Ansley, John Milton, you are indicating to me that you're quite familiar with Peyton Ansley, John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley, John Milton, as written in all capital letters.
All right, and you understand for my purposes,
I object.
So that language doesn't make any sense. So
No, I do not.
I understand? Okay, well, I'm telling you that. And so I am, until you disabuse me of the motion,
There's a lawsuit.
I am inclined to believe that you are both the agent and the person. And it's in
I'm
all
not a
caps.
person. I am one of the people. Thank you.
All right, okay, thank you.
Alrighty, almost ready. I'm just getting dressed here. We'll just enjoy the music for a bit longer.
You're talking about stuff that is not relevant.
I was kicked back, taking it easy.
I can't work with long sleeves. I don't know what it is. I cannot have the long sleeves. I just gotta roll them up. All right. Ooh.
I'm not a cat.
It would help if I had a camera right there.
Because he's the guy.
Now I wish that I had worn pants. Hold tight. We're just going to listen to a little bit of music for a minute.
I'm not a camel.
Nothing to see here. We're just going to do this for a second.
Somebody just sent me a video of roaches fighting.
There we go. There we go. Wow. Yes, a little bit of a wardrobe malfunction. Got it all under control now.
I'm not a cat.
There we go. Okay. Apparently this camera needs to be plugged in to work. We learn something new every day, but now this camera plug is a necessity. We know that now. Okay, we're going to turn this off. Oh my goodness! Welcome to the Court of Public Opinion. I am the Recovery Addict. Good morning. It's been a morning for sure. No, I didn't just get out of bed at 8:43 this morning. Why do you ask? Who would have? Really? Who would have? No. Okay. Well, anyway, we're here now. We're here now. You look fuzzy from camera number one. That's because yesterday I was filming a piano video for my son. He's entering an online piano competition. And my son has been playing the piano for a little over a year now, and he plays beautifully. I'm not sure if any of you have learned how to play the piano before. I have not. I can plunk out a couple songs, but I can't read music or anything. And but he started, and literally he didn't know where middle C was when he started a little over a year ago. And he's been using this program called Piano Panacea and Piano Marvel. So it's an online training. Plus, he meets with a group regularly of other students, and he's just learning songs he likes and learning how to play. So I edit together a beautiful, beautiful video. I mean, we've got 3 camera angles. We've got like a ghost image of in the piano.
Is that correct?
Yeah, I did a great job of putting it all together. And then last night this happens, boom, and I lost all my audio files, my video files. I just lost connection to everything. So we are fixing that, and I'm going to re-edit the entire thing, and apparently that's why my camera was unplugged, so I had to use this one for some of the artistic shots. Okay, let's see. Who was first in chat? First in chat today, welcome to Mystic Mama, first person in chat. Congratulations. She says, see, I'm here, see? Welcome. It's good to have you here.
There's a lawsuit.
Yeah, I'll be editing that video like while we're talking. How about that? It's no rush. It's no rush, but we'll get it done here sometime later today. It's not complex editing. It really isn't. It's just I just have 3 different cameras that are all recording. One of them has audio. I have to sync everything up precisely so the keys are being pushed at the same time. When you see him twice on the screen at the same time, like everything has to match. And then I've got there's one part where he does this really cool haunting little down the piano, which is really cool. It sounds better than what the
When are we going to break for lunch,
but
Judge?
chat isn't on screen.
Have them send someone with more
It's in the
experience.
wrong place, but it's on the screen. Apparently, I need to wake up earlier in the morning because 8:43 is not cutting it. When we're supposed to be live at 8:45, and then I stretch it out till 9. Okay, Mystic Mama, you were here for 12 months. Where did that go? Hang on one second. Wait. We can't just be losing chats like this. Hold tight. Man, I'm way behind. Okay, here we go. Mystic Mama, here for 12 months. 12 months. I apologize. Mystic Mama, 12 months. And you own the internet. Congratulations. The internet is all yours. I'm pretty sure you've won before. It's been a while, but this does count as recidivism. You're back again up to your old antics. Welcome. Happy Valentine's Day. Oh, crap. No, just kidding. No, we're good, guys. No, I wouldn't do that.
When are we going to break for lunch?
Happy Valentine's Day. I hope you guys have a wonderful Valentine's Day. Taminator61, happy Valentine's Day to everyone. It's going to be a great day. I believe it will, now that we're sort of up and running. I think we're, let's see, I've got a buffer sound somewhere. We've got, let's see, Simone, Crystal, the state of Arizona. Like literally, Arizona is 112 years old.
Somebody just sent me a video of roaches fighting. I don't know who won.
I trust you. I'm not fact checking you at all. Hey Siri, how old is the state of Arizona?
The answer I found is 112 years.
Yep. Okay. State of Arizona, Alita Lay has a 26th wedding anniversary today. Happy birthday, or happy Valentine's birthday. Oh my goodness. And I'm not sure. Should we sing first? Can't find the button. There we go. Here we go. All right, I'm ready.
Mike. What day is it, Mike? Guess what today is?
Scratch all that. Oh, that was terrible.
It's hump day.
I apologize.
Hump day! Welcome to Wednesday. Welcome to Wednesday. Oh my goodness. Okay. There's we've got the buffer. We've got that. Sharon's still on the screen here. I won't forget. I promise. Let's see. What else? Victoria Holm, my son had his 13th birthday yesterday. You got a teenager. Congratulations and our condolences. Yeah, teenagers are fun. We love our teenagers. they just, you never know what you're going to get. It's exciting as, they're trying to figure out growing up and everything else. All right, let's go ahead and sing birthday wishes to Simone, Crystal, and the state of Arizona. Because, how often do you turn 112 years old? Not very often. I'd say like once in 112 years. But we're going to sing to Simone, Crystal, and Arizona. Now that we've all done the hump day cheer, we're already warmed up. And my volume was a little low. There we go. Happy birthday to you. Happy birthday to you. Happy birthday, Simone, Crystal, and Arizona. Happy birthday to you. What do you get the state of Arizona for its birthday? Wrong answers only. No, Pickles, not politics. Before I open that door. To everyone who's celebrating a birthday today or roundabouts today. That is super loud. Is it like... Oh, that's better. It was loud in my ears, but not yours. All right, snow, offense. See, that's what I'm saying. Pickles, not politics, right? You make a mesa, cactus, tacos, sand, sunblock, air conditioning. Good answers, great answers, all of them. The rain cloud, they'll be happy just for the cloud, for a little shade. To everyone who's celebrating their birthday today with Arizona, congratulations. This is your special day. I realize there are a million places you could be to celebrate, a million people who would like to celebrate with you, but no, you chose to be here with us, and that is not lost on me. Thank you very much. Hope you have a wonderful day. Hope we can make it a little bit better. We'll start that off with, you guessed it, yes, we have a police chase this morning. I thought, Arizona needs a good police chase. They're going to learn from one of their states, their neighboring, well, not neighboring states, but all the states are neighbors. Like, what state is my neighbor, right? Can Rhode Island still be my neighboring state? I think so. I tell you, I wouldn't visit it very often just because it's not very big. But one place I would visit is Arkansas. I'd like to visit Arkansas. Oop, that probably looks less good. Let's go back to this one. Let's see, where are we? I've got it here. That's why. It's going to be a long day. I can feel it already. Things are not working the way they are supposed to work. Okay, we have a police chase that is brought to you courtesy of the town of Tontitown. Let's see here. Well, no, you can't start yet because you guys aren't watching. I have to wait until you guys are ready to watch. Okay, so did I forget anything else? Probably. We can come back. We have a beautiful police chase. What are you guys looking at? No, the wrong thing. Come over here. Look at this. This is where the police chase is. At least where it's supposed to be. There we go.
South on Industrial.
No police chase is complete without there being a U-Haul vehicle involved, and sure enough, there is one.
Coming a pit at South on Industrial. 2 mils. Probably 2 mils. Still out. You got away from us.
There's our U-Haul. And these cops look like a herd of cats, or probably better description would be like Little League football players rushing to the ball carrier. That's what we have right here. No one's playing positions. Everyone's just like jockeying to be the person in front.
14 TPR on that thing. I'm not a cat. Not let him back on 412.
Don't let him back on 412. Whatever you do, don't let him back on 412, because if you do, I'm going to have to fix this problem.
Take a wrap.
Passing 1, passing 2. Now he's in second place. We have a good view here. This is good. Ooh, surrenders to the faster vehicle. We're now in first place. Well, second if you count the U-Haul.
Eastbound through Barrington, primary. Copy eastbound Barrington, Tontitown 1's primary.
This is some next level driving. Look at that. Man, that was close.
Copy 412.
This is heavy traffic. Red light. Oh, they went through.
3 Jones.
Is there a pit? Can we do a pit here?
Hi, Tommy, if you have updated speeds in 20. We're at 83. Heavy traffic. We're passing good right now. James 5. Cody Charlie, coming up to 49. Coming up to Gene George. Approaching Gene George. 49. 85.
This is nuts. They're still at 70 miles an hour, 65 miles an hour here.
Gene George right now.
Oh, here we go. No! Tanker truck blocked the shot. That was terrible. Could have got it right there. Oh my goodness, how did it not hit? This is crazy. Shout out to KFC. Just saw them there. Semi in the way, semi. Get in here. Got him. Hook the bumper. Wrong way traffic. Split the turning lane. that a Wendy's? Doodle Mom NC and Jerry, happy birthday. I'm sorry we missed you in the song. My apologies, my fault. Up to 75 on the on-ramp. Oh, this is lighter traffic. Let's do it right here. Let's do it. Got him. Dispatch, I'm gonna need a tow.
I'm good. I'm good.
Are you alive?
I'm good.
Are you alive, buddy? Okay, guess what? We get another view. Not one more view. We get 2 more views. Let's do the entire chase again from a different perspective. That'll buff out. It'll buff out. These cars are tough. They're built different. They're just built different. You got to choose a direction, dude. You can't. These kids, they're all running to the ball. Run to the ball. I'm not sure what happened to that utility truck, but it just took a right. Maybe it got a flat tire. Just a scratch. Oh, you let one car pass. Now everyone thinks they can pass. Gotta be careful, dude. Yeah, you're still in second. Still in second. Watch out for the state guys. Those state guys try to butt in every time they can. Green light for you. No crime there. This is why you don't buy a used cop vehicle. For those that were in the market. I see an Arby's. Why did I miss Arby's last time? I clearly have an Arby's right there. Heavy traffic. Ooh. Through the chicanes. Not sure if you noticed, but gas is only $2.65 a gallon here. Which is good because they're using about a gallon per second at the way they're driving their vehicles. You got to go. Look at that. The state guy took you. You had like 2 open lanes and you let him pass. Watch out for the delivery guy. Thank you. Now choose your path. You got a lot of debris in the road. Choose your path carefully here. You don't want to get blocked behind a slow vehicle. Tanker, you chose the right. Okay, that's different, but you lost. Oh man, that guy. Unfortunately, that police officer is missing most of his rear bumper. Well, not missing it. He's just dragging along with it. You're really falling behind, my dude. Don't let anyone else pass you. We're going to miss all the action at this rate. Left, right, left, left. Okay, good. Oh, the state guy got trapped. Good. We can take him here. Okay, now you're way back. We're way back, and we know that the action's happening right about now. So watch ahead up underneath those signs. Not the close ones, but the next one's up. Looking for dust. There's a spin. It hits a boom. Hits the side. And we have some
roll over.
Yeah, that was 3 rollovers. Ooh, chase is not over. Yippee. Oh, that's gonna need some ice.
Charlie and Randall, airbags deployed, airbags deployed.
Oh. Airbags deployed. At least they're airbags. He hits the window out of frustration. It does nothing. I can read lips. He's saying, would the occupants of the vehicle please get out? Let me open the window for you. Please, we'll only ask nicely 10 more times. Please kindly disembark. The ride is over. Oh, no one will notice me stepping across right here. There's a hand. Yep, just come right out through the broken glass. There you go. Just stick your body right out there. You know what? We will help you. We will help you. Oh. Yes, something was fired there. Something was fired, but I believe it's a less than lethal. I think that's a tear gas round. He's struggling to reholster it. He's ready to do it again. He said, "Please get out of the back of the car." I can tell what he's saying here. They're saying, "Thank you, thank you, thank you for complying." There was a tear gas charge deployed, I think. All right. That was pretty cool. Good thing we have one more angle available to us. Yes, we get to watch the chase one more time from another perspective, another loser, because there's only one winner in the chase, and that's the one in the front. But we'll get just a minute here. We'll see if we can. Not sure what. Oh, because we had to see that. Why did they not cut this part out? I hear music. Why are they playing music? We're gonna get like a zing for that. No, I think we're gonna be okay. It's really quiet, and as long as I keep talking, I don't think it will be able to tell it. So let's talk amongst ourselves while we wait for.
I know. I'm good. Anybody got some towels or wipes?
Towels or wipes? Anybody? Okay, view number 3. It's another individual.
South on industrial. Copy, south on industrial.
Oh, you chose to get out of the car? Why did you get out of the car in mid-chase?
2 mils. Copy, 2 mils. Still out. You got away from it.
He got away.
My car went. That's my car. Then carries passenger radio.
Ooh, that was a rock on the undercarriage, I'm pretty sure. Ooh, we see the bumper issue. Pass him. Don't let him take you. That was a speed bump. You just about didn't make the corner, dude.
Hey, let me around you.
Don't look now, but most of your car is not with you.
14 from the lead. Within stable.
I'm not sure if he was going to let you pass or not. Just own it. You've got half the lane there. Just go. Come on, guys. Now's not the time to be polite. Just floor it. He's got some pickup.
We're coming up to Jones right now.
Wonder how much better the car ahead of you is doing without the added weight of its bumper.
Through Jones.
left. Oh, he took the right. You took the right too. Was that a wise move? Was that a wise move?
Hi, Tommy. You have updated season 20. Ready, free. Heavy traffic. Right now.
You're like a quarter mile back, dude.
Heavy traffic coming up to 49. Coming up to King George.
Approaching King George. 49, 85.
This is in Arkansas.
Coming up to the intersection King George right now.
Left, right, left, right, left, 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 left. Apparently that's the right choice.
Continuing eastbound through King George.
10-4.
I can't even see the leader from here. Split, split, split. This guy goes left.
You able to DVR or no? No, not yet.
See, it's already happened.
16, Tontitown, unit direct.
I can see the dust cloud. Got the rollover.
Medicals en route.
Skid marks everywhere.
Airbag deployed, airbag.
Handbrake turn. This guy walks up like, "Hey, what's going on?" Oh, wait, we're doing the guns? We're doing the guns or no? You can't decide. Yeah, this has made me rethink my decision. U-Haul apparently makes better vehicles than I thought. This is right along day. In the black car, there's somebody in that black car. No, I think it's actually the driver, the officer, because he's rammed in. He's stuck. Let's see if he can climb out through the passenger seat. He's trying. He's trying to climb out, hands and knees over the console. That is not comfortable. There we go. Not glamorous either, but hey, you're out. Watch where you're pointing that thing. Yep, we're now in a full circle around it. What could go wrong, right? What could go wrong? They're going to help the one dude out of the car here. He's on the ground. Nice. I know there's more views of this. We just need to make the right request to get other footage. Thank you very much for the police department for making those available to us. Thank you, thank you, thank you. Well, not that one. Not that one. That's a different one. Yeah, so Arkansas once again delivers on the police chase. They do it in a way that nobody else does, mostly because they just don't care. I mean, don't take me wrong. They do care, but they don't care what happens to you or to them in a pit maneuver. Many cars were harmed in the making of this video. I think the entire fleet of vehicles was harmed. Tontitown, that's where the Duggars live. 19 kids and counting show. I don't think the dog got any action. The canine was just there for moral support on this one. But anyway, that was a great chase. Props go out. Oh. Something has arrived to me that I don't think I ordered. It might be tape. Oh, I did order it. I'm so excited about this. This is 2 rolls of gaff tape. 2 rolls of gaff tape. Also known as gold. No, it's commonly referred to as gold at any gig. Anytime you have a job to do where your cabling is involved, this is it's like very thin, long, sticky gold. Yay, that's awesome. Can you stick that on that bin right there? Thank you. All right, now I just need about 15 more cables and we'll be good to go. I got 7 new cables yesterday, all HDMI, because you can never have enough of those. All right, so we had a police chase. We are still in the pursuit though of a good trial to watch. So we're still going to be court hopping today. Not duct tape. See, duct tape leaves a sticky residue. Have you ever tried to peel it off and then it leaves half the adhesive behind? This is gaff tape. You know it's gaff tape because they charge $15 per roll for it, even on the little 2-inch wide 30-yard version. So it's very, very expensive. It's the most expensive tape I ever buy, but it is worth it. There were 2 anniversary chats. Oh, no, I missed those. I apologize. Let me go back and find them here. Let's see. We had Reverend Beasley says, love you all at the Michigan-Indiana border en route to Chicago. Just wanted to say hi. Reverend Beasley, thank you very much. Drive safe. Drive safe. Robin says, could we just pick a trial that's already happened that we didn't watch at the time? I think LNC has playlist. Just an idea. Happy Valentine's Day, y'all. We actually run into issues if we do that, issues for the channel, legality-wise. So we have to be very careful about what we get and which permissions are available to us. But I thought as long as we were just doing court hopping, I could at least reward you with the chase. And since that one came through, I thought it would be appropriate to add that today. Okay, Cyber Editor, Judge Boyd. We did some homework on Judge Boyd. She did a jury selection yesterday, and she has a jury trial today. And normally we would be like, oh, yay, but it's not one of the good cases. It's one of those cases that has kids and things involved, and no bueno. No bueno. We can't go there. All right, I did watch the jury selection, though, was funny. Let me just share this with you. Judge Boyd does her regular intro where she talks about her mom and what her mom says she should tell juries and everything, and it's funny, but we've heard it before if you've heard one of her jury selections. And at one point she says, now this defendant has been arrested, and he's charged with these XYZ crimes. But he's charged, but he's innocent until proven guilty. Are there any of you who can't view him as innocent and would just be, holding to the idea that because he's been arrested, he's obviously guilty? And number 39 shoots up his hand and is like, me, right here. Yep. If he's arrested, he's guilty. And the judge is like, really? Fine. Number 39. And he's off. That's the quickest way to get off the jury. Answer that first question. Yes, I'm going to hold it against the defendant. They were arrested. Clearly, they're guilty. Let's see. I have a package at the post office right now, Tammy, that I need to go get, but I did not have a car yesterday, and it's a long way to the post office. Let's see. Yes, gaffer's tape. I call it gaff tape because it's easier to say than gaffer. Did you see the Sarah Boone new attorney assignment? I did. I'm actually waiting for Sarah Boone's new letter. I anticipate a letter to come through on this new attorney because she's going to complain about losing her old one. I think there's a letter coming. Okay. Let's see. What else is the... Let's see. My van was involved in a hit and run yesterday, so my van is out of commission. My other half was in the van. He's okay. The van, not so much. Karina, that is no fun. That is no fun. I'm sorry that happened to you. Please check mod chat. Apparently, this is something I'm supposed to do on a regular basis. Let's see. Got a possible trial. Hang on. Let's take a quick gander at this one. Don't want this. Where's my mouse? There it is. So I'm just taking a quick peek at this court. It's a Let me see if I can get through another feed here. Hold tight, everybody. Don't go anywhere. Okay, let me see what we've got here. What are they listening to?
Is she not cute? So she is somewhat clear, but she's not as clear.
Who?
She's a clear,
Marie? No, she's not here today.
but not super chunky and bulky. It is very like.
She's not, how does she get her feelings hurt if she doesn't know?
Okay.
Nobody can have their feelings hurt if they don't know. I've never followed this one before. Judge Hare's on point. Lots of flair.
It's not on us.
What state is this in?
Mm-hmm. That's on them. That's why I'm making the announcements at the call docket. That way we have
It's
a
got to be
record.
Texas.
And telling them they're going to be here at 8. And we have double, triple notice to them. It's our blood.
The background says Texas. Just trying to figure out what's going on here. It's in Bexar County, Texas. We love Bexar County. Bexar County has very open policies. It says Texas Court 13. Drug court. Is it going to be a trial, though? We've heard that they were in Vordier. Look at those swinging cheese grate things. This judge is wearing all the bling. Judge Rosie Speedy Gonzalez is, I think, who we're dealing with here. And she sings. Well, we'll keep an eye on this for just a minute. I have to tell you, the other day after we took an early break, because we didn't have anything to follow in the afternoon, so we took a late lunch and then an early break, and I got sucked into the vortex of YouTube and YouTube viewership, and usually I'm on the other end of that, right? So you guys are sucked into the vortex. You're here watching with me, and you can't leave. But I got sucked in as a viewer, and I went over to Airline Videos Live, and I proceeded to watch an entire day's worth of departures and arrivals in LAX, and I was just I was sucked in. Not that I like planes, right? I like watching airplanes, but I was sucked in because I was like, okay, how's he doing this and how's he doing that? It was the technology side of me. What is like, clearly he's on the roof of a hotel, Okay, it's a great channel. It is a great channel. I love what he does. He's on the roof of a hotel putting out a ton of content in a very difficult environment outside with the noise. And so I'm picking out, okay, he's got a shotgun mic here. That's how he's getting his sound. He's running it through the new Rodecaster Pro 2. That's how he's getting his audio. He's got a police scanner audio in through the Rodecaster. And I'm sort of building in my mind, I'm building his set. And I hear he's got running flight radar. That's how he's getting his flight information with the arrivals and departures and destinations. And it's all sort of clicking together. And I found the lens, and he's running it looks like he's running the Sony A6700 camera with a 200-600 lens. And he's got mounted on the back of the cameras, which was a concern because they're out in the sunlight all day. He's got a little battery-powered fan to keep the camera cool. And just so I'm in my head, I'm like, this is cool. I'd love to do something like that. That's really cool. But I'm more interested in how he technically made it all happen. And so I'm watching I watch the entire stream. Like the entire day is just going on in my office here as I'm working on editing and everything else. And then at the end of the day, the very end, I go to his channel to see like what else has he done, and I see, this entire time, he's had another live shot of behind the scenes that show all the equipment that I'm like trying to piece together and gather from his words and how he interacts with it, what it is. And I see, he's got a behind the scenes shot that shows exactly how many battery packs he's running, exactly where it's plugged in where, what tripods, what umbrellas. Oh my goodness. It was funny. So I watched airplanes all day long. But it was really cool. Anyway, so we're going to watch and see what happens here. It looks like we might have a trial in the works, and it might be drug related, which would be fun. I got punked. Mushroom forms to airline departures. It's a slippery slope. No intervention needed. It's okay. I can quit anytime I want, John. I'm fine. I can quit anytime I want. I'm in full control. I have gear acquisition syndrome. Also referred to, some people say I have gas, but it sounds bad when you say that. But gear acquisition, sometimes you can change it to tech acquisition syndrome, which is a terminal disease. You die from it or with it. It depends on how you view it. But Shares, I love channels like that. Shares, here's what I like about it. Okay, it's cool. Airplanes are cool. I've always liked airports. That's cool. I couldn't tell you, that's an A380, whatever. This is a Dreamliner. I have no clue. Like, that one has more windows than this one. Look, these ones' wings have little things on the end. That's all I know. But I like watching them work, right? But the thing that drew me in is he's doing something that normally you could only see done in a studio, right? He's putting together this very highly produced live stream, and he's doing it on the road. Not just on the road, on the roof. And that's what why you die with all the toys. So yeah, win-win. Anyway, that's what I liked. Do we need another man bun emoji? Where's the man bun? Oh, it's front and center. I do see that. Okay. But then you discovered someone doing something you've been trying to figure out how to do for the last week. As Shares, what was interesting is I looked at his gear and I could see that the little umbrellas he had. And that's how he's trying to overcome the problems he's got with overheating with a lot of this gear, because he sits in the sun in LA and it can get hot down there. It can. And so he's just chilling out there in the sunlight. I'm like, my laptop, it would die. It would be like, I'm done. I'm not going to play this game if it sat out there in the sun all day. But he's got different ways, different fans set up. So many power banks. I think I counted 7 power banks that run $500 to $1,000 each to run. So I mean, he's committed. Not to mention he's got probably close to $4,000 just in lenses of the 2 cameras I saw. Another maybe $3,000 to $4,000 in cameras. Maybe $5,000 Depends on what the unseen camera was, because there's one camera that's filming everything else. He must have like a whole crew of people that helps him carry that stuff to the top of the hotel. And now I'm curious about how he gets the deal with the hotel. I mean, does any hotel just let you run up to the balcony level and set up shop for the day with all that stuff? Power banks and batteries are the norm here because of load shedding. Maybe you can get them for cheaper. I have to trust mine. I have to trust. I cannot get a secondhand unit. I cycle mine through. As soon as I detect that that they're not performing as well as they should, I will send them to a recycler. Amanda, we're talking about I think it's Airline Videos Live, AVL. And he like flies around the country. Like he does LAX, he did San Francisco, he did Atlanta. I think he's been to JFK, all over the place. I think he drives around. He goes on the parking garage too. Who is he? Kevin, I think is his name. I think his name is Kevin. But all right.
And we'll have a solid list at the fourth docket call. This is our third one. I'm recalling case number 722-250, Socorro Torres. The state has announced ready. Mr. McCrae?
That's trial if the state's announcing it ready.
So it'll be a plea? We're not taking you off until you confirm that that's going to be a plea, Mr. McCrae. Come on up.
We would love to be able to hear.
What is your question?
May hold at the court's discretion the affirmative finding and in this case we would like it not to be deferred.
Is it a deferred?
It's probation.
It's straight probation? I don't hold it in abeyance on straight probation. That's a guilty plea. The affirmative finding of family violence will be issued.
Yeah, it is.
Oh, it's a VPO?
Yes.
Then it cannot be issued, even on a guilty plea.
But it's taken into consideration of felony. So that's why we want to have.
Taking into consideration means you're dismissing the felony. It's not going to have an affirmative finding of family violence. Okay? Yes, sir. Case number 721-994, 721-995, and 721-997. Crystal Amador, also represented by Mr. Leland McCrae. State, what is your announcement? Dismissal forthcoming on all three on Ms. Crystal Amador. Ms. Crystal Amador is dismissed. You may leave if she's here. Case number 710-776, Mario Aguirre, represented by Adrian Perez. State, what is your announcement? Is it going to be a plea, Adrian?
Yes, I'd like to plea him today if possible.
If possible, we'll do it. If possible, it'll be number 2 on the pleas, because number 1 would be Socorro Torres once they get that plea. And then if we're taking pleas today, you would be number 2. Okay, thank you, Adrian.
I watched Big Jet last night too. He's over in the UK.
And then our next one,
He's got some good videos.
Is 719-468 Antonio Perez, represented by Mr. Richard Saldivar. The state has announced ready. Mr. Saldivar?
Your Honor, discussing the plea, we probably don't do that.
I don't think I can
that's
watch this
also a
trial
plea?
if we don't have any audio.
Okay, if the defendant accepts the offer, correct?
Yes.
Okay, and then we skip over to case number 722-383, Katarina Rudd, who has a second case, 722-384, and that's Mr. Joe Stenberg. State, what is your announcement? Okay. Okay, well, he's going to be number 2 on both of those cases. I'm going to assume it's ready to go. So right now we have number 1, Anthony Parrea, and number 2, Ms. Katarina Rudd with 2 cases. That's all we have left, Sybil. Off the record, Olga.
Your Honor, if I may, Katarina Rudd, as of last night, she was still at the hospital, but we haven't heard from Mr. Stenberg.
And you've called him?
Yes, I called his office and just left the phone number advising him he was late, and I also called his cell phone and left a message as well.
I'm going to bet he's sitting over and presiding across the street. So I'm going to bet he's sitting over in civil presiding across the street. It's the only other court that would be up and running this early. But
No one else
that's
wants to be up
just
this early.
A hunch. I don't know. So like, we'll keep it on notation as number 2 till we get an update from Mr. Stenberg right now. We only have one going, and that's Anthony Parreya with Mr. Statesman. Mr. Saldivar, is that going to be an acceptance of? Okay, all right, so that leaves Parreya and Wright, and that's it, Ms. Obledo. Off the record, Olga, the last call will be at 9 o'clock this morning.
Last call? Is that like drinks? I'm confused. What's last? Oh, last court call. I'm hoping they actually turn the mics on once they start business here. Get the EcoFlow. We have 2, a smaller one and a bigger one. Both can run between 60 and 80 hours and can solar charge. For me, solar charge isn't as big a deal because I'm drawing so much power with all my equipment that solar charge barely adds anything to the playtime, the runtime. Read a news article in the Chase. There were apparently Molotov cocktails and firearms in the U-Haul van. Oh, man. They must have known about it beforehand. I think that same Chase, I'll have to find it, but there's a traffic cam video that shows the ending of that chase where you just see the cop car just spinning through the air. Okay, we're not seeing anything productive here right now, so let's see if I can find another feed in the meantime. And yes, now my feed is full of big jet TV and airplane landings, Lufthansa, Boeing 747s. Who's Judge Colin Hunter? What's he doing? Let's go. Let's try this judge and see what he's got going on. Ready?
This is APJ and James and Patricia Anderson. This is file number 19-0796-26-CK. I'm Judge Hunter. I'm sitting here by assignment as the Charlevoix Circuit Court Judge for this case. So, counsel, if you'd like to start with your appearances.
Good morning, Your Honor. My name is Carl Scheer. I'm appearing on behalf of the plaintiff.
Is this North or South Carolina?
Good morning. Matt Lund, appearing on behalf of all defendants, APJ and Mr. and Mrs. Anderson.
I'm here for all the defendants.
Thank you. So, counsel, as you know, we've had several different hearings in this case, but most recently, the hearing at a status conference where the attorneys both told me of their desire to file dispositive motions. Now I've had a chance to review each of those dispositive motions. First was defendant's motion, and I say first only because that's just the first one I reviewed in detail. That was defendant's motion for summary disposition. I've had a chance to review not only the motion itself and the brief in support, but all of the attachments as well. I've also had a chance to review the plaintiff's brief in response to the defendant's motion. And what I would view is the other side of the same coin, which is plaintiff's motion for a default judgment. I say the other side of the same coin. I think the attorneys probably review it the same, but it's an alternative argument. Both parties are asking me for dispositive relief today, one through a motion for summary disposition, the other for a motion for default judgment. But when I look at the motion for default judgment, I have reviewed the entirety of the motion for default judgment, the proposed default judgment, as well as the brief in support and the attachments. But I did not have, Mr. Lund, from you any response to the motion for the default judgment. And I wondered whether that was because it is the same, basically opposite of the argument. But in any event, I just wanted to make sure I'm not missing something. Did you file a response to the plaintiff's motion?
Yes. I can articulate it very when you ask me to. It's short, and we did. I believe we drafted one, and I believe it was filed. Yes.
Well, if it was filed and drafted, I'm sure it was. If you say it was, but I don't have a copy of it. So I don't mind, for purposes of today's hearing, if you want to simply cover your response to the motion for default judgment orally, and then follow up with a written copy of it to my office. Again, this is a little bit more confusing than ordinary confusion in the 46th Circuit, where I have 3 counties, because this is now my 4th county. So even though you file all documents with the Charlevoix County Circuit Court, I need to still get a judge's copy at my office here in Grayling. So that address is 200 West Michigan Avenue here in Grayling. So just make sure and send that copy, either hard copy or to my staff, and I can give you her email address if you don't have it already, Mr. Lund.
I have it. I'll do that, and I apologize that you don't have it in advance. I
That's
will,
all right.
when the time comes, I'll articulate it, and I will send it to you.
Sure, and luckily for the attorneys for today's purposes, I'm not going to rule on the record today. I'm instead going to take it under advisement and issue either a written opinion, most likely, or perhaps come back for my oral findings, but I'm leaning towards a written opinion in this particular case. So in any event, I'm not going to rule today, and so I can certainly look at your written brief in the future. Given the procedural background, Mr. Scheer, do you have an objection to the court doing that, receiving that brief later and then reviewing it?
No, I don't. If that's what the court wants to do, I don't have any objection to that.
And did you receive a copy of the defendant's response to your motion for default judgment?
I did.
All right, then given that fact, again, even if you announced prejudice, I would tend to indicate that I won't have the benefit of all of the briefing because I'm going to take this matter under advisement. It won't hurt me either. So what I would intend to do then is I want to hear from the attorneys, but I want to ask you how you want to be heard. Probably the simplest for me is to have one attorney argue, then the other attorney argue both what you're advancing and then any defense to what the other side is advancing.
Judge, let's do both at the same time
It's
this
easier for
time.
the attorneys to break it up into first the motion for summary disposition and second the motion for default judgment. I don't have a problem with that. Mr. Scheer, do you think it makes sense to argue them separately or all together at the same time?
I think all together at the same time. I prepared my argument in that fashion.
Mr. Lund, any problem with that?
I am fine with that.
Then from a mechanistic standpoint, Mr. Scheer, did you want to argue first or last?
Last.
Did you have any objection to that, Mr. Lund?
No, I'm happy to go first, Judge.
Okay, then your oral argument, please, Mr. Lund.
Thanks. So I am sure that you've read, as you said, everything, and I don't wish to belabor all of the facts or all of the arguments that we've submitted in writing. But I do, unless you tell me not to, think that a little bit of the evidence and the context is relevant for the arguments that I really want to highlight. And I won't hit on all of them because there are several.
No, I think it's absolutely going to be helpful to me. Again, I've read everything, but oral argument can help crystallize those things. There's times where I don't allow and don't benefit from oral argument, but here today, again,
Okay, this guy's not
different requests.
It's not gripping me. This is just, I'm not sure. I apologize, guys. It's just not doing it. So we're going to jump down to Florida. Look at, I think we've got some arraignments going on here.
Disease or sickness in order to get in that would contaminate someone else, is what I'm told.
I've never heard of that in 25 years.
Never.
Mr. Gibson, you've dealt with nursing home before. You ever had that? What facility? What facilities have you?
I've checked the assisted living facility in Blountstown. I have checked the nursing home in Mariana, the VA nursing home in Panama City. They all require a medical examination in order to get in with the paperwork.
Okay, and you don't feel that he could safely, I'm trying to get him out of jail.
Yes, I understand that.
And I hope you are too. So my question is, you don't feel like he could safely reside with you until you can get him in somewhere?
The issue with my dad residing with me personally in my home is my children, because my father did physically attack me back in May, and he was arrested for domestic violence. And they told me that if he ever returned to my home, that they would physically remove my minor child.
Who told you that?
The DHS department that came into my house that interviewed me in front of my children. And she said that directly to myself in front of my children.
You don't know who that was?
I do not recall her name, but I'm sure I've got it on my paperwork at home.
Your concern is if he comes into your home, then they'll use that as justification for removing your children.
Exactly. And the other concern is the physical, because he is a physical threat. He definitely physically assaulted me. He hurt my older son, and he did the same thing at Terry's house. He tried to physically assault Terry.
So tell me, what is your plan? I know you're trying to get a guardianship. We recommended it. You started the process. It's been delayed, and it's not your fault.
Correct.
But I know that you started the process. So what is your plan to get him out and get him placed somewhere?
My only other plan that I have is Terry Strout is presently in the process of moving from the house that he lived in, that where my dad stayed. The only other option that might be available is when he is out of the house, March 1st, that my dad would be able to go there. But my only concern is this. Even if I have guardianship, what makes him have to stay in that premises where he doesn't go out and walk into the neighbor's house and trespass again, which he's done, or anything? What guarantees that?
If you're appointed guardian, then you have the right to decide if it's a full guardianship, what's called a plenary guardianship. You have the right to decide where he lives.
Okay.
And if you choose to let him live somewhere like that, then you're taking the risk that he's not going to do exactly what you're concerned about.
Okay.
So if you have guardianship, the more appropriate decision may be to place him somewhere. If you're concerned about that, the more appropriate decision may be to place him somewhere. But there's a lot quicker options and a lot more options than just the VA. There are multiple. They don't even call them nursing homes anymore. They call them
assisted living facilities.
They call them. All of them have rehab in their name, something to do with federal funding. So every one of them changed their name and they have rehab in their name. Mariana Rehab, Courtyard at the Mill Pond Rehab. They all have rehab in their name, but they're essentially the same thing that we used to call nursing homes. But you can get in one of those today if you had the guardianship.
Correct.
Now the guardianship is the holdup, at least that's my understanding, because you have no authority to put him there, and he would have to go willingly, and then he could leave willingly. He could sign himself out the next day if you don't have the guardianship. But you've given us some more information, and my judicial assistant got a call from the clerk's office this morning, Ms. Bremer and Mr. McDaniel, saying the exact same thing Mr. McDaniel just said, that one of the physicians didn't want to do the evaluation because they didn't want to go to jail to do it. So they were going to a backup physician to try to get the evaluation done. The other two people have already done their evaluation. And I don't know what their recommendations are. Do you know what their reports say?
I only know of one that stated that he really needs to be in a locked facility, secured locked facility.
Okay.
I don't know of the other one.
Okay. Mr. McDaniel, any questions for this? And I didn't get your name for the record.
My name is Amy Bailey.
Any questions for Ms. Bailey?
No, Your Honor, I don't have any questions for Ms. Bailey.
Ms. Bremer, any questions for Ms. Bailey?
No, Your Honor.
Ms. Bailey, thank you for coming and giving us that update. Appreciate
You're welcome.
That. Thank you. I see your brother, Mr. Baxter, in the courtroom. He's been to the court several times on your case. Mr. Baxter, any additional update or information you have or suggestions about placement?
Yeah, in my own home. There's plenty of room.
I was talking to your brother. I wasn't clear. Your brother's in the courtroom. The other Mr. Baxter. Mr. Baxter, I want to get him out of jail, but I got to have somewhere for him to go. Do you have any ideas?
I don't know where he should go. I can tell you that once before, he had been, I think it was Bexar acted. Anyway, they said that he was sane. He was at the hospital here in Mariana for about a week. And they had a place for him to go, but it was not mandatory. And he refused to go. So they released him. And that's whenever he got put back in jail again.
Okay. All right. Thank you, Mr. Baxter.
Thank you.
All right. So, Mr. McDaniel, what's your preference? What do you want to do with the case?
Your Honor, I was going to put it on the next, hearing date, March 13th, and hopefully, we'll hear something back by then. If the March 1st, if it works out that, Terry wants to let him go live in that house, and, if Miss Bailey contacts me, I might get him out and get him over there to that house March 1st. I think someone needs to be able to keep an eye on him, though, because I'm afraid he's just going to walk off. That's Miss Bailey.
The only way I would consider that is if, number one, y'all wanted to do that. Number two, the state had a chance to have input. And number three, he assured me he was going to stay there. So that's a lot of ifs. But so the March 1st thing may happen. What I want to ask you to do is proceed with the guardianship, do what you can, which I know is limited. Hopefully they're going to get, I was told that I believe Dr. Akerson may be willing to do the evaluation this morning is what I was told by the clerk, told my judicial assistant. So hopefully Dr. Akerson is able to do the evaluation, and you may have the evaluation back. So once you get that evaluation back, then Ms. Simpson can proceed with the guardianship. Is that correct?
Yes, that's what I believe. So.
Okay. All right. So Mr. Baxter, we're doing everything we can to get you some options. You've heard the reasons why what was your home that your daughter now owns may not be a placement option at this time, but we've got to have somewhere for you to go. And if I do have some assurances that you have somewhere to go and you're going to be safe and the community is going to be safe, I have no problem considering that. But right now I have 0 options. I'm going to schedule you for that March date that Mr. McDaniel said, with the hope that I'll see you before then, and we'll have some other type of placement option before then. Mr. Baxter, do you have any questions?
It doesn't make any difference what I have. It's all the same crowd. Nobody cares.
All right, sir. Sorry you feel that way. We'll see you at next court date.
Well,
thank y'all for coming. I appreciate you coming. It's important that you come so that, you know, we can hear the current status. So his next court date will be that March date. Mr. McDaniel, that's March the 13th, unless you get a guardianship before then or the other place becomes an option, in which case we'll see you before then. Okay. And if that place becomes an option, we may, if he says he's going to stay there, we may put forth some kind of framework on a conditional release, let him go. And if he violates those rules, you can put him back in jail. But I can only do that if I feel like he's not a danger to the community or himself. That's the key. Okay. Thank y'all for coming. Thank you, Mr. Baxter. Thank you, gentlemen.
We'll see you soon, sir.
That brings us to Cody Clemens. Mr. Clemens, good morning. Mr. Clemens, you're here in case 23-754MM, charged with violation of injunction. I think Mr. Gill is in charge of your case, Mr. Clemens. So, Mr. Clemens, listen to Mr. McDaniel, and we'll see where we stand in your case.
Your Honor, right now we're going to tentatively put it on the February 26th trial docket. I think there's a good chance we may end up working something else, you know, before that trial. But I think we're ready to go and go to trial, though, if we can't work it out.
Okay, Mr. Gill.
The state's fine with that trial date in February. It's a week and a half, I guess, but we're ready to go forward on it.
What about, is the felony case still pending?
No, what happened, Judge, was the felony case was tracking. He picked up this new law misdemeanor that pushed a plea. And then he, of course, has a violation on a positive UA. That was resolved. So it's just the misdemeanor right now. That's pending.
So the VOP was resolved. Y'all didn't resolve this?
That's correct.
How was the VOP resolved? What was
it was a low-risk technical violation, Judge. So the maximum was 90 days. The state offered inpatient drug treatment. He declined that, but it was a low-risk technical. So he pled to the low-risk technical.
So this happened before he was on probation?
Correct, Your Honor. Yes.
So this couldn't be used as a basis for violation?
Correct.
I follow you. Okay. Thank you, Mr. Gill. Mr. Clemens, February 26th trial date, jury selection date. Any questions?
No, sir.
All right. Have a good day. We'll see you then.
Thank you, Judge.
Thank you, Mr. Gill, for coming over. The next one I've got on the docket is...
go ahead and do Charles Smith.
Mary Catherine. Well, wait, hang on. Mary Catherine Simmons. We resolved that earlier by a plea a few days ago. Is that right?
Correct.
And then on my paper docket, I've got Charles Smith after that. And I believe we've got his counsel here. Ms. Kelly's here. Mr. Smith, good morning. Ms. Kelly's here on your behalf in case 23-787 CT. Mr. Smith, please listen to Ms. Kelly. I think the parties have a tentative plea agreement in your case.
Hey, Mr. Smith, can you hear me?
Yes.
Okay. So the state just contacted me yesterday about lunchtime when I was in Panama City, and I haven't had a chance to get to the jail to see you. They have agreed to amend the charge from DUI to reckless driving with alcohol, and the sentence would be the 60 days that you've already served. You've served about 75, so it would essentially be a time served plea. Now, the problem with that is that could still affect your commercial driver's license. So I don't know that it would automatically disqualify you from getting one. I don't normally handle those types of cases, and I spoke with a friend of mine who handles them in Panama City, and he indicated that that was one of those that could go either way. It isn't necessarily 100% that it's going to permanently bar you, but it could have some serious impact depending on your other driving history. And also it'll go on your insurance, so that could keep employers from hiring you because of insurance rates. Now, we had discussed before, I'm not sure that vehicle was operable since it had to be towed out. It had been parked there for a while, and you indicated that you were denied both a breath and blood test when you requested them. So this is definitely a triable case. It's just, we had filed a motion for conditional release because you had indicated you couldn't post the bond. And so that's where we're at. I think you have defenses, but, the state has made this offer.
Well, have you all contacted Alabama about the community hours? If did interstate combat that, or?
I haven't heard back from them.
Well, I'd like to wait to hear back from that and to know more about the consequences of the reckless driving with alcohol before I plead anything.
Okay. And that would be my recommendation, but I also understand that I'm not the one that's been sitting there for 75 days. So
77 actually.
Yes,
a couple of days.
77. He's
Ms. Kelly, where does that leave us, ma'am?
So we would request that he be placed on a trial docket, and then I don't know if you want to have a hearing on another date on that motion that we had filed, or if you want to rule on it today, or.
Okay, so let's deal with the motion first then, because I can't give him a conditional release when he's got to go somewhere else to jail. He can't comply with it. So a regular conditional release, that is. The only option I could even think about would be some other type of non-reporting release, because Corporal, he has a hold somewhere, correct?
Yes, sir.
Where's that? Where's the hold from?
Houston County.
Alabama. And
yes.
Corporal, do we know what that's for?
The only thing I owe them, the only thing I owe them up there is 50 community hours. I don't owe them no money.
What's the warrant for? I don't even know what the warrant is for.
It's for a pretrial from back in 2018.
So it's not a violation of probation warrant?
No, sir.
Okay. And is it a misdemeanor or a felony?
It's a possession charge.
Okay, that doesn't tell me. Is it a misdemeanor or a felony?
It's possession of controlled substance.
Okay, that's probably going to be a felony. Corporal, do you have any additional information?
They don't list whether they don't list a lot of information on why. They do want him and ask for a waiver to be signed. That's it. They don't give any information on case or charges.
Okay, so let's assume he's got a felony, but it's not a violation of probation. So this hasn't violated his probation as far as I know. He's got a new charge down here, and this was a DUI without a breathalyzer?
I wasn't on probation up there.
Okay, all right. I'm assuming you weren't on probation.
There was no blood drawn, and I believe the probable cause affidavit read that he was in the cab of a truck that was stuck in some sand on the side of the road. They were waiting on a tow truck, and I think one of the residents who lived nearby called the police because he had been there for a while and couldn't get the truck out. And then when they showed up, Mr. Smith, don't say anything because you have a right to remain silent. I don't know what you're about to say, so don't say anything that's gonna hurt you. But he had been there for some time, and then the officer showed up and stated that he observed signs of impairment, but Mr. Smith has indicated to me that he requested both a breath and a blood or urine test, and the officer took him straight to the jail and denied him both. So.
Okay.
Ooh, he'll probably get
I'm
out
looking
now.
over the complaint now. The officer says, en route to Marion Police Department to give him a breath sample due to his increasingly belligerent, aggressive, and initially refused to enter my patrol vehicle. I transported him to Jackson County Correctional Facility for the concern and safety of all officers and Smith.
I only started cussing him when he told me he wouldn't want to take me to the police department.
Your attorney told you not to say anything, and now I'm telling you not to say anything. You're gonna hurt yourself. I think he set a reasonable bond. I'm not going to give a conditional release to someone that's wanted from another state. So appreciate you representing your client, Ms. Kelly, to the extent you have, but I'm going to deny the request for a conditional release. He's got a reasonable bond. He posted he'll be released. Otherwise, he's not. So we have a February trial docket. We have a March trial docket. Ms. Bremer, what's the state's preference?
I know we have several set for the March trial date, Your Honor. At this point, I don't know if we have.
I'll make this easy. I'm supposed to chaperone my child's field trip to St. Augustine the February trial week, and I've still got someone set with Judge Garcia right now, so I would be unavailable for February.
March? March, and he'd probably be top of the docket because it's in custody. So I know you have others set, but we're typically going to try our in custody cases first. So we're going to schedule them for the March trial docket. You want them set on the March pretrial also?
Yes, sir.
We'll schedule them for the March trial docket and the March jail pretrial docket. Madam Clerk, give me those dates when you get them, please. March 13th for the pretrial, March 25th for the trial. Mr. Smith, if Ms. Kelly gets the answers to your questions that you want about the Alabama and the more information you said you wanted on the reckless driving, and if Ms. Kelly, if you decide that you want to take the time served offer and be done with this and then go deal with the Alabama, then Ms. Kelly can add you on the first appearance docket. So I may see you before then. I may see you in the next few days. Ms. Kelly, as you know, I can do it at first appearance almost any day.
Yes,
I do
sir.
first appearance 90% of the time. So if you do have an agreement that you want me to consider, and I have no problem with the plea agreement, I just don't know that I can give him a conditional release when he can't comply with it. That's the only concern I have. In the meantime, you've got the bond that was set. Do you know your bond, or do you want me to look it up for you, Mr. Smith?
I believe it was a $250 cash bond.
Okay. Mr. Smith, any questions, sir?
I have the money, but it's in a check form, and I had my brother call my employer, but they said I got to come pick it up myself. Would there be any way I could get, if she can get Alabama to drop the hold for the interstate compact? Is there any way I could get like a 48-hour conditional release so I can?
If Alabama were to drop the hold for the compact, I would consider a conditional release, but that is going to be very difficult to do. You've also got to realize Ms. Kelly's not representing you in Alabama. Ms. Kelly's appointed to represent you in Florida, so she's going above and beyond her normal job duties already, but she can do a little bit, but she can't represent you. I don't even know that she's licensed to practice in Alabama, Ms. Kelly.
Well,
At Georgia, I'm okay, but not Alabama. So
if it gets dropped, I certainly will consider you for a conditional release.
Otherwise,
I'll see you the next time you're in court. Okay, sir. And Ms. Kelly, if he decides he wants to do something, we'll be at first appearance. Okay? Yes, sir. Thank you.
And Mr. Smith, I'm going to keep talking to Ms. Bremer, and I'm going to keep trying your attorney up there. Okay, he's probably just busy, and I, we've just been playing phone tag.
All right, thank you.
You're welcome.
Thank you, Ms. Kelly, for coming. That brings us to Anthony Evans. Mr. Evans, good morning. Mr. Evans, you're here in case 23-453 MM. You're charged with one count of, I'm trying to find the charge. There's no charge.
Violation county probation.
Oh, it's a violation of county probation charge. Is there a new charge too? Or it's just the misuse of 911 was what he's on probation for? Mr. Evans, you're accused of violating the terms of your county probation. Mr. Evans, I've already appointed the public defender's officer to represent you. Please listen to Mr. McDaniel, your attorney.
Your Honor, Mr. Evans, is asked to represent himself, and I'm going to be here to assist him in any way I can to help him along the journey.
Pro se.
But he is asking to go pro se. I think, he filed some motions I saw, but I'll let him, and I'll try to assist him in any way I can.
Tell me where we're at in that process. If I made the inquiry I have to make before I can let him represent himself, I don't remember that.
I don't think you did at first appearance.
Okay. All right. So, Mr. Evans, let me ask you a couple of questions. How old are you, sir?
44, sir.
Mr. Evans, what is the extent of your education? Do you have a complete high school education or any college?
Associates in psychology and social work.
Oh. So you have an AA degree, a 2-year degree, is that right?
Yes.
Okay. Do you have any education or training or in legal courses or the law?
No.
And have you ever represented yourself before in a criminal charge?
Yes, I have.
Where was that at?
It was in North Carolina.
Okay. Did you go to trial?
No, it got dismissed.
Ooh,
okay, so there was never a trial, correct?
True.
Okay. And
he's got a good
Mr.
record.
Evans, here's what I'm required to tell you. This is the way I had the judge explain it this way one time, and this is the way I explain it also. I think it's a good explanation. What is your trade? What do you do for a living when you work?
Right now, I was working 2 jobs before this incident, which was at the distribution center, and I picked up a second job, which was at Zaxby's.
Okay. If I showed up at the distribution center tomorrow morning and I clocked in, I would have no idea what to do. I have not been trained for that job. I don't have the skill set for that job. I don't know nothing about it. I'll do a horrible job. That's common sense. What you're saying is, even though you don't have any experience, you have no training, you haven't been to law school, you haven't taken or passed the Florida bar, and you have no experience in criminal law in Florida, that you think you're capable and competent of representing yourself. Now, what I've got to tell you is that's a bad idea. Here's the analogy that I heard. The analogy is you're about to have surgery. And what you're saying is that you want to perform surgery on yourself. Even though you don't have the training, the experience, the expertise, you think that you're capable of performing surgery on yourself. And what I've got to tell you is if you do that, you have the right to do it, first of all. You've got the right to represent yourself, but it's almost always a bad idea. If you perform surgery on yourself and we get involved in this case and you nick an artery and you're bleeding out, literally, I can do nothing to help you. I can't help someone who's representing himself. I can't represent you. I can't give you advice. You're just like an attorney in the case. You've got to take the ball and run with it. It is a bad idea. I would strongly encourage you to take the services and representation that's being offered to you of an attorney that's been a member of the Florida Bar for many years and represented not dozens, but hundreds of criminal cases. Mr. McDaniel has represented hundreds of criminal cases. Mr. McDaniel had a trial last week, Mr. McDaniel?
Yes, Your Honor.
Week before last, when the jury found the individual not guilty after a trial. He's a very good attorney.
Past
he knows what he's
performance
doing. And I would encourage you to accept that representation way before I even thought about suggesting you representing yourself. Having said that, you have to make the final decision on whether you want to represent yourself or not. Do you want to follow my advice and be represented by an attorney that's qualified, or do you want to represent yourself, Mr. Evans?
He wants to represent himself with standby counsel. I think that's what he wants. I don't think it's fair that the judge said, this attorney right here, he was just in a case and then got the guy off, not guilty. You don't know, apples to apples, that case might have been completely different than yours. So hanging that out there as hope is like, hey, this guy can help me. I would have left that part out if I was the judge. He represents everybody. He represents all defendants. They have like an exclusive contract with his public defender. He's making bank. Just lives at the jail. Yeah, maybe.
Your Honor, I'm going to continue to represent myself.
Okay. In that case, Ms. Bremer, are you ready to set this matter for a violation of probation hearing?
Yes, Your Honor.
All right. And when do you want to schedule it for? Looks like, based on the allegations, it's like the only witness is the probation officer, Mr. Ham. We should be able to do this next week, shouldn't we?
Yes, Your Honor.
All right. So let's look at next week's calendar.
Your Honor, is it possible that you could do this hearing right now if the probation officer is present? Because the last time we spoke,
the probation officer is not present.
Okay. One more
is
thing.
Is he here today? He is here today. He's downstairs.
Let's get him.
Ms. Bremer?
Drag him up. As my first move as a pro se, I'm going to move my court date till today.
Is there a time this afternoon that we'd be able to, or does it need to be this morning?
I have civil stuff this afternoon.
It's pretty simple.
The allegations are he quit reporting, and there was some financial allegations.
Yes, Your Honor.
Your Honor.
Just a second. Seeing if the state is in a position. She may have something right after first appearance. I have no idea.
Okay.
Ms. Bremer?
I should be able to do it this morning, Your Honor.
I'm looking at my calendar too. I don't think I have anything until I've got some civil hearings at 1:30. Okay. So Ms. Bremer, you want to go ahead and get Mr. Ham up here and try to get it done?
Yes, Your Honor.
That's great.
Mr. Evans, before we do that, you need to make sure you understand that if we go forward with your request and have Mr. McDaniel.
Judge, can I make, I think after speaking with him just right now, I think he's wanting to go ahead and admit and then offer mitigating circumstances to the court on the sentence and let the court sentencing. Is that correct?
I'm not sure why the attorney is still in the mix here after the judge just granted that he can go pro se and then just bent over backwards to schedule him for the same day trial. Judge is not happy with this. The courtroom has a procedure. They have like an order they follow. They love it when the docket, they can just work through the docket and work things out. And when we have these things, interruptions, it's...
I can speak now?
Yeah.
I started doing now? Yeah. Hey, Your Honor, okay.
First, you got to admit that you violated the probation.
Okay, I will.
Yeah, Mr. Evans, let me explain. Since you're representing yourself, let me explain to you your options. Option number one is to say, I want to have a hearing. I want to dispute that I violated the conditions of my probation. I want to have a hearing. If you want to do that, we're going to schedule the hearing. We may do it this morning. Mr. Ham's just coming in the courtroom because he's obviously been watching downstairs. Your second option that Mr. McDaniel is referring to now is to say, I don't want to have a hearing. I basically want to throw myself on the mercy of the court. If you do that, you admit that you violated the terms of your probation, but then you're entitled to tell me anything you want. There may be some specific reason why you may have violated the terms of your probation. You have the right to explain it and give your side of it. If you take that option, you take option two, admitting to the violation of probation without a specific plea agreement. You also have the right to say, I admit to certain conditions and not others. You may feel like, hey, they've accused me of three specific violations, and I admit to one of them, or I admit to two of them. Okay, so that's option two. Option three is to say, I want to accept the state's offer. So let's talk about what the state's offer was in this case, and then we can see if you have any questions. What was the offer in this case, or what was the court's offer? I don't know.
60 days in jail with public works.
With court costs and fines.
Okay, and he's been there how long, Mr. McDaniel?
34 days.
Okay. So those are the options you have. Do you understand those choices, Mr. Evans?
So,
mute.
Okay, Your Honor. Your Honor, I have one concern. My concern is if I choose the option as far as having a hearing, is it possible? Now, this is what I want to do. Is it possible that I can get maybe a 48-hour furlough so I can get my funds together so I can actually pay this stuff off? Because everything that I'm violated for, I can rectify.
No, no, it's not. And let me tell you why. You're not here on a financial obligation only. You're accused of quitting reporting to probation. So if it's finances only, a lot of times we will let people just pay it late and be done with it. But you're accused of just disappearing on the probation office, not reporting in. If that violation is proven, then the chances of me putting you back on probation is not real high. The chance of me letting you pay it off is not real high. I don't know if the state can prove that violation or not, but that's what you're accused of. So you've got to decide. You're representing yourself now at your request against my advice. So you've got to decide if you want to go to a hearing, or if you want to admit the violation and give me an explanation and tell me your side of it, or if you want to take the state's offer. That's your choice.
So listen.
Mr. McDaniel, I'm not comfortable with him continuing to get advice from you after he seeks to represent himself. He can't have it both ways. So I'm going to ask you not to talk to Mr. McDaniel anymore. You've got to decide. You want to represent yourself. I've told you you need to talk to an attorney. You can't keep talking to him and represent yourself at the same time. Now, if you want to represent him represent you, I'm fine with that. I think that's the wise thing to do. But you can't have it both ways. If you don't want an attorney, you don't. If you do, then that's great. Mr. McDaniel's an excellent attorney. I've already told you that. Do you want him to represent you, or do you want to represent yourself?
Well, won't be represent you? Yeah. So.
The judge is frustrated. Look at this. The judge is like, why? This is a decision between you and me.
Your Honor, I spoke to Mr. Evans, and he's going to accept my representation. We're going to go ahead and admit that we violated our probation, Your Honor, and we'd ask the court to listen to mitigating circumstances from my client, Mr. Evans, on the sentence. He's been in jail for 34 days, and we just asked to go forward on that, Your Honor. Mr. Evans, I guess I'm going to go ahead and
Yeah, Mr. Evans, okay, there are two things I got to make sure. I got to make sure, number one, that you've changed your mind and you want to accept Mr. McDaniel's representation. Is that accurate?
Yes.
The second thing I've got to make sure is that you want to admit that you violated the terms of your probation with the understanding that you're not going to have a hearing. You're waiving your right to a hearing. There will not be a hearing. I'm going to listen to you. I'm going to listen to the state, and I'm going to impose what sentence I think is appropriate only after listening to both sides. Do you understand all of that?
Yes, sir.
And knowing that, that's what you want to do, correct?
Yes, sir.
Okay, Mr. Evans, I know you're accused of two financial issues, which are not that, they're not the end of the world to me. They're financial. But then you're also accused of not checking in for November and December after having been put on supervision in July, the end of July. So what that typically would mean to me is, and Mr. Ham's here, he can confirm this, Mr. Ham, he's accused of reporting in August and September and October and then disappearing. Is that what he's accused of? Okay. So that's what you're accused of. So I'm glad to listen to anything you want to tell me, Mr. Evans.
Your Honor, it's not that I intended to like violate probation. I picked up a second job and I started doing double shifts. I would call in when I could call in, and I was always told, okay, come in when you could come in. My intentions was to like get everything together, get all my money and everything together, and just go in, because he told me if I go ahead and pay everything off within that 6 months period, my probation would be terminated. So it's like right now I'm to the point where I could pay the majority of the fines. I want to continue doing my job. I want to continue my work, and plus I have a child on the way. So I'm not trying to cause anybody any problems or anything like that. It was just the mishaps, and I want to keep my job. I want to keep being employed, and I want to like catch up the payments that I can catch up. And the reason why I couldn't pay when I could pay was because of possible eviction. So I had to get that situated, and then the mother of my child, I had to make sure that she was situated. So it's not like I was neglecting my responsibilities. It's more like I was put in a situation where my time had to be split up between prioritizing with family and prioritizing and trying to. I was just under a little. I was up under a little too much pressure at the time when things just conspired and things just happened. I was trying to manage the best that I could. My intentions wasn't to like not intentional, just not stop showing up, just stop showing up. I showed all the way up until I picked up the other jobs. The other jobs was I picked up so that I can actually maintain and manage things a little bit better so that I could actually take care of this situation. It's like I'm not trying to neglect the situation at all, Your Honor. And I'm still
let me do this. I want to find out some more specifics on when you reported. So, Mr. Ham, can you tell me he was put on supervision July the 31st? His first report date would have been August the what?
15th.
Did he show up?
August 16th.
So in August, he was there a day late, but he showed up.
Yes, sir.
Okay. And then his next report date would have been September?
September 15th. He called and said he would check in on Wednesday. He had to work and is off next week on that day. He checked in 13 days later on September 28th and reported a new job at Zaxby's.
Okay. So his next one would have been October?
It would have been October 15th. He checked in October 27th. And then no November, no December. He did call one time and say that he was working and he wanted to check in. I told him, you can't check in over the phone. You have to do it in person. But if you can't come today, come the next day or the day after, but you have to come check in person.
So he never reported on time?
No, sir.
The first time he was 1 day late. Second time he was 13 days late. Next time he was about 12 days late. And then he just quit reporting totally.
Yes, sir.
Okay. And so the warrant was done in December, the end of December, December 27th.
Yes, sir.
That's when the affidavit was filed.
Yes, sir.
Let's see when the warrant itself was done. Same day. Warrant was done December 27th. So from December 27th, when did we hear from him again? When did he get in custody? Do you know that?
That I don't know, Your Honor.
I can tell that in the file here. The first appearance would have been
mid-January, January 7th, mid-January, sometime in January.
17th. I guess my question is, did he miss January also after the warrant was done?
Yes, sir.
Yeah, because he was first appeared. He should have reported in on the 15th of January, and he got arrested. And it looks like he was first appeared on the 17th, so he got arrested on the 16th.
Yes, sir.
Okay, so Mr. Evans, that gives me some. Thank you, Mr. Ham. That gives me a better understanding of the timeline here. So we're talking that's what the probation officer's position is. So if you want to fill in any of those gaps, I listened to what you've said so far. But if there's something else you want to say now that we know those specifics, I'm glad to listen. Anything else, Mr. Evans?
I was arrested on January the 15th. The 15th, I got paid a couple of days. No, I got paid after the 15th. My intentions was to go ahead and settle everything that I could settle because I really wanted to go ahead and pay as much as I could to go ahead and get off probation within that 6-month period, like he had instructed me to.
The attorney
Were
wants
you
to mute the
arrested
mic.
at the courthouse did you come report in January, or did you get arrested somewhere else?
I got arrested at the hospital.
So you weren't coming in on the 15th because that was your report date. You weren't coming in to report, having missed a couple of months trying to get back on track. You got arrested at the hospital, totally unrelated to the probation office, correct?
Yes.
Okay. Anything else you want to tell me? Well, look, I do have one question. You seem to think you still may have the job. If you've been in jail if you've been in jail, how long, Mr. McDaniel?
34 days.
I do.
What makes you think you've still got a job if you've been gone that long?
Because I keep in contact with Pam. Every day she tells me, make sure you let me know what's going on. And as soon as you get out, just come up here and talk to me. I know I have the job.
Where's this at now?
This right here is at Zaxby. She said, you can call, you can verify.
Okay. What about the second job? The other job, you said that the full-time job.
The second job, I don't even have it anymore because my injury to my hand, I'm supposed to have surgery. And I never went to have surgery because I can't even move my pinky finger anymore. So
when did you lose the second job? When did you lose the other job?
I lost the second job in the end of August.
Okay.
No,
and I'm totally confused because you said the reason that you were not able to comply with probation is because you were working 2 jobs. You didn't comply with probation October, November, and December, but let me finish. You lost one of the jobs in August. So what's the second job you had that kept you from reporting to probation that you said you in October, November, December?
The second job was I started picking up double shifts. I started working instead of 8-hour shifts. I started doing 16 hours if possible. So I was carrying on that right there.
At Zaxby's.
Yes,
at
sir.
Zaxby's. So you're saying that you were working full time plus some at Zaxby's?
Yes, sir.
Wow.
Okay, so listen to my question now, because normally fast food places don't let you work more than 32 hours a week because if they do that, that involves certain insurance requirements under the Obamacare Act. If we get your work records from Zaxby's for October, November, December, it's going to show you working more than 40 hours a week. Is that what you're saying?
Yes, sir.
Okay. Easy enough. All right.
The most hours that I was working at Zaxby's, Your Honor, was it was above 60 hours
a week.
Yes, and the least, Your Honor, was probably like maybe 44, 45, and that was to the minimum.
Oh, I'm not talking about a 2-week period. You're talking about in 1 week, 60 hours.
And in 1 week, I would probably end up with over maybe 45, 48 hours. In 2 weeks, I would probably have like 80, maybe close to 90 hours sometimes.
Okay.
So that's like, and that was me trying to rush and trying to get everything situated with my living situation and my probation situation. And I still have my employment.
Mr. McDaniel, Ms. Bremer, what I'm inclined to do is give the state and defense a chance to verify that with the employer and see him tomorrow at first appearance. Actually, I won't be here tomorrow. See him Friday at first appearance. Actually, I will be here tomorrow. I'll be here for first appearance. I want the afternoon docket is the one Judge Garcia is covering. See him tomorrow at first appearance and let y'all talk to the employer. And if he really was working more than 40 hours a week at Zaxby's, that'd be unusual, number one. Number two, then that means he's being truthful. And I'll consider something along the lines of time served. If he's lying to me, then I'm gonna consider something a lot different than time served. Who can verify this at Zaxby's, sir?
My manager, Pam. Actually,
Pam?
Any manager.
And Pam still works there, right?
Yes, she's the GM.
Okay. I'm going to defer your sentencing until tomorrow morning at first appearance, and we're going to ask Ms. Bremer and or Mr. McDaniel, one or both of them. They want to get together, make the call. That's up to them to see if they can verify this. And then we're going to send it. I'm going to send it to you tomorrow once I get the answer to that question. How many hours are you working? And the time period in question is the months he did not report allegedly. Ms. Bremer and Mr. McDaniel, those are the months which would be November, December. November and December around the 15th of each month is the time period I'm concerned about.
Thank you.
Yeah. Thank
Zaxby's
you.
sells
Any
chicken.
questions about any of that,
Fast food
Mr. Evans?
restaurant.
No, sir.
Ms. Bremer?
No, Your Honor.
Mr. McDaniel?
No, Your Honor.
We'll see you tomorrow, Mr. Evans. Thank you, Mr. Ham.
Yes, sir.
You have to go now. You have to go now.
I'll see you in the morning.
Mr. McDaniel, that's everything I had on my docket for today. Anything else from the state of from the public defender's office? Excuse me.
No, Your Honor.
All right, thank you. So I will be here tomorrow morning.
We'll take up the Zaxby's issue first.
My son's wrestling in the district in the afternoon. So Ms. Bremer, Judge Garcia is going to cover that afternoon docket. I'm going to give her my docket with your notes, your plea offers on it, and then there's only like maybe half a dozen cases on that docket. Anything else from the state this morning, Ms. Bremer?
No, Your Honor.
And Corporal, anything else from the jail?
No, sir, that's it.
Thank you all. It's 9:41. We're through with first appearances, and first appearance court is adjourned.
There we go. Let's jump down here to
And it was like sitting next to
Judge Kenneth King.
And when he was in the process of doing that, he
By he, who do you mean?
I mean the defendant that's here, like present here. Yeah.
He took the phone out of your hands?
No, it was on the couch.
So you put the phone down on the couch?
Yeah, it was in my hand at one point in time. Before that, but I set it down on the couch.
Was this the same couch that the individual was sleeping on?
No. It was two different couches.
Okay, this one, the audio's bad. We're going to jump to Judge Babcock.
Your firm recently took over representing them, but I have seen cases that have stretched back 18 months of non-payment, again, under prior counsel, to be sure. I think I'm going to set it for a new date, which is 10 a.m., March 13, because I do see a real good faith effort, and Ms. Clark has committed to paying the rent. Now, on the 13th, you'll also have owed and paid the March rent. That will also be the last chance in court. And I see Ms. Clark nodding in the affirmative, so she understands. But I just think that with the relatively small amount at stake, and with the good faith effort, it just warrants a third hearing. So anything further for this record, Attorney Amato?
Yes, Your Honor, just so Ms. Clark is aware, if we don't have the matter resolved and we have to appear for court, that will be an additional attorney fee assessed. So
it'll be paid. It'll be paid.
Okay. And just for the record, how much is the additional attorney fee?
That would be $150 for a contested hearing.
That's cheap.
Okay. Anything further for this record? Attorney Amato?
No, thank you, Your Honor.
Okay. Ms. Clark?
No, not at this time. Thank you.
Okay. All right. Well, and if it's paid up and resolved, if it's paid up by March 13th, the hearing, Attorney Amato can dismiss the case. Now, Ms. Clark, just a public service announcement, anytime that you've been summoned to a court hearing, unless you receive notice from the court saying not to appear, always appear. Okay. All right. Well, I believe that is all for this
good advice. Oh, that's all we got there. That's all we got. All right. Not a lot happening this morning in the world of court. We have some more arguments in North Carolina. The Supreme Court is hearing something. Actually, they just started hearing this one here.
Dissent catalogs, as does the record, numerous material factual disputes, the type of factual disputes that would normally entitle plaintiff to survive a summary judgment motion. SS&C, the defendant.
Yeah, I'm not up for that anymore. I'm not up for that. Yay, oral arguments, Mathis. I realize this is your ball of wax. We're going for something a little bit lighter today, so let me just see if we've got some other options. I'm not sure. I might get a strike for doing this, but if my son plays a song on the piano that is copyright, do I get a strike for that? Do you know? Asking for a friend. I was going to show you. I've been editing. Here, let's see. Let's go here. I'll turn this one off. I've been editing his video together to put a little piece together, and it sounds like this. So it sounds like that. But I guess I could play it with the music off. This is all my artistic camera work here. Let's go full screen. Boom. Is that just too weird? I don't know. I've got to make it look fancy. So anyway, we're gonna play that one. He'll post it on YouTube on another channel in case it gets a copyright strike. How about Judge Middleton 3B? Here's the problem. Judge Middleton does not like us to use her stuff. I really like Judge Middleton's stuff. Who's this? Don't see anybody there. Oh, that's not it. Judge Mercer? Nothing from Judge Mercer. Let's see what if Judge Middleton has updated her feed yet. His feed, sorry. I think I was thinking not relevant instead of Judge Middleton. Let's see what we have here. He was live this morning. He's not live right now. Not showing anything live from him. Let's see. Manning. I was thinking Manning. She's also not live. Oh, but holy cow, she dropped her do not record from her camera. Hang on. When did this happen? When did Judge Manning drop? Sweetness. Let's watch this one because hey, we can.
See exactly where you are at. Please make sure that you do wait so I can see where you're at. Unless enclosed, your lawyer should send you a copy of your bond order. But in the event that you don't get it because you make bond, please reach out to them and get them to send you a copy, or go by the courthouse and get a copy. It's important you have that. That's going to have all your bond conditions. It tells you where you can go, what you can do, and who you can be around. So make sure you please keep a copy of it. Stay in your booths. If you got to go get your meds, I get it. You can jump out real quick and get your meds. Don't go hang out yelling at people, waving at people. And sit up straight and pay attention. If I call you and you're out of your booth, I'm going to skip over and your case is going to be reset. So please stay in your booth. Keep your head up. It's not a mirror. Sit up. 6 South, booth 3. Sit up.
6
There
South.
we go. Sit up. There we go. You're in a courtroom, okay? So sit up straight, people. We'll get out here as quickly as possible.
I'm up.
Here, Mr. Powers. The big might go a tad slower tonight because Odyssey's still down, but we'll get it as quickly as we can.
She runs a tight ship here. If you're not paying attention, she's going to call you out.
We got South NX here yet? No.
I'll contact him, Judge.
Yeah, because she's working at those phones.
What's that?
Yeah. I'm sorry, this is Lieutenant Conklin. I'll contact South Annex.
Oh, okay. I'm just checking to make sure we're getting. Let's see. Let's see if we got somebody here so we can go ahead and start. Do we have, let's see.
Okay, pay attention.
We got Mr. Mondelli here for, you ready? Mr. Mondelli?
Good evening, Judge, and yes, I'm ready for Miss Boyd Brown. She's on camera.
All right, and you ready, Miss Bridges?
Yes, ma'am.
And we got Bostic 2.0. Who's here with me tonight? Miss Roberts. Okay. Miss Roberts, we'll start with position 7. It's Kayla Boyd Brown. Position 7 on the regular calendar is 23 CP 221-101, 179 days without indictment. What I have right now, Mr. Mondelli, is no bond on cruelty in the first degree.
That's correct, Judge.
2 cycles. She may have an open case for aggravated assault. The arrest is from April 7th, 2023 out of Fulton County.
All right, go ahead, Mr. Mondelli.
And Judge, just to correct on that case is no longer open. She has resolved any and all pending matters with the first offender plea before Judge Carnesale last week. So this is the only other pending matter that she had, and she has been in jail obviously more than 90 days at this point in time without indictment. So we are seeking a bond by statute under these circumstances. The allegations in this case, Judge, are that my client is accused of physically abusing her infant niece while the child was in the custody of Miss Boyd Brown's mother, the child's grandmother. My client, of course, strenuously denies the allegations, and we are assembling a packet of medical information to submit that any alleged injuries that the state may be investigating are actually explained by other medical facts and information about the child. But that is a battle for another time and not before your honor. With regard to the overall facts, her criminal history is what it is. She has just entered a first offender plea to her outstanding aggravated assault cases, consolidated into one. They both involve a now ex-boyfriend. So there is no previous allegations of child abuse, child danger, child cruelty, child endangerment of any form. With regard to her ties to the community, obviously she has been I think, lifelong resident of Georgia. She resides with her mother and would continue to do so. She can find gainful employment through various members of her family who run various custodial businesses
it's getting crowded
in the metro Atlanta area, and she would be able to go to those jobs almost immediately. The child in question, in this case, is no longer, in my understanding, in the state of Georgia. Upon my information and belief, she is with extended family members of, I believe, the child's father in Pennsylvania. So the child is in no danger from my client. Not that there was ever any harm by my client towards her, but even if there was a concern about that, she is nowhere in the state. And my client has no intention of going to interact with the child's extended family or have contact in any way, shape, or form. So in other words, Judge, she has extensive ties to the community. I'm sure her mother is on the YouTube live stream watching this right now because she asked me for the link just before court. She's got additional family ties. Her crimes that she's alleged to have committed, we'll deal with that when the time comes, and while they are serious, she has a relatively small criminal history since she just took a first offender plea. She has had no danger to the alleged victim in this case, given what I believe to be the extensive physical distance between the two. And so, Your Honor, we are asking for a reasonable bond set by this court.
All right, go ahead, Ms. Bridges.
Your Honor, the state is going to ask for a substantially high bond in this case. The defendant does have a criminal history and is one that's violent in nature, although his first offender for aggravated assault. And the crime before the court today is a crime of violence, and it involves a minor and a knife. So the state feels that the defendant is likely to reoffend and is a danger to this victim. There is family ties, so that means there may be some incidents of witness intimidations because of the family ties. So the state would ask for a bond to be set no less than $50,000.
Can you give me the alleged victim's initials, please, Ms. Bridges? You have it?
Yes, ma'am.
South Annex, sit up. What are you doing?
FB.
Okay. All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with F as in Frank, B as in Bravo. Does she have minor children?
No, she does not, Judge.
Okay, so no further contact with FB or any other minor children of, you said it's her niece, her sister, her brother, any other minor children, unless, of course, they're her own. What's her sentence on her first offender, Mr. Mondelli?
Judge, she ultimately received a 10-serve-1 with, or 10-serve 12 months with extensive credit for time served. I believe this may be the last thing holding her in, or there might be just a little bit more time after that.
All right, we'll give her a $20,000 good bond. Best of luck to you, ma'am.
Thank you, Judge.
All right, have a good one.
Have a good one.
All right, let's see. Now I've got
Kimbers, congratulations on the 10 months. Thank you so much. So close to orange.
Ms. Browning here.
Your Honor.
All right. We got, is it RGO Jester?
Yes, Your Honor. Is he here? Because I went to go visit him at ACDC last week, and they told me he was released February 3rd.
Okay.
Yeah, he's right there at ACDC.
Okay. Well, then, in that case, I would ask that we have a reset for a week so that I can go back and see him. We are working right now with Home of Light and Viewpoint Behavioral Health to get him placement. And so I want to just be able to ensure everything is in place before a bond argument. So because I was told last week on the 6th when I went there that he was released on the 3rd, I would ask for just a week reset. But since we're probably closed Monday, then for Tuesday the 20th.
All right, we'll get it, Ms. Robinson. Can we just get it on as quickly as we can? It may be a couple of weeks.
Yes, Judge. Which client was this for? I'm sorry.
This is position 4 on the add-on Jester.
She just wants it reset for a couple weeks.
Right.
Oh, I would rather it just be reset 1 week if possible. Just I want to ensure everything's in place for him, and we've been working at it. But because I was told he was released last week, I didn't actually confirm all the placements have been made.
Okay. That's right. Next week may be kind of full, so it may be the following Monday, but we can get it. We'll get him back in.
Great. Thank you. I'll come see you, Mr. Jester. I was told you weren't there, so I'll come see you this week.
All right. Thank you, thank you, ACDC.
Thank you, Your Honor.
Let's see. Do we have, let's see. Is it South Annex? Are you Terrence Mills? Wave your hand if you're Terrence Mills. No, well, I can go to the next one if you're not.
There's Terrence Mills.
All right. That's Terrence Mills. Sorry, calendar's not like it usually is. All right, this is Terrence Mills. This number 15, pretrial 23 CP 217934. Terrence Mills, 297 days without indictment. Looks like there is a $60,000 good bond as of September the 8th on possession of a knife or a firearm during the commission of a felony. Receipt of possession, transport of a firearm by a convicted felon, felony first offender. Purchase, possession, manufacture, distribution, or sale of marijuana. Purchase, manufacture, distribution, sale of marijuana. Possession of a firearm during the commission of a felony. Possession of a firearm by a convicted felon, and possession of drug and use of drug-related objects.
Yep.
Wow.
Judge, I'm not sure that Mr. Walker has joined yet. If you
he's not.
I don't think he's on here.
I can actually make an announcement. Our office contacted Mr. Walker, and he stated that he had withdrawn from this case. And so Mr. Mills subsequently filled out an application with the Public Defender's Office and was determined to have been qualified. I submitted a substitution and a motion for bond, and then it was subsequently calendared. And so that's the status right now.
So are you ready?
Yes, I'm ready, Judge.
All right.
Pre-trial.
21 cycles, 2 FTAs, possession of cocaine with intent to distribute conviction 2013, and possession of a controlled substance conviction 2007. Nothing further.
Go ahead, Ms. Collins.
Yeah, yes, Your Honor, make him look good. Is Mr. Mills. As of today, he's been in custody for 297 days on this case. He also has an indicted case that we're handling as well. But the current incarceration is for this case. The case remains indicted. He does have a high bond on this case that he's unable to afford. As you mentioned, his last hearing for bond was in September. It's been 90 days since then.
Did I miss a cow?
And the case is still unindicted. He has not been able to post bond, so it is unreasonable for him. He's 36 years old. He's from Atlanta. He has a good address, which should be the address on file. I'm unable to check because of the Odyssey issues, but it should be the Seville Street address on file. He is employed as a barber, so if he were to get released, he will return to that line of work. He's a father. He has 6 children that he cares from, ranging from ages 17 to 3 years old. He co-parents. He's completed the 11th grade at Mount Zion, but prior to his arrest, he was taking GED courses at Atlanta Tech and also working on getting his CDL license. Judge, we're asking if you consider reducing this bond. In my review of the warrants, it looks like a couple of these are duplicate charges, as in I don't see a warrant for them. And based off of what was found in the warrants, it appears to be duplicate charges, specifically counts 3, 4, and 5. Judge, I would ask for a reduction on all of those charges, but on the duplicate ones, which I believe to be duplicates, I would ask for a very minimal bond on those, perhaps $1 bond on those charges. But Judge, on total, we would ask ideally for a bond to not exceed $10,000, Judge.
You also have 60 on each one? I mean, like 10 on each count?
Yeah, it's 10 on each count, and possession 7. I'm sorry. Count 7 has been a UJR through the jail, and then the other 6 are 60 each.
Oh, 10 each. Okay, thank you.
I'm sorry, 10 each.
All right, thank you. Go ahead, Ms. Bridges.
No objection, Judge.
Well, I'm not going to do a $1 bond. I understand. I can't look at the bond orders to see if it is duplicate, but as soon as it comes back up, Ms. Collins, I'll be glad to pull it up and look at the bond orders. I mean, it seems it may be duplicative, but I just don't know. So I'll do 5,000 on each count and leave count 7 at UJR through the jail. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Let's see. If available, he'll have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as he supplies the name of his employer, proof of employment schedule, and the exact location he'll be working. So it's 5 on each count, except for UJR through the jail. Best of luck to you, sir.
I'm sorry, I interrupt, Judge. He does have a couple of holds on his last bond hearing. There was a ankle monitor, no ankle monitor going to the holds, but if no holds, then ankle monitor. So I was asking if we could keep that condition in case they are going to pick him up on those holds.
All right. If it is, he'll have 24 hours to have the ankle monitor placed back on his ankle once he's released.
I think it was actually a giraffe.
Thank you. Let's see. Position 12. What about Jaheem Capel? Ms. Gibson here? There's Ms. Gibson. All right, let's see. It's position 12. 23 CP 218530, 272 days without indictment. Got hijacking motor vehicle, armed robbery, possession of a knife or a firearm during the commission of a felony.
Hijacking.
And I have a $45,000 good bond as of, what is the date? November the 20th.
I sent you a message. It's a few that I didn't have because I can't get an Odyssey to get their information. So I can get a date of birth. I will be able to reach GCIC.
On this one?
Yes, 12 is one of them.
Ms. Gibson, can you send pre-trial officer, yes, Ms. Collins, his date of birth, see if she can?
Yes, I can do that. My Wi-Fi is going really slowly, so.
The Wi-Fi actually is a
I'm going to try to send it.
Radio signal, which I believe travels about the speed of light. It's pretty fast. Your computer, on the other hand, might be having issues. I have to play the screaming goat as soon as she says pre-trial.
I think it's the storm because mine's moving like stagnant pond water.
I just need her to tell somebody to stay out of Fulton County. That's all I need. That's what I came for.
Okay, hold on. I know I'm trying to find the year of his birth. I have his birthday, but.
We could ask him. I mean, you could unmute the mic and he could tell us. That's one of the things you can do on this new fangled Zoom.
Sent.
Okay.
Judge, if you want to go to someone else and come right back, I'll have it by the time we're on the next person. It's a two-step process. It'll take a few minutes.
Right.
5 North, sit up. 6 South, sit up. Judge is going to look in just a minute, and you don't want her to yell at you.
All right. Let's see who I have next here. Something next. Do I have Alpharetta? Yeah, there's Alpharetta. Let me see who's there in Alpharetta. Just if this is who you are, Alpharetta. If it's not, shake your head and I'll go to the next person. Are you Walter McCarter? Nope.
Nope.
Aaron Shelton? Nope.
Third time's the charm.
Mark Harwell.
Yes.
Ding ding. Now we're cooking with gas. Okay. Mark Harwell. So do I have Miss Browning? There we go. All right. It's position. I think you said you had this one. Position 6 on the add-on. So it's 23 CP 221023. Mark Harwell, 182 days without indictment. Looks like there's a $2,000 split bond, criminal damage to property to second degree, and 1 count of criminal trespass.
40 cycles. The last felony conviction I saw was in 2001 for forgery.
They do good.
Everything else is in the 90s and 80s.
All right, go ahead, Ms. Browning.
Your Honor, as you said, Mr. Harwell has been in custody for 182 days. He is still indicted. So he has been in custody for 6 months. He does dispute the allegations and does have video footage of the complaining witness admitting that she lied to the police, saying that she didn't want her boyfriend to get in trouble because he did catch them together, and he subsequently hit the complaining witness, not my client, the other person who she was protecting. My client is 61 years old. He was born in Atlanta and has lived here essentially his entire life. His family is in the state and he is not a flight risk. He has been on disability for over 30 years, Your Honor, and thus he has no income to pay bond. His income is solely reserved to surviving. He has lost everything due to these unsubstantiated allegations. He has spent half a year in jail. He has lost his home, his storage unit, and all of his possessions. And even his cats were put down because he has been in custody and unable, and was evicted because he wasn't paying his rent because he was incarcerated. We are asking at this time that he gets UJR because of everything he has gone through, and he cannot pay any bond at this time.
All right, Ms. Steffo, did you see that message in the chat that Edward North, position 5, will have to be reset? He's at Grady.
Mr. North is there. He's in.
Moss. Sorry about that. Moss.
Moss. I don't represent Mr. Moss, Your Honor.
I do, Your Honor.
Okay, there you go. Yours. So he looks like he's at Grady.
All right, thank you.
Okay, go ahead, Ms. Bridges.
Your Honor, the state will be asking for a bond to be set no less than $5,000.
It's $2,000 right now.
It's okay.
Yeah, because he's been in.
5,
yeah.
Okay. Well, with that being said, the state feels that the bond is reasonable. I believe he can qualify for PAD or some other type of assistance to help with his bond matter, and so we'll ask the court to keep it where it is, being that we do feel that he's likely to reoffend. He has 40 cycles, and that's all, Judge.
Your Honor, may I say one more thing?
Sure.
Okay. We cannot go through the bail project because he does not remember a lot of phone numbers. Therefore, he cannot get the references he needs through the bail project. And as pre-trial said, other than one felony conviction, I believe, this century, the rest were from like the 90s. So just due to his lack of recent criminal history and lack of resources, we are asking again for a UJR.
Sir, you gonna live in Clayton County still?
Yes.
Yes, so you're not gonna live in Fulton County? All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Let's see, no further contact. I don't have the victim's name. You have the victim's name, Ms. Bridges? Oh, you're on mute, Ms. Bridges.
Ms. Bridges?
No, we haven't had any victim contact.
Do you have the victim's name?
Oh, not right now, Judge. Not.
All right. Nope. All right. Well, stay out of Fulton County unless you're here for court or to see your lawyer, and no further contact with the alleged victim. If Ms. Bridges could find the name, since we still don't have Odyssey, then we'll put the victim's name in there.
Hey, and do you mind if I put it in the chat box, Judge?
Okay. Okay. Yeah, that's fine.
She still has to read it.
I mean, I'll have to say it out loud for the record, so.
Okay. Give me 1 second.
Let's see. All right, while you're doing that, I got Mr. West. Let's see.
I think Michael Russ Jr. just finished his breakfast. He's just wiping a little
All right,
bit
Mr.
of
West, do you want to send it to me?
Off his face.
So, Judge, I'll get a consent order prepared on Bogdan and Tamasov. You should have gotten the email from Lauren McCauley with the DA's office indicating that the state consented.
All right, so she's all right. I just got
on trial. Yeah, she's on trial, and she took a second to send you an email quickly saying she had no objection, just at 5:02.
Okay. All right. You and your client can go ahead and leave. So we'll remove on the add-on calendar for the modifications number 1. All right. Just y'all get it to me and I'll sign it.
Thank you,
Judge, I'm sorry, just really quickly. His client was position 1 and 2, so he's going to be submitting an order for both positions.
Not sure about that.
Yes.
Okay. All right. Well, all right. I'll sign it whenever you guys get it to me.
Thanks, Judge.
Have a good one.
You too.
Do we have a name yet?
Your Honor, it is, sorry, just had it. It is Belinda Miller.
Okay, no further contact with Belinda Miller.
Yes, I was.
Let's see.
Typing it.
182 days. Can he do the 10% or no?
Your Honor, he cannot. He doesn't have access to his disability or anything while he's been in there.
All right, we'll do UJR on both since it's been, but stay out of Fulton County, sir, unless you're here for court or to see your lawyer. No further contact with Belinda Miller. Best of luck to you, sir.
Thank you so much, Your Honor. And also just regarding Mr. Moss, could we get him set for as soon as possible as well? He has been in there for 154 days and he has no bond set.
Okay.
I'll get him reset to the first available calendar.
Thank you so much, Ms. Robinson.
Kay Bosk is the reporter.
Let's see who else we got here.
The court reporter. Instead of typing everything,
what about
she's speaking
now,
into a microphone.
Alpharetta, just don't get up. Just tell me, are you Aaron Shelton?
Yeah.
Aaron Shelton. All right.
First try, Judge. First
That's
try.
another one where I need the date of birth.
Okay. You got his date of birth?
He's like, I could tell you.
And Your Honor, I'm here for Ms. Murray for for Shelton.
Do you have his date of birth that you could put in the chat?
Oh, let me check. I'm sorry, Your Honor. I didn't realize.
It's okay.
You've been talking about before.
The stenographer's
Yes, I will
mask.
put it in the chat now.
That's what it is. Snakes Weather Watch.
Do you have the other one ready? Or purple?
Yes, I do.
Hey, I could get that job if YouTube doesn't pan out.
Right? Yeah.
If YouTube doesn't pan out, I could do that.
All right. So we're waiting on Mr. Cable, right? You got that one, Cable?
Yes, I have his date of birth.
All right.
23
CP 218530, 272 days without indictment. Hijacking motor vehicle, armed robbery, and possession of a firearm during the commission of a felony. Like I said, there is a $45,000 good bond as of November the 20th, 2023. Wow.
2 cycles, no felony convictions, a point in arraignment on pistol conviction in 2023, and nothing further.
All right. Go ahead, Ms. Gibson.
Judge, Mr. Capel is 18 years old. He will be in custody 9 months as of the 16th of this month. He is in 11th grade at Douglas High, and his mom is actually on the Zoom today to support him. She's been working with his school, and they have said that he can come back and even attend online from home. He works with Chaz, who is his older brother through the Big Brother program here in Atlanta. He works HVAC with Chaz. He also is a sound system tech at Heelan Heights Church,
Hey.
where he is an active member.
Let's hear it for the
He
techies.
also just had a baby in December.
Another
and
man
he would
made
like
a
to
miracle
get home
delivery.
to help his girlfriend take care of the baby.
Nice
He
of the
also
girlfriend
has
to take care of
elderly
his baby.
grandparents that he helps take care of when he's at home. So we would be asking for his bond to be significantly reduced today, not to exceed $15,000.
All right, go ahead, Ms. Bridges.
Judge, the state is going to ask that first, the state feels that bond is reasonable, but if the court is inclined to reduce it, we ask that it be reduced no less than $30,000 in total. We have not had victim contact so far, but however, I do have the victim's name in this matter. Again, these charges are egregious and just based off what's in the warrant. We have an admission from Mr. Cable, so the state feels that it's likely, there's a strong likelihood they'll be able to prove his case if this were to go to trial. So given the nature of these charges, we'll ask that bond, if the court is going to reduce the bond, it'll be reduced no less than $30,000.
All right. No
They've
drugs
never been able
unless
to
prescribed,
contact
no
the
alcohol,
victim.
no weapons, no replicas of weapons, no further contact with Mystique Taylor. Stay away from 1305 Oakland Drive in Atlanta, Georgia. No further contact with your co-defendant, DeJour, D-A-J-U-O-R, Ingram, I-N-G-R-A-M. Also, no replicas of weapons. You can have ankle monitor paid for by the county if available with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. 15,000, 15,000, and 3,000. 15, 15, and 3. Best of luck to you, sir.
It's 33,000. She said that a time or two.
All right, let's see. Now do we have, you got Mr. Shelton's
Birthday? Alfreda?
history yet? Ms. Robert
Yes.
Shelton. Oh, okay. All right, so we got Aaron Shelton. That's put number 2 on add-on 23 CP 222938, 111 days without indictment. There's a $5,000 cash bond on criminal damage to property second degree and burglary second degree. Pre-trial.
Sorry, the goats.
He has a 2023 conviction for burglary, criminal damage to property, criminal attempt to commit a felony, and then a 2023 conviction for entering auto. Burglary convictions in 2007 and 2005 out of New Jersey, and a 2008 burglary conviction out of New Jersey, 1 FTA from 2018, and nothing further.
All right. Is Ms. Murray not here? Oh, are you covering this?
I'm here for Ms. Murray. Yes, Your Honor.
Okay.
As you said, Mr. Shelton has been in jail for 111 days without an indictment. Mr. Shelton's entire record is theft related, and he's never been accused or convicted of any violent crimes. This incident and others on his record arise from a drug problem that began in 2018 when his grandmother passed away. He wants help for these issues and would like the state to indict so he can possibly participate in drug court. Mr. Shelton is not eligible for a UJR, but can't afford any bond. He also has a probation hold in Muskogee, so he is not bail project eligible. We would ask for a nominal bond of $10 so he can be released to his hold.
All right, everybody sit up straight, Go ahead. What says the state?
Yeah, Judge.
I don't know why they made this, somebody made this a cash bond. It wasn't me.
And that's what I was about to say. Maybe we can change it into a $5,000 bond. But given the fact that he's a multi-state offender, the state feels that he's likely to reoffend. I'm not sure if we just set it to a $5,000 bond, he'll only be responsible for 10%.
ADA there is a bad news
You
bear.
do that, Ms. Browning, through the 10%, through the jail 10%?
I don't believe so, Your Honor.
She's always
all right.
Thinking the worst
No
is going to
drugs
happen.
unless prescribed, no alcohol, no weapons, no replicas of weapons. You don't happen to have the alleged victim's name and address, do you? Kind of hands are tied without being able to access my warrants.
Yes, I will check. Give me one moment, Your Honor.
Okay.
It looks like it was a Barnes & Noble, Your Honor, 48 5th Street Northwest.
All right. So that's at Georgia Tech, right? So stay away from all Barnes and Noble, stay away from Georgia Tech property. Stay away from 48 5th Street Northwest and all Barnes and Noble. So I'll do 2,000. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'd be working. 2,000 and 2,000. And that can go through the 10% at the jail too.
But you can't work at Barnes and Noble.
Thank you, Your Honor.
No Barnes and Noble
you.
restocking the shelves.
Let's see what I got here. What about, let's see, McCarter. You have McCarter stuff?
Carter, are you 4S?
Good morning, Your Honor. That's my case.
All right, let's see. Let me let him get him in the seat. 7 South, booth 3. There you go. Keep setting up, sir. All right, this is Walter Lee McCarter, position 11, 23, CP 217310, 321 days without indictment. Got a $345,000 good bond as of July. That's the last thing I've got from there, Mr. JS. So sorry about that. Trafficking in illegal drugs. BGCSA, possession of controlled substance in Schedule 1 or 2 with intent to distribute, possession of manufacture, distribution, sale of marijuana. BGCSA, possession of controlled substance, Schedule 1 or 2 with intent to distribute. BGCSA, possession of Schedule 3, 4, or 5 controlled substance with intent to distribute, possession of a firearm or knife during the commission of a felony, possession of a firearm by a convicted felon, purchase, manufacture, distribution, sale of marijuana, and BGCSA Schedule 1 or 2 with intent to distribute.
14 cycles. The last felony conviction I saw was in 1999 for possession of a firearm by a convicted felon. FTAs in 2006 and 98.
I need Mike to teach me his ways.
Nothing further.
All right, go ahead.
Thank you, Your Honor. As you just heard, Mr. McCarter had no even contact with law enforcement until now. The last time was 1999. This is a nonviolent allegation that's based on the amount. It's based on him being merely present at a scene, and there hasn't ever even been a finding of probable cause. I filed for us to set a preliminary hearing, but that hasn't been ever scheduled. We came before this honorable court before when his bond was at $500,000, which I thought was inexplicable. He's deemed to be a good bond candidate. If he was wealthy, he would be out by now. He had his bond reduced to $325,000, but that's also just way beyond his means. I've been retained for a really modest arrangement, Your Honor. I just think it's wrong what's going on with Mr. McCarter. He's approaching a year in confinement, and there hasn't ever been any finding against him, and he's actually innocent, and there's nothing we can do to force the state to indict him. He's just sitting there because he doesn't have $325,000. I think if it were something like $20,000, he can maybe stretch with his family and go through a bonding company and try to, show his innocence. But for now, all he's doing is just languishing away based on not having a lot of money. And Your Honor, we would just ask this court to set a bond that would ensure that he comes back, but that is actually one that he can pay because he's essentially in a no bond status because he's unindicted and just can't afford it. So it's like having no bond, Your Honor, which is not right in this case.
All right, go ahead, Ms. Bridges.
Judge, the court is inclined to reduce the bond. We ask that it be reduced no less than $40,000 on all the charges in total, and that he also has an ankle monitor placed on him.
Is $345,000? You want it reduced to $40,000 per count, or what do you? It's $345,000.
Well, we take into consideration that it's been a year. I was asking the court to go no lower than $40,000. If the court is going to reduce it from $300,000, that you go no lower than $40,000. If you're inclined to reduce it.
You're talking total.
Total, yes.
That's a huge.
All right. Well, I'm going to go by the standing order. I'm not going to quite reduce it that low because there's so many trafficking charges. Let's see.
Why have they not indicted him? Is anyone else concerned about that? Why has he sat there for a year without indictment?
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Is there a co-defendant, or can you give me an address? Either one of you? Because I can give you
an address.
Okay.
going to try to edit these ones out.
The address. Sorry, wrong one. The search warrant was it.
Okay, we're going to turn that off for just a minute while she gets through the address there. We do have a Monroe County Judge Mark Bronlick, who's just gone
live in
live.
Fulton County Council.
He would, Your Honor, unless the court wants him to live elsewhere. He intends to live in Fulton County, yes.
All right. He'll have an ankle monitor paid for by him with a 24-hour curfew, court, lawyer, medical, employment, as long as he supplies the name of his employer, proof of employment schedule, and the exact location he'll be working. 25, 25, 25. 25,000, 25,000, 25,000, 10,000, 15,000, 15,000, 5,000, 5,000, 5,000, and 10,000. You want those again?
Your Honor, I didn't keep track in my head, but that's way beyond what he's going to be able to afford, like, given that he's on a house arrest and an ankle monitor, and even the state is okay with 40,000.
Right, but you got 1, 2, 3, you got 2 trafficking and other things.
He's
so
unindicted.
Here's my numbers: 25,000, 25,000,
50,
25,000,
75,
10,000, 15,
85.
15, 5, 5, 5, and 10.
140.
Best of luck to you, sir.
150, 160. It's 160,000, roughly.
Right, let's see.
Oh, Judge Manning, you're not going to be my favorite anymore.
What about Edward North? Edward North. Wave
Wait.
your hand if you're Edward North.
Edward.
Nope, no Edward North. Let's see.
Your Honor, he's there in booth 3, 106.
Wave your hand if you're Edward North. I don't see any hands waving. Oh, there he is. All right. I think that's it for South Annex. That's everybody.
How you doing, Your Honor? This is Officer from South Annex. I don't know if you skipped over Joel Garland.
I don't have a Garland.
No, Joel Garland, book number 211.
Judge, he's position 12, sorry, on the calendar.
Not online. Let's see.
Or no, hold on. Sorry, I lied. He's position 8.
She lied.
His case has been indicted. Sorry, your case has been indicted. Thank you, South Annex.
Thank you.
All right. Now, where was I at?
Like, what does that mean? He's like, so do I have to still say it?
Now. Who did I just call?
Mr. North. Edward North.
Sorry, I can't. This stuff's got to get fixed quickly because this is all throwing me off. Let's see. Let me find it again now that I've looked through this.
I don't like this.
All right.
This has got to go. I think these guys need to go to the Supreme Court, U.S. Supreme Court. This just does not.
Oh.
That's not right.
All right, Edward North, position 5. Edward North, 23, CP 222760, 116 days without indictment, aggravated assault, terroristic threats, no bond.
Pre-trial.
6 cycles, no felony convictions. He may have an open case pending. The arrest was from July of 2022. The arrest was aggravated assault and possession of a firearm during the commission of a felony. And nothing further.
All right, go ahead, Ms. Duffo.
Mr. North has been a resident in Atlanta for the last 40 years. He has his sister, nephew, and brother here, and 2 sons. He's had a 12th grade education and has been working lawn care service for himself, as well as contracting with Andy's Lawn Care for the past 8 years. He visits New Hope Church in the Pittsburgh community where he lives for 3 times a month, and he also does maintenance around the church for free in order to help them out. He does have a good address. He will be living at the address that's on file. He does live there by himself and has been renting that home for 15 years. We are asking for a bond not to exceed $10,000 in this matter.
Is that in Fulton County where he's going to live?
Yes, Your Honor.
All right, go ahead. Ms. Bridges?
Miss Bridges. Paging.
Go ahead, Ms. Bridges.
Paging Ms. Bridges.
Okay, I'm sorry about that, Judge.
given that these were serious violent charges, the state is going to ask for a bond to be set no less than $40,000. It's 20 on each charge. We have not been able to make contact with Tyrell Hardaway, who is the victim, but the state will ask that the defendant, that a stay away be put in place. And also, Judge, we're going to ask for an ankle monitor paid for by the county on this case.
Do you have an address where the offense was allegedly?
Yes, that's in Atlanta.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Terrell Hardaway. Stay away from 946 Hubbard Street, Southwest in Atlanta, Georgia. Have an ankle monitor paid for by the county if available with a 24-hour curfew, court, lawyer, medical, employment, as long as he supplies the name of his employer, proof of employment, schedule, and the exact location he'll be working. $20,000 and $20,000. Best of luck to you, sir. It looks like position 4 is off the calendar. That's Selenion. All right. What about Gene Predestin? All right. Position 14.
Good afternoon, Judge. I'm ready. I'm Mr. Predestin.
Predestin. All right. Sorry, I may have mispronounced it. All right. This is position 14, 23 CP 223318. Do you have his date of birth, Ms. Roberts?
Yes, I'm good with him.
Okay, that's one you need. All right. Gene Predestin, 23 CP 223318, unlawful for a person employed by, associated with criminal street gang to participate in criminal street gang activity. Possession of firearm by a convicted felon, and unlawful for a person to commit the offense with the intent to obtain, earn membership, maintain, or increase status. No bond in 96 days without indictment.
Sounds like he did some gang stuff, allegedly.
Auto conviction, 2 counts from 2020, and then 2 FTAs, 2015 and 2019. And nothing further.
Which one is he?
All right, go ahead, Ms. Taylor.
Judge, did you all still need the date of birth?
Yeah, she got it. She as long as there's a few, she didn't have a DOB. She had his.
Okay. All right, Judge. On behalf of Mr. Predestin, he was born in 1992. He's been living here in Georgia for the last several years. He has at least 6 children. The oldest is 13 years old. The youngest is 2 years old. He was doing warehouse work. Judge, he disputes these gang charges. Basically, he was arrested, Judge, on Cleveland Avenue. And as you know, if you get arrested on Cleveland Avenue, they're going to put you in the gang. But he denies being in the gang. He does warehouse work, supports his children. The address on record is the correct address. His father lives there, Alex.
Got a little update on Georgia law for you.
To that address in Snellville. Judge, this case basically is about 14 grams of marijuana that was found in a car, and a gun found in a car. He was not in the car at the time the gun was found. Judge, I'm asking the court to consider a reasonable bond for Mr. Predestin. I would ask the court, like I said, these gang charges, he denies them.
I think she meant gang.
Like I said, even they would say in the warrant, Judge, that because of the location, this is a known location for YSL and sex, money, murder. Like I said, it's like you can't be on Cleveland Avenue unless you're a member of a gang. At any rate, the 14 grams of marijuana and the gun were found in a car, not on Mr. Predestin. So we got a misdemeanor amount of marijuana and a gun located in a car.
Just like a young thug?
I'd ask the court to consider a total bond in the neighborhood of maybe $15,000 to $20,000. I recognize he's got these gang charges on there, but, at this point, he's presumed innocent. And certainly we'd ask the court to consider that. He's been in custody now more than 90 days.
The judge smirked when she said presumed innocent.
Powers.
Thank you, Judge. Mr. Predestin is entitled to a bond at this point. We have no objection to that. We think that a bond in the amount of about $100,000 total would be appropriate in this case based on his history of failures to appear and based on the severity of the gang charges.
What gang are you alleging that he's a member of?
Your Honor, as defense counsel said, it is YSL / sex, money, murder. Those are both subsets of the similar gang.
I didn't say he was a member of the gang. I said that's what they have on the warrant is that area that in those, that's the area for those known gang members. Right. Like I said, the presumption arrested unless you're in the area. 100,000 bond just for 14 grams of marijuana and a gun, I think.
All right, record's clear. Miss Taylor wasn't alleging that, but that he was a member of that. But thank you for letting me know that's what's on the warrants. All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no social media, no further contact with any gang members, any affiliates of any gangs at all, but especially those YSL and sex, money, murder, not just limited to those. Stay off of Cleveland Avenue, stay out of Fulton County. The only reason you come to Fulton County is court or to see your lawyer. You're going to have an income monitor paid for by you with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Once again, stay out of Fulton County unless you're here for court or to see your lawyer. 35,000, 35,000, and 10,000. 35, 35, and 10. Best of luck to you, sir.
That's 70,000.
All right. Judge, can he get the income monitor paid for by the county if available?
How's he paying for you, Miss Taylor? Are you appointed? Is he paying for it? Are you?
Judge, I'm telling you, it's minimal. Okay, I told you he got 6 or 7 children.
And he pays child support for them?
Yes, Judge. Well, he supports them. I don't know about court-ordered child support. I know that he supports them. I've talked to the mothers of the children, and they certainly indicate that he supports his children.
Higher math.
What's the state's position?
Thank you, Smurf.
Judge, we don't have an opinion on that one way or the other. Whatever is available, that's fine with us.
All right, paid for by the county if it's available. If it's not available, paid for by the county, then he's going to have to pay for it.
Understood, Judge. Thank you.
All right, best of luck to you. Good to see you, Miss Taylor.
He's not sure
you, Judge.
If it's 6 or 7, I think.
Ian Ball. Thank you, Mr. Powers. That's your only case.
Thank you, Judge. That is.
Ian Ball. Wave your hand if you're Mr. Ball. All right, we got that. Mr. Showalters, position 1 on the add-on, 23 CP 222663, 120 days without indictment. I think it's no bond on aggravated assault and possession of a firearm or a knife during the commission of a felony.
This was the final one that I needed a date of birth on.
Okay, Mr. Showalter, sorry, could you put the date of birth, his date of birth, in the chat for pretrial? What about we go to while he's doing that, we go to what about Julian Shipman? Where's Mr. Shipman? All right.
5S booth 3.
I don't think I got a bond order holding Mr. Shipman. All right. Mr. Showalter, if you get that in there, then we'll hang on. We'll do that one after Mr. Shipman. 23 CP 216632's position 3. 446 days without indictment, but not on this charge. Right now, there is a $19,000 good bond.
46 days without
as of
indictment.
December the 11th on riot, unlawful for an inmate to possess any controlled substance, drugs, gun, or dangerous weapon, and 1 count of ag assault.
21 cycles, 3 FTAs, 2012, 18, and 19. Sale of marijuana conviction 2019, and then a possession of a Schedule 1 controlled substance and sale of marijuana conviction in 2017. And that's
21 cycles.
Go ahead,
That's in and out, right?
Yes, Judge.
In the
Mr.
system,
Shipman
back
is
out.
31 years old. He was born and raised in Atlanta, has lived here his whole life. His whole family is in and around Atlanta, mom, cousins, and grandma. He has 3 kids, a 3-month-old, a 9-year-old, and a 10-year-old. And his mother, Mr. Shipman's mother, is taking care of the 9-year-old. Before being arrested, he was coaching football for 8-year-olds at Hateville Recreation as a pastime and to volunteer in his community. He was doing that for about 3 years. He has his own business, All Love LLC, where he sells clothing. He will be living at an address with his mother in Atlanta. Again, his mom and his 9-year-old son lives there. He does help his mom out with rent while he is living with her, but his goal is to be able to move into his own place with his son.
His mom charges him rent. That's what I heard.
This bond was last heard back in December 11th. He does have those 3 FTAs, but they are old, 2012, 2018, and 2019. So I'd be asking for a bond not to exceed $10,000. And to be clear, this is not what is holding Mr. Shipman. He has an indicted case that is holding him on no bond.
All right. Go ahead, Ms. Bridges.
Judge, based off his history and his criminal history and the history of his FTAs and given the serious natures of these charges and violent natures of these charges, the state would ask for a bond no less. If the court is inclined to reduce it from $19,000, they'd be reduced no less than $14,000 for both of the charges in total.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Vanlin, your co-defendant, Vanlin, Vanlen, Preston. You have an income monitor paid for by the county if available with a 24-hour curfew, court, lawyer, medical. No further contact with Quashawn, QWAYSHAWN Green. So 5,000, 500, and 5,000. 5,000, 500, and 5,000. Best of luck to you, sir.
Thank you, Judge. And that's my only matter this evening. May I be excused?
Yes, ma'am. Thank you. Let's see. Well, this is good. All right. We ready for Mr. Ball again now?
Yes.
All right. Ian Ball. So we got position 1, 23 CP 222663, 120 days without indictment, no bond, aggravated assault, possession of a knife or a firearm during the commission of a felony.
Well, pre-trial goes off on.
First adult arrest.
Oh.
All right. Go ahead, Mr. Showalter.
First adult arrest.
No, you're on mute, Mr. Showalter.
You're on mute.
Thank you.
State of Georgia has 4 years to indict you.
Ian Ball is 25 years old.
2 years on misdemeanor, 4 years on a felony.
His address on record is the address he would be going to. That's 1961 Pinedale Drive in Atlanta. That is his mother's address, Chile Ball. He would be living with her. He is going to be finding a new job if he's released, and is working on getting his GED. I do want to remind the court that this is his only offense. He has a clean record, and so it's not an everyday thing. He's not a repeat offender. And so I believe the court can trust him out on bond. He's not a flight risk. He's not a threat to the community. So given that, I'm asking the court for a $10,000 bond on the aggravated assault charge and a $2,000 bond on the weapon possession charge.
All right. What says the state?
Judge, the state's going to ask for a substantially high bond in this matter. This incident basically boils down to an argument over barbecue sauce and 75 cents, where the victim would end up being shot by the defendant twice.
What?
The state is going to ask for
over barbecue sauce?
No less than $60,000 to be set on these charges before the court. Again, the state feels, they're serious, they're violent, and what took place was very senseless. So the state, and it took place in a public place. So the state feels that he's a danger to the community. And so for those reasons, we ask for a bond no less than $60,000.
Do you want to give me the alleged victim's name and the address?
Yes. Etonio, so I'm going to spell that ENTONIO Wagner, WAGNER. This took place at
it better be good barbecue sauce.
Parkway, Northwest Atlanta, the Checkers restaurant located.
All right.
At a restaurant, Checkers restaurant.
Mr. Walter, he's still going to live in Fulton?
Yes, Your Honor.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas
charged
of weapons.
for barbecue
Stay away
sauce.
from 264 Donnelly Hollywood Parkway. And all Checkers restaurants. No further contact with Etonio, ENTONIO Wagner, WAGNER. I'll give 60,000 and 10,000. 60,000 and 10,000. Best of luck to you, sir. You can leave the booth. Thank you, Mr. Showalter, if that's all you have.
Yes.
Okay, Malik Drummond. All right, Ms. Gibson. Sorry, I'm trying to get to you guys. 23 CP 221826. $20,000 bond on riot in a penal institution and battery. 588 days without indictment, but not on this one.
11 cycles, 2018 FTA, 2020 conviction for purchase, possession, or have a control.
28
Schedule 1
FTAs.
or narcotic in Schedule 2, and then a 2020 conviction for tools, possession of a firearm during the commission of a felony, 2 counts of entering auto, and 2 counts of criminal damage to property. And nothing further.
All right, go ahead, Ms. Gibson.
Judge, Mr. Drummond is 24 years old, a lifelong resident of Atlanta. His mom, dad, sister, and brother all live in Atlanta. He has a good address where he lives with his father. And he also works with his father. Daniel and Boone Lawn Care is a business that Mr. Drummond started when he was a child, but obviously a child cannot own an LLC. So his dad got the LLC up and running, and that is their business together. He graduated high school from Life Christian Academy. He has only ties in Atlanta. He's not a flight risk. He also has other indicted cases that are holding him. This was a mere fist fight that happened in the jail. And so we would be asking for a UJR on both charges so that this case is not holding him in jail when he goes to either move down the road or complete his time for his other cases, because this incident happened in Rice Street. And so we would ask that he get a signature bond for these charges and not be held in Rice Street where the incident happened.
All right, go ahead. What says the state?
Judge, given that he has an extensive criminal history, feel that he's likely to re-offend. So we'll be asking for a bond no less than $14,000.
All right. Do you have the alleged victim's name by any chance?
It's probably another inmate, I'm guessing.
Oh, 1 second, please, Judge.
Okay. Hey, Miss.
Oh, you can.
Mr. Malkin.
Hello and goodbye.
Goodbye.
See you tomorrow.
Okay. Yes.
Just pop it in, interrupting court.
Aaron Sparrow.
Aaron Sparrow.
No further contact with Aaron Sparrow. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. $5,000 on each count. Best of luck to you, sir. You can leave the booth.
Judge, I don't think that's the correct victim, at least not on the.
What do you have? I mean, what do you have?
I have Lamarck Manigault and Sharante Wright.
Or Julian Shipman?
No,
this is Malik Drummond.
Okay, no further contact. Can you spell those, Ms. Gibson?
Now she screwed up.
Yeah, of course. Lamark.
She just lowered the bond on someone.
Last name Manigualt.
Okay.
And then the second name is Sharante, Sharonte. Last name Wright, Wright.
All right, so 5,000 and 5,000. Best of luck to you, sir. You can leave the booth.
And Judge, you did not order an ankle monitor on that, correct?
No, he's got those other cases that are holding him in. That's fine.
So
all right, let's
the state
see.
argued their position based on somebody else's record.
Where's Tyree Moore?
Didn't even mention the 24
Position 6, 23
FTAs.
CP 223 315, 95 days without indictment. Looks, I don't have a bond unless you know something more. I don't know, Ms. Steffo. 95 days without indictment, possession of firearm by a convicted felon, misdemeanor obstruction, and possession of marijuana less than an ounce. Right.
44 cycles, 2022 conviction for possession of meth, possession of a firearm by a convicted felon, and possession of a firearm during the commission of a felony. 2020 aggravated assault conviction, 2012 and 2006 burglary conviction, FTAs 23, 2 in 2018, and then 1 in 2015. Nothing further.
All right. Go ahead, Ms. Steffo.
Mr. Moore does have a $12,000 bond. He's just unable to afford that, and he has been incarcerated for 95 days. He is a lifelong resident of Georgia. He's 37 years old and currently has a baby on the way. He would live with his mom when released in Valdosta, Georgia, so he would not be in the Fulton County area. And he did currently have a job at Racetrack and Quick Trip. We are asking for a bond not to exceed $3,000 in this matter.
All right. Go ahead, Ms. Bridges.
I guess the state wants it higher.
The state feels that $12,000 is reasonable based off his criminal history, but the court is inclined to reduce the bond amount. We ask for the gun charge that a bond be set no less than $5,000, and the state doesn't object to UJR on the misdemeanors.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay out of Fulton County unless you're here for court or to see your lawyer. That's the only reason you come back to Fulton County, sir. And you have an ankle monitor if available, paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. And no further contact your co-defendant, Michelle Palmer. Michelle Palmer.
I apologize for interrupting. Miss Palmer is actually the soon-to-be mother of his child. Can they talk at least in regards to child care? And
sure, except for child care and basic life necessities for the child. 5,000 UJR. Best of luck to you, sir. 5,000 UJR. You can lead the booth. Thank you, Ms.
And your Honor, that concludes my business. May I be excused?
Yes, ma'am. Have a good one.
He wants to talk, but they don't unmute.
Jarrell Hassan. All right, number 9, 23 CP 223-372, 93 days without indictment. So, Mr. Bruss, I have a $20,000 split bond. I hope that's right. 93 days without indictment, ag assault, possession of a firearm during the commission of a felony, and cruelty in the third. Right.
4 cycles, a conspiracy to commit burglary conviction in 2008 out of Maryland. Nothing further.
Go ahead, Mr. Russ.
Good evening, Your Honor. Mr. Hassan is 34 years old. He is not born in Atlanta, but he's been here for 3 to 4 years. While he was out, he was working continuously, always has been. I'm uniquely positioned. I actually grew up with Mr. Hassan. I've known him for a number of years, probably 25 to 30 years at this point, and so I can talk to him outside of this situation, but also to him as a man. He has 3 children. He's done very well as a father, which is very unique and very rare for where we come from. His son is a senior who has been accepted into at least 8 or 9 different colleges, Morehouse being one of them, a school in Savannah as well. And I think that is also a testament to how he's been as a father. In regard to where he would be when he gets out, it would be a different address. He would be living with his aunt, who has been here for probably 7 to 8 years. That is in Fulton County. She is also here on the Zoom because she is offered to be what I'll call, and I know it's not the federal system, but serve as a third-party custodian, for lack of a better phrase. She would report any concerns to the court. She would report them to me, and I would report them to the court. And so we don't think there's any concern for him, one, fleeing. There's no history of FTAs, of committing a different felony, or intimidating anyone, because we have myself as a backdrop, but also Jennifer Fields is her name, and again, she is on the Zoom. We will be asking for a reasonable bond. We will be asking for a total bond of $20,000, Your Honor.
All right, go ahead, Ms. Bridges.
And I'm sorry, I may have misheard you, Judge. Did you say he had a $19,000 good bond split?
I've got 20, not 0 on the ag assault, and then 10 and 10. That's what I have right now.
Okay. Judge, for the aggravated assault, well, first, the state feels that the split bond is reasonable for those 2 charges, the cruelty to children and the possession of a firearm or commission of to commit certain felonies. As far as the aggravated assault, just based off the 4 corners of the warrant, this did involve a shooting incident where the victim was shot. Also, I'm sorry, just wanted to make sure. Yes, and also the victim was struck several times in the face with the firearm. So the state feels this is a serious and violent nature, and also the defendant does have some criminal history, so we feel that he's likely to reoffend. And so we're asked for a bond on the aggravated assault to be no less than $60,000.
Do you have that alleged victim's name and the incident location?
Yes, Alicia McNeil, ALISHAMCNEAL. This took place at 2.
Mute this part out.
And that's College Park, Fulton. Do I need to spell the Picardy circle for you, Judge?
Do you need that, Mr. Dukes or Ms. Robinson?
That will be helpful.
All right, we're almost done here with this court. We might jump in on another. We heard that at noon there might be something really interesting in Cedric's court, Cedric Simpson.
Oh. All right.
May I say one more thing, Your Honor? I apologize.
Sure, go ahead.
The prior incident, and I know it was a while ago, my understanding is that it was in relation to video games. And the severity of that was based on the value of video games. And also what the state is recommending as far as a bond goes, Mr. Hassan would not be able to make that. I know one of the questions that comes up is, hey, well, he hired a private lawyer. I am doing this case completely for free. Again, I grew up with Mr. Hassan, and so he is not paying a lawyer. And so a bond set for what the state has recommended, he would not be able to meet. And that's also another basis for why we're asking for a total bond of $20,000.
Mr. Ross, I got a question for you.
Yes, sir. Yes.
I'm assuming that he got into Savannah State, but why is he going to go anywhere except for Morehouse, his son? I don't
know. I need to do some convincing, I guess.
I'm just trying to figure that out. I mean,
maybe it's just the options. You keep the options open and you nail it down, because sometimes we get nervous, especially where we grow up. Not many people go to college, Your Honor, truly.
Right.
Not many people do. So.
But he got into Morehouse, so that should have been his number one pick. Right.
I know. I'm going to let him know.
I'm just saying. All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 2695 Pick Hardy Circle in College Park. No further contact with Alicia McNeil or that minor child that's the cruelty in the third. So we'll do, you have an ankle monitor paid for by the county if available, with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. Now, was this person allegedly shot in the face or hit in the face?
Hit in the face several times with the firearm.
Okay.
And also shot in the right leg.
All right. We got 25,000, 5,000, and 5,000. 25, 5, and 5. Best of luck to you, sir.
Thank you. That's all I have, Your Honor. May I be excused?
Yes, sir. Have a good evening. All right, I got Jason Nickerson.
Sit down, buddy.
Let's see. It's position 3, 23 CP 222161. 140 days without indictment. Right now, I've got $40,000 good bond as of 6/23. Possession of a firearm or a knife during the commission of a felony. Aggravated assault, hijacking, and armed robbery.
No felony convictions.
All right. Go ahead, Ms. Browning.
Right, Your Honor. Mr. Nickerson is 36 years old. He has lived in Georgia since he was 2 years old, essentially his entire life. His whole family lives here in the Conyers area. He has 2 children for whom he provides. That's an 8-year-old Jace and a 7-year-old Royal. He also has a fiance whom he has been engaged to for about 6 months. He graduated from high school and received his AA in business. He has his own barber shop, and he is also a certified master barber. He served time in the military in the Air Force several years. He needs to get out, as Your Honor. He is desperate to see his children and support them, and he wants to fight this case that he can raise his children. Because he hasn't been working and he is the sole provider of his home, we are asking that bond does not exceed $10,000 at this point. As you said, he has been in there for 140 days without indictment.
All right, what says the state?
Judge, I want to make for sure. Did you say position 9?
No, it's position 3, Nickerson. Jason Nickerson.
See, that's the problem. I don't have position 3. For me, is Julian Shipman.
She messed up her paperwork.
So I think there were 2 calendars.
Yeah, this might be the add-on calendar. Yeah.
This was the add-on calendar that was sent out.
Yeah, maybe the add-on. Sorry, I mean, I'm getting them mixed up because I don't have them printed out like I usually do. So
yes, it's number 3 on the add-on calendar, Your Honor.
Yeah. It's actually the last case. So, I mean, on this, besides the other bond modification.
Come on, this guy's had to sit there through everybody else's, and now you can't find his paperwork.
Can I get the bond amount again?
It looks like previously it may be 40,000, 10 on each.
That's correct, Your Honor.
She's just going to wing it. She doesn't have any of his data. She's like, well.
Okay. Judge, given the nature of these charges, the seriousness of the charges, we feel that 40,000 is reasonable. So we'll ask that the court keep the 40,000 as it is.
And Your Honor, may I say one more thing?
Sure.
Yes, I did just also want to highlight the fact that Mr. Nickerson does have no felony convictions, and he is a provider. He's 36 years old, so had, he highly disputes these charges and does want to fight them. If he were one likely to commit charges like this, I do believe he would have had something before 36 years.
Do you have the alleged victim and the location by any chance?
I have the location, Your Honor. And the alleged victims. The location is just like.
Okay.
So it was another, okay. He wouldn't be doing that right outside his home.
Okay.
But it is on Metropolitan Parkway Southwest.
Okay.
But obviously cannot stay away because that is where he resides. But the alleged victims are Mr. Jordan Free, Free, and Jose Cisneros, that's D as in dog, Isneros. They're with a repo company, not there to repo Mr. Nickerson's anything. It was someone else. But so they don't reside on that street either. So I don't believe a stay away from that location would be necessary.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Jordan Free or Jose Disenos, Diseneros. If available, you have an ankle monitor paid for by the county with the 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. So 5,000, 8,000, 8,000, and 5,000. 5, 8, 8, and 5. Best of luck to you, sir.
26.
Thank you, Your Honor. And that concludes my business. May I be excused?
Yes, ma'am. Have a good evening.
Thank you, you too.
All right. All right. Let's see. Now I just got the one bond modification. That's Talia Coleman.
Wait, there's.
Judge, I think that the case that the other attorney is on here, his case have been indicted.
Which case is that?
That is going to be for Corey Woods, position 10 for Mr. I'm sorry, I don't want to mispronounce his last name. I won't even try it. The case has been indicted.
All right, we're going to bail on this just briefly.
You haven't have
We're going to bail because we're going to try to get over here to Judge Simpson. If you give me just 1 minute. Let's see. Where are we? Judge Simpson. Okay, we're on a holding pattern with him right here. We think he starts right now, so we'll keep the audio on, but I'll keep the video here. Does that work? Apparently, we've got might be a little bit of a spicy, or at least an interesting sentencing going on. I am so small, we in the corner. Sorry, I moved myself back to where I should be. Let's see. It was nice to get a little bit of Judge Manning. I like it when she doesn't put up her "you can't use my stuff" warnings. All right. When are we going to break for lunch? Is it lunchtime? It is noon. It's noon, but let's see if we can get what's happening with Judge Simpson. If hopefully that does. Come on, it's live. At least we're waiting for it to become live. It wasn't very spicy. I realized that was a slow one. That was from previously because it was not live, but it was not as spicy as I would have thought. You guys just want to talk amongst yourselves while I continue to edit video? I don't want to play it and then get a strike. Strikes are no fun. Let's see. We have What did I miss? I'm just trying to catch up in chat and see if I missed anything. Simpson's on break until his 12 o'clock block. He normally comes in about 12:07, and it's 12:06 right now. So we're waiting for him to come in. 12 o'clock block is coming up right now. We don't want to miss any of it. Go back and find the cow. I found the cow. It was actually it's the apple emoji. Like you can build your own little animal emoji for yourself, and it maps your face, and so that like the ears and the eyes, and you move your eyebrows and it moves. It's very really cool mapping. If you have one of the newer iPhones, it can do that. I think it uses LiDAR, actually, like 20,000 points of LiDAR to map your face. It's Memoji. I think it was the giraffe, not the cow. But it was very brief, and it was somebody who just logged on and then logged back off. Pretty sure the 4-year figure is a statute of limitations for most felonies, and there's a 90-day time limit between arrest and before being a grand jury. Yeah, once you're indicted, they can hold you for like a long time. But unindicted, 2 years for a misdemeanor, 4 years for a felony in Georgia, which is one more reason not to commit a crime in Georgia. It was Melanie, one of the lawyers. Oh, busted. Let's see, where's my camera 7? This is an old police chase, I think.
I'm not a cat.
Yeah. $10 months ago. Looked familiar. Okay, John Stevens, he's not live. It doesn't look good. Okay, sorry, I'm just going through seeing if there's anything else available. There's not a lot unless it's out of Montgomery. Play the reel? What reel? My son playing the music, the piano? We do have a podcast tonight, or not tonight, tomorrow night. Sorry, Thomas. Didn't mean to give you a heart attack. Tomorrow night at 8 p.m. You want to edit with me? Isn't there a way you can connect? Are you on Final Cut? You use a Mac for Final Cut? Is there a way? There's a way you can connect devices so they can share. I think you have to do network attached storage and have both devices sharing off the same thing, and then open the file. I think you can do it where two people can edit the same thing. I've never had the need to because I'm just one person. Okay, judge is taking his time getting to court here. How am I supposed to freak people out? Hang on. What did lawyer Melanie do? She joined using a Memoji video filter. So she appeared as a giraffe on the, just briefly for like a second. Logic Pro. Sarah Boone is still scheduled for May with her new attorney. We're actually waiting to see if we get any letters from her. Let's see. Sarasota. No. Let's see. Where's Orange County? There it is. Orange County.
I'm not a cat.
Yeah, why is it? I cannot get them to authenticate my account in Orange County for some reason. So I don't know. I tried. Vicky, no, the old trials are very difficult for the channel. Holly, where did the goatee go? I'm not sure. We're still looking. Can we do a poll on how long this attorney lasts? This is number 8. Man, but you've got a new judge here. So let's see. Just checking to see if there's any new anything. So still on trial for the 13th for Sarah Boone. Hearing on the 3rd. So it looks like it's going to be happening in May. Let me check the docket. Notice of provision of witnesses. When did this come in?
I'm not a cat.
Oh, the witness list was given to the attorneys. Okay. That's good. That's normal. Notice of placement of state's witness on state's Brady list. Brady is turning over evidence. I mean, that's a disclosure. Chelsea Copespel of the Orange County Sheriff's Office. Okay. I think she was one of the responding officers. Yeah, I can't see much else. I am expecting another letter to come in briefly from Sarah Boone. Happy Valentine's Day, everybody. Hope you're enjoying it. It's wonderful. Attorney Cashman is apparently no nonsense, according to a lawyer you know who knows folks who have worked with her. Wonder how that will go, given Sarah Boone wants it done her way. This is the first lady lawyer. Maybe I don't know who won. Maybe she'll be able to handle Sarah Boone. Josh, yes, please do send something to the burner phone. We'd love to take submissions and suggestions for trials if you have one. Let's see.
I'm not a cat.
I'm not a cat. I wonder if the new lawyer is going to go with the same, just continue the work that's been done by previous lawyers, or if she's going to come up with a different defense. What is the problem with old trials? A couple of them. Copyright issues is predominantly the problem, like a legal problem for the channel. Spoilers are a huge problem for the viewers. So it's tough to do that. I've been saying that I thought Boone should get a female lawyer. Boone doesn't seem to get along with men too well. I don't know. I think she doesn't get along with other people who were telling her how things are. She struggles with people not accepting her version of the reality. Thurston County's live, but no Mr. Frog. Let me take a look at Thurston County really quickly. Is it 3 or 4 or 1? Who is it? Thurston County District Court. Two is not live. 1 is not live. Let's guess 3 or 4. Those are our 2 other options. 3 is live. Let's see what's going on here. We'll jump in on this one while we wait for...
Issue's been going on for quite some time.
Cedric.
Of course, this is the first one that's been gone to trial. This is the second violation in this. I do not feel safe around her or for her to be anywhere near my house or my children. The civil case was for to extend the order to protect my kids, not just me. For her knowing that she had a no contact order and her coming to my home is very disheartening, and I do not feel safe. I had to put cameras outside my house because of her stealing from me and doing these violation of stuff. So I really would like to have the court extend, like maybe having her get some jail time, because I do not think that she's going to learn her lesson without that. And hopefully extending this order for even more than 2 years, if possible, protecting me and my children, because I do not feel safe around her whatsoever. Yeah.
Is it Michelle?
Ms. Rowe?
Your Honor.
It's Attorney Rowe.
This is an unusual situation.
Our friend.
It's not an unusual situation. These type of things happen all the time. Miss Morrison is actually in the process of working with the police because now she's filing for an order against Miss Charlene. It's my understanding, and Miss Morrison has called me at times right after
we're going to back up because this
incidents
gets
have
pretty
happened.
spicy.
It's my understanding that Miss Charlene is actually...
We're going to back up and get the background.
You have a case. Feel free to come in. What case are you here for?
We're backing up about 10 minutes.
Attorney waived the said he's gonna waive the hearing or something.
Wow, there's a goatee.
Do you have a case
Full
today?
beard.
Your Honor, that's
Okay. And whose client is it? Mr. Pizderka? Is he your client?
yes, Your Honor.
Okay, I'm just gonna have you take a seat. We'll call your case in a few minutes. And if you could, please take your hat off. Thank you. So I'm just gonna do this one case and then somebody else is gonna come out and complete the calendar. So Ms. Rowe, you're here. Ms. Morrison, can you come on the Zoom call, please? Michelle Morrison, can you unmute and come on the Zoom call?
Paging Michelle Morrison, your attorney's here.
And I think Charlene Wilson is here also. And so we're here for sentencing. I also had, do you remember Ms. Morrison there? Ms. Rowe, when we were in court and she pleaded guilty, I told her that there was a court hearing on February 5th for renewal of the civil order, and I told her she needed to be there. Do we all remember that? Ms. Rowe, do you remember that?
I believe, I remember she had another case, yes.
Right. And I guess I'm wondering, I asked her to show up on February 5th. I guess before we get started, I'm kind of wondering why she didn't.
Miss Morrison?
Did we lose her?
Did we lose her?
Is there an echo? Nope. Kidda, happy Valentine's to you as well. Thank you very much for the well wishes for me and my family. Emmanuel County, Georgia, huh?
Well, I'm going to step off and, a no bail warrants can issue. I'm going to be here all morning. And if she comes back on, you can track me. I'm going to be in one of the other courtrooms.
Okay, I will.
And then are you on this calendar there, Ms. Rowe?
Warrant. What a day.
Yes, I have. I've got quite a few cases in courtroom 3 today. You're right. Yes.
Okay, so if she comes back on, you can.
She will. I know that something must have happened, so I'll reach out.
Okay, she's coming back here.
Oh, okay.
Apparently.
Alrighty.
Ms. Morrison, you there?
Yes, I'm here. I don't know what's going on. The Zoom stopped working and I had to restart it.
Okay. So again, do you remember when I asked you to be in court on February 5th, excuse me, to address the civil order?
Yes.
Thank you, Alicia.
Why we missed you? Is there an explanation for your non-attendance there?
We missed you.
Yes, I had worked from like 3 o'clock in the morning until about 7:30, and while I was waiting for the Zoom call, I had fallen asleep. And I when I woke up, I emailed the court and told them what happened, and they extended it until the 5th of March, I believe.
That was a different court case.
Yeah, there was.
She missed 2. That was the Olympia case.
All right.
Defendant has, or the plaintiff has all the tea here.
So that case is on here today. There is Ms. Morrison. I'm going to speak directly to you. Ms. Wilson is here. We're here for sentencing. I took the plea. We're going to go around the horn for recommendations. The civil case is on the calendar as well. We're going to talk about that, whether or not there's been a petition to extend that. And then we're going to take that up here today also. And so, again, let me call the plea form. So I'll hear from the state first, then I'll hear from Ms. Wilson if she wishes to speak. Then I'll hear from Ms. Rowe, and then Ms. Morrison. You'll have the opportunity to address the court if you would like. So, Mr. Fortunato.
Your Honor, I'm going to be making this very brief. I think that the recommendation for 364 days imposed with 363 suspended, 1 day credit for time served, 24 months probation, no criminal law violations, abide by the post-conviction no contact order protecting Ms. Wilson, and paying $245 in restitution to Ms. Wilson for the damaged goods is appropriate. That was the recommendation. That was the agreement. Ms. Rowe is going to be asking for a deferred sentence. Ms. Wilson's going to be asking for, or Ms. Morrison's going to be asking for a deferred sentence. I don't think that's appropriate here. The state has already agreed to dismiss the malicious mischief charge in agreement to Ms. Morrison pleading guilty to this charge, which she has done. But understanding that there is also a pending Olympia Muni case involving these two same parties, Ms. Morrison and Ms. Wilson, state thinks that it is very appropriate to ask that Ms. Wilson plead guilty, serve the sentence, and at the end close the case rather than dismiss it. That is going to be the recommendation of the state. Ms. Wilson is certainly going to be free to elaborate a little bit more on why that's an appropriate request. Additionally, I believe I'm not going to be representing her on this civil matter, but I believe she has more to share on that as well. But that is going to be the request of the state, Your Honor, and I certainly defer my time to Ms. Wilson.
Ms. Wilson, anything you'd like to say? You filed a letter.
Yeah.
I had read a while ago, which I have up in front of me now. I'll hear from you, ma'am.
Yeah. So this issue's been going on for quite some time. Of course, this is the first one that's been gone to trial. This is the second violation in this. I do not feel safe around her or for her to be anywhere near my house or my children. The civil case was for to extend the order to protect my kids, not just me. For her knowing that she had a no contact order and her coming to my home is very disheartening, and I do not feel safe. I had to put cameras outside my house because of her stealing from me and doing these violation of stuff. So I really would like to have the court extend, like maybe having her get some jail time, because I do not think that she's going to learn her lesson without that. And hopefully extending this order for even more than 2 years, if possible, protecting me and my children, because I do not feel safe around her whatsoever. Yeah.
Ms. Rowe?
Your Honor, this is an unusual situation. It's not an unusual situation. These type of things happen all the time. Miss Morrison is actually in the process of working with the police because now she's filing for an order against Miss Charlene. It's my understanding, and Miss Morrison has called me at times right after these incidents have happened. It's my understanding that Miss Charlene is actually, her actions show that she is not afraid of Miss Morrison. Miss Charlene came to Miss Morrison, was at a gas station or a store not long ago, threw herself on the trunk of Miss Morrison's car and would not let stood behind Miss Morrison's car and would not let Miss Morrison leave. Miss Morrison is actually in the process of working with some officers to get the footage of that. Miss Morrison has also called me no less than 3 times, indicating that Miss Charlene has come to her apartments, yelling and screaming for Mr. Joseph Shelby to come out of her apartment. So although Miss Wilson stands before the court as an alleged victim, Miss Morrison's position is that Miss Charlene is doing everything she can to try to
Miss Morrison is nodding emphatically through all this.
With Miss Morrison. And Miss Morrison has finally gotten a couple of neighbors to write declarations about Miss Charlene's presence in her apartment complex. These neighbors have seen Miss Charlene lurking around Miss Morrison's home.
So,
and Miss Morrison,
Ms. Rowe, I hope you're not forgetting who's being sentenced here.
I am not. Your Honor.
Ms. Morrison pleaded guilty. I reviewed what the allegation is. I mean, it was in the police report, and
she pled guilty.
Yeah, I don't.
Now you're saying she's not guilty?
I will just tell you up front. You can continue, and I apologize for interrupting. You're not going to get very far with me by blaming the victim here, which is kind of what you're doing. And so again, I'm just going to tell. I'm just a word to the wise there, and you can continue. Go ahead.
Thank you, Your Honor. I am not trying to this is why I started out this recitation saying this is unusual. It's unusual on my part, but as this court knows, because this court has dealt with many of these types of cases, this is 2 women interaction because of a gentleman. We are present, ready to go forward. Ms. Morrison absolutely understands the no contact order and assures the court she has not violated it and will not in the future. I just want this court to understand that this appears to be a situation where there are two women basically fighting over a gentleman. That being said, Ms. Morrison took responsibility for her actions regarding the incident that we were going to trial on. She's assuring the court will not see any future violations. She was doing everything that she believes is humanly possible to avoid contact with Miss Charlene. Unfortunately, as this court knows, no contact orders basically are one way. And so Ms. Morrison wanted the court to understand a little more of the tenure of this case. As the court can see, Ms. Morrison has little to no criminal history. And at the age she is, I believe that shows that she is a law-abiding citizen and tries to be for the most part. We had discussed with Mr. Fortunato requesting a deferred sentence in this case, and we will be asking that the court consider deferring sentencing on this case, allowing Ms. Morrison to show the court that she can abide by the court's orders. And we are requesting that the court consider deferring sentence so that this can ultimately be dismissed.
Wow. That's a big ask. I realize we've got a jury of voir dire.
Ms. Morrison, anything you'd like to say at this time?
Happening in Thurston County 4.
Yes.
So we got lots
I heard in the beginning when you spoke, Your Honor, about the deal that I am making with the court about, you said something about 24 months of probation. I wasn't aware of any probation. I was only aware of 24 months of me not contacting Charlene Wilson. So I was kind of confused about that part.
Okay, I'll explain that to you.
Mm-hmm.
Anything further?
If I'm allowed to speak about this whole thing in general, this whole case going on right now with Charlene Wilson.
Sure. Lay it on me.
I just want to say that I know that she has gone through a lot with Joseph Chelde throughout the years, and it hasn't been good on her part. Like, it's been very hard for her mentally, physically, in every way with him. And I know that she feels like I'm the problem and I've hurt her somehow. And the real fact is, Joseph Chelde is the one that's been hurting you, or hurt, not you, but her. And I think that is the main problem and not me. And I feel like that's something that if she could,
James is like, I'm out.
In her life,
I'm out.
Figured out, and it would make it a lot better for her and her children when it comes to her and Joseph. And that's pretty much what I'd like to say about that.
What's your position on the extension of the civil no contact order, the order that's been in place? It's like Judge Buckley entered that back in June of 2023. There's been she's been trying to get that reissued.
Sorry, Your Honor. Sorry.
That was June 20th of 2023. So she wants to extend that. And so I guess what's your position on that?
Your Honor, I'm in the process of, I'm going to get a no contact order on Charlene Wilson because it's been a major problem with her coming over to my home and, doing things. There's a lease violation.
That's one thing I'm not interested in what you're going to do. I ask you a specific question about this order.
Okay, so this order, I have no problem with staying away from Charlene, and, that's not an issue for me. And I spoke to my lawyer in the municipal court case. I think his name is Terrence Wong. And I told him that there was a 2-year no contact order with the district court, with this court. So I don't think that there would be a need for another no contact order to be placed. And that's, as far as that, that's all I understand about what's going on with that.
So,
Your Honor, I would also piggyback on Ms. Morrison's argument, and that is that because that Ms. Morrison is willing to abide by any
Your Honor, I would object
existing
Ms.
no
Rose
contact
representing
order.
Ms. Morrison on a case.
Don't worry about it, Mr. Fortunato.
Mr. Fortunato, don't.
I'll reserve anything else, Your Honor. Thank you.
So, and again, I just want to, put on the record what's actually alleged. This pled at a late date. An alibi witness was produced at the last minute with no notice to the state. In the state's trial memorandum, it indicates that on October 30th, shortly before 1 a.m, officers were called to the residence of Ms. Wilson. There was a description of a car that had come to the house, driven away, and maybe my words, but kind of peeled out. There were neighbors who observed the car. Officers got the license plate or identified the car, went to the owner of the car, which was Ms. Morrison, felt that the engine was warm, recent use, and then Ms. Morrison indicated that she was at the casino. She produced a receipt from the casino, which was about 11:59, which is about 55 minutes before.
A receipt? You lost X amount of dollars?
The officers were called about the incident, which is plenty of time to go from the casino to Ms. Wilson's residence.
Cat's going to jump. Sneaking into the
and
window.
now, and then when we come, the person who's charged with the violation of the no contact order, the person who is pleaded guilty is basically come to court and say, well, gosh, it's not me, it's her. And so I think that alibi witness, given the way it was produced and without notice, I think might have sustained some credibility problems. And yeah, I'm just going to leave it at that. But with regard to the sentence, I'm not going to do a deferred sentence. This is the first conviction for violation of the no contact order. So I'm not going to impose any more jail time than has already been imposed. Although there's some, by the time you get around to sentencing, if there is a sentencing in the city of Olympia judge is going to see that there's previous convictions for this order, and will probably take that into consideration in what he or she decides to do with this case. So there's that. But so I'll go along with what's recommended. In the criminal case, it'll be 364 days in jail with 363 suspended, credit for 1 day served. It'll be suspended for a period of 2 years. And the term probation gets thrown around in the sense that you're not going to be on probation in the sense that you're going to have a probation officer, you're going to have to check in or anything like that. That's not the case. The probationary period means that's the period of suspension. So for the next 2 years, if there's any violations of this order, then you can get summons back here, and some of this suspended time can be unsuspended. You understand that, Ms. Morrison?
Yes, I do, Your Honor.
And so again, you'd be subject to jail time if there's any more violations of this order, and you won't have a trial on that. This will be a evidentiary hearing determined, and the standard is different. If the order's been violated, you'd be looking at some incarceration time. And there'll also be $246 in restitution. And again, that'll be in place for the next 2 years. I'm also going to sign an order on the civil case that extends the civil order for 2 years from today. So both of these orders are going to be in place for 2 years. And they are, I've heard this thing, well, why do we need 2 orders? And Ms., on the civil order, that includes the children. And so that'll be part of that civil order as well, whereas the criminal order doesn't. So, and of course, Ms. Morrison, you're free to pursue any sort of order that you wish to pursue. But that's going to be what's going to happen here today. Now, give me just a minute. I'm going to need a minute to fill out those orders.
Okay. So while this happens, we're going to jump over to another. We should have jury selection in Thurston County 4. So let's get ready here. We've got some pre-trial work going on.
There's not a keyboard.
Here we go. There we go. All right. Is everyone holding still, or do you? Oh, yeah. Go ahead and move. Thanks. They're just holding still for me. Okay. So this happened a minute ago. It looks like they're in a break right now. So we're gonna try to catch up right now and get this pretrial motion sorted out, because it looks like we're going to have a jury trial that's starting right now in District 4, and we love those. This is Thurston County, Washington.
Please.
Oh, yeah. Very patient judge.
I'm going to jump in and do that one when it's ready. Okay. Sure we're on. Okay. Mr. Castling, you're standing, so I assume you have something to say.
Thank you, Your Honor. I was hoping the court would call Mr. Archie Salzer's matter. He is not present at the moment, and I can just make a record that I'm surprised by his absence. I did expect him this morning. Last information I had, last I met with him, I perceived him to have a pretty serious medical issue. I don't have details to add to the court. I do not have any concrete information on where he is at this point, but we are not ready to proceed to trial.
Now, he was present at your motion hearing a couple of weeks ago, wasn't he?
Yes.
All right. Well, it turns out we have another case that's probably ready to go to trial. Okay. State?
Your Honor, the state would be requesting a bench warrant in the amount of $5,000.
Has he failed to appear before?
Do you guys really pick up people when they don't show up for court?
Once at arraignment
asking for a
this
friend.
Case.
March. Okay. All right. Well, in any event, strike the trial.
Strike the trial. Well, we thought we were going to move forward. Apparently, there's another one. Let's see what happens.
We'll issue a warrant $1,500, but Mr. Gasling, if you get other information about his health or anything like that, you can bring that back up. That may be a basis to quash the warrant.
Yeah.
And then in any event, when he does reappear, that's when time for trial will recommence.
Thank you, Your Honor. I appreciate it.
He was standing because there was no chair.
So you're here for Mr. Red.
Yes,
Is
Your
this
Honor.
Mr. Red here?
Yes, sir.
This is Mr. Red.
Good morning, sir. All right, and that's 23M149 for trial. Is the city ready to proceed?
Yes, Your Honor.
Okay, and you're gonna be doing this trial, Ms. Kitmacher?
With the exception of motions in limine, Your Honor.
Okay, excellent. And
new lawyer.
Are you part of this too?
Second chairing, Your Honor, yes.
Okay, gotcha. All right then, before we go any further with this case, let me ask each party if you're going to consent to me hearing the case for trial. City?
Yes, Your Honor.
Okay. Mr. Phone?
Yes, Your Honor.
That's because he's a magistrate and not a judge.
Okay, so you,
it's a weird little rule. I don't know the difference.
Yeah, both sides have filed some motions in limine.
You're just going to get up and leave? We just got started.
We'll deal with the motions in limine first. And it's Mr. Thompson, it sounded like you wanted to be part of that for the city.
That is correct, Your Honor.
Okay. All right. Well, just in general, since for Ms. Kitmacher and
the new trial.
Ms. Capone have done trial with me before, when it comes to motions in limine, generally speaking, I don't rule on them. The reason I don't is because most of them are not really motions. They're things that I would expect contemporaneous objections to be made.
I don't rule on motions in
Some
limine.
do require ruling, and I would, of course, do that. But what I rely on you to do is to go through your motions in limine and bring up the ones that you actually need rulings in advance on, rather than just the sort of evidentiary or, more, for example, like if one of your motions is to prevent people testifying in the form of hearsay, we don't really need a preliminary motion in limine ruling on that. That's something you would object to if it happens in trial, and that'd be a ruling at that time. So with that in mind, though, and I know you've been through this with me before, Mr. Thompson, so you've seen this. So you want to raise the motions in limine from the city side that you think need ruled on?
Remember, I don't think there was anything specific from the city's filed ones that are beyond standard.
Yeah, I do see these usually.
Yeah, there was. Sorry, I've helped a lot of people prepare motions lately. I'm trying to make sure I don't miss one that was added that was non-standard. The state did wish to address some of the defenses, however.
Yeah, we'll do that. I'll let Ms. Capone raise hers first.
Yeah, the state has nothing from, I think, that are beyond standard, and ones that, generally speaking, I don't think would be addressed.
Okay.
We do have a specific witness, I think, somewhat related to Ms. Capone's motions eliminated on the defense witness list that we do wish to address also.
Okay, we'll do that too. All right then, Ms. Capone, your turn.
Thank you, Your Honor. If we get a specific ruling on defense's motion in limine number 5, I know that typically that would be something that you address as a contemporaneous objection, but I imagine that.
The one about the word assault?
Yes.
Okay.
That would be a legal opinion, and it would be something that a witness is testifying to with regard to a defendant's guilt. And I have watched many trials in this courtroom, and I anticipate witnesses attempting to use that language instead of expand upon what exactly happened. And because I anticipate that being a likely issue, I would like a ruling on that now.
Sure. Is there any response?
Your Honor, the state has already instructed the witness who would be describing said assault to not use the word. However, assault is a very common everyday word that people use and is difficult to not use that word. I think a minor violation or a curative instruction or a limiting instruction by the court that's something to the effect of a witness may have used the term assault in describing conduct or actions. That does not mean that it meets the legal definition. That is for you to determine. Something to that effect, I think, could cure any slip of the tongue that is, frankly, with assault specifically, is very likely to happen. It's an everyday term that people use all the time.
Okay. Yeah. Well, I appreciate that,
especially when they're describing an assault.
Witnesses about that. I think that's more than enough. This is like, victim or defendant or words like that. These are,
I used it this morning.
Also,
talked to my family.
Words that have a meaning in the vernacular and words that have a specific legal meaning, and they're not the only words that we're going to encounter along the way that's true of. So, I generally speaking don't find this to be the kind of problem.
Do you like a pepper shaker? And I said, no, assault.
Quite frankly, in all the years I've been doing this, I don't think juries have ever stumbled and been confused about assault. Words that are just in common everyday usage that also happen to have a specific legal definition. So I think rather than trying to corral and control that, it's best just to kind of be aware of it. And if it comes up in a context in which the witness is making a statement that is a legal conclusion, or if counsel is using it in a way to preclude the jury determining that, rather than having presenting it as if it were already proved rather than something that has to be proved to the jury, that would be a problem.
Please, Josh, send it to the burner phone.
I just felt that it was relevant if we're going to be proposing to the jury potentially an instruction that says the person's guilty of assault in the 4th degree if they commit an assault, and then there's a witness on the stand saying that an assault happened.
Understood. I am not.
It's always fun to ban
you for raising
ban
it, but I am
words
saying
pre-trial.
that at least in my experience, it's probably not going to be the problem that you're anticipating.
Judge Boyd has a trial today that involves a child. We're not going to go to that one.
Motions, Lindsay, that need a specific ruling on. I think there might be a conversation about the admissibility of the police video. It's my understanding that the state might want to introduce that, but we can address that.
Oh, is that in the,
when it comes up?
Is that in the supplemental that you filed?
In the supplemental, it just had 2 things. One of those things was that I'm asking the court not to let people testify as to policies, procedures, and practices done by the Hampton, as I don't think they're relevant, and I think that that is a best evidence issue. And then policies, procedures, and practices with regard to nursing profession as a whole, I think that's an expert.
Let's go back to the video, though.
Okay.
Tell me more about that.
So the state indicated to me on the 9th, so this past Friday, that they intended to use a video of Mr. Red's statement to police. It's like an hour and 15 minutes. And I was asked if I had any objections to it. I indicated that there's probably most of it is not relevant. And it also is redundant if there's going to be an officer on the stand testifying to what was said. I asked the state to indicate to me if there were certain aspects of that video that I could look at, because it's an hour and 15 minutes, and I would be able to let them know how I felt about more discrete sections. I asked that on Sunday, February 11th, and I didn't get a response. So I don't know how much, if not the whole thing of the video that the state's going to be asking to rely on, but I do have some objections to it.
This is a video that's an interview between Mr. Red and police?
That's correct.
Okay. So that's number 23 here then.
Yes, so that is just addressing that if any part of the video or audio recording were to go back with the jury and found admissible, I just asked that the copy provided to the jury be cut down to exactly that, so the jury doesn't accidentally hear things or see things that they weren't supposed to.
Yeah, they would now normally they would only get the admissible parts.
Yeah.
Yeah, the non-admissible parts that would have been redacted out, they wouldn't get, certainly. Yeah, there wouldn't be a problem with that, would there?
No, specifically, yeah, I would agree that whatever the court admits would go back to the jury. And whatever the court admits may need redactions. What the state was seeking in informing defense counsel was if they had specific objections to anything in the video. They've known for almost a year that this video was evidence in this case. I would wholeheartedly disagree with defense counsel that it's not relevant or cumulative. It's in the defendant's statements, and it's irrelevant whether an officer can testify to it or not. It is the defendant's statements from his actual mouth on video.
From his actual mouth.
There's no 3-5 motion or no 3-6 motion has ever been requested by defense. There's nothing to suggest other than subject to some certain hearsay rules or whatever, which is what the state was seeking in reaching out to defense counsel was, do you have specific things in this video you find objectionable under the evidence rules? So we could edit them out in advance. We got no response from defense in that regard. While I understand Ms. Capone disagrees with the state that it should be admitted, the video is admissible as relevant. It's an interview regarding the facts of this case.
And Your Honor, if I could respond.
I mean, obviously it is going to have, it'll have to be authentic. It'll have to be relevant. And then, you know, statements within it can't be hearsay, of course, or otherwise, you know, objectionable. They may not, individuals statements about, I mean, I don't know what's on it, but if it's an hour long and there's a conversation for 5 minutes about fishing or something like that, that's probably not relevant. But
and the state would edit that out just for time's sake.
I'd actually want to hear the fishing part.
It doesn't sound problematic just from the description I've heard, so I don't know.
No, Your Honor, and I'm not objecting to the whole thing. I just, when you're presented with an hour and 15-minute video, I was pointing out that there are aspects of it, many aspects of it that are not relevant. There's plenty of time that passes where the conversation is not relevant and should not be admitted. And I would also point out that the state has had this video just as long as defense counsel has and did not disclose pursuant to discovery that they intended to use it until Friday.
I believe we disclosed it in April of last year.
Yeah, I mean, it's one thing for the state to provide information and discovery, but they don't have an obligation to tell you their trial strategy with regard to any of that evidence. So, I mean, I guess we'll have to take it as it comes if there's any objections to segments of it or anything. Like I said, the description doesn't
raise
any alarm bells with me that it's problematic.
There is one specific section, if I could address. Okay. There is some conversation in the beginning of the video about a prior bad act, a prior investigation that may have occurred. It was proposed by the police officer around 8 minutes. I don't think that any of that conversation should come in as 404B. It implies that there was a prior investigation done on Mr. Red, and that goes to that's propensity evidence.
Okay, I'll take your word for what it is, but Mr. Thompson.
At this point, Your Honor, if again, I think the state would ask the defense to articulate specific sections of the video similar to that 8-minute that they would object to being admitted. That would give the state a chance between now and tomorrow to edit the video down, because we very well may agree with their objections. Over the years, I've edited plenty of videos in advance of trial in an effort to speed this up. So we're not doing this with a jury sitting in the back room. And so I again would ask that they have specific objections to time, that they can timestamp in the video. The state can edit in advance, and we don't have to have an 1.5-hour long watch session with the court editing the video together. We can do that in advance. But I'll leave it at that at this point.
Okay. I mean, normally what I would see with a video like that, especially something that, I mean, it seems like it's lengthy. If it's an hour in that neighborhood, that's decently long for a trial video. But between the process of the prosecution essentially creating their own highlight reel, that would, of course, limit things coming in that aren't important or cumulative or whatever. And then if defense, on top of that, defense and prosecution can come to some kind of agreement on what should be excluded from it and what's going to be admissible anyway, you may just find yourselves in agreement about, a portion of it that's 10 or 15 minutes as opposed to an hour plus. It seems like that's something you could do, but if you're totally at loggerheads about the admissibility of a portion of it, obviously we're going to have to resolve that. I don't know if that's an answer, but again, I don't know what's on the video.
Understood, Your Honor. Because the video was so long, I was hoping the state would be able to narrow down the scope of what exactly they were hoping to admit, but I can go through the video and go through every section that I don't feel is admissible and relevant.
Well, I'm sure the prosecution doesn't want to bore the jury any more than you do. So I'm sure that they'll present what they think is important and relevant and persuasive, et cetera. Okay. All right. What about this policy and procedure manual? Tell me more about that.
So, Your Honor, this is a case that involves, I think, 2 layers. One is that there might be policies and procedures employed by the employer, the Hampton.
What? I don't know what the Hampton is.
It's a elderly care facility.
Okay.
That's where the alleged incident occurred. And Mr. Red was a CNA there. Okay. The state's witness, Ms. Duplessis, was a CNA there. So defense anticipates that witnesses may want to testify to what policies, procedures, and practices were employed by the Hampton, the elderly care facility, and also what policies, procedures, and practices might be employed by CNAs generally. As to the Hampton, we feel that that wouldn't be relevant. It would serve to confuse the jury. The jury might start supplementing the standards put out by the Hampton for the actual criminal standards. We also think there's a best evidence issue that those things are probably going to be in a handbook somewhere. And because someone might be testifying to the contents of the handbook, we would want to see the handbook. And then with regard to the CNA or medical profession generally, we feel that that's an issue for an expert, and it hasn't been disclosed to defense counsel that the state intends to rely on an expert. I also think that that would be a relevance issue and a confusion of the jury issue. Our biggest concern is that the jury is going to take the practices, policies, and procedures employed by either the Hampton or the medical profession at large and supplement those standards for the actual standard involved in a criminal case.
City?
As far as the specifics of the policies and procedures, I don't disagree with counsel that the state's witness is probably not a subject matter expert sufficient to testify absent those documents too. And the state has no intention. However, she is a nurse, has been a nurse for nearly a decade. I think her training and experience is relevant, just as it would be for an investigating officer's training and experience would be relevant. And the court should consider, the jury should be able to consider her training and experience as much as her actual witnessing of the testimony, because it's all relevant. It all happened in the course of the employment as nurses or nursing assistants. And I apologize, I'm going to misuse the nursing term, but medical professionals. She has experience as a medical professional, and the jury should get to consider her experience as much as her testimony in weighing what she observed.
Okay. Yeah, the witness's experience and training might, although I can't say in advance, justify that witness testifying as to an opinion as well as to facts. Right, like any person who qualifies as an expert through training and experience and familiarity. So if that witness does, then I would expect that witness might be able to answer questions that are hypothetical or placed in front of her in the form of an opinion. For example, as to whether a certain procedure meets a medical standard or something like that. Now, again, I don't know if that's going to be the case, but that's whether or not that witness has that level of training and experience is a different issue than whether the policies and procedures of the employer are admissible. So it seems that if a witness is basing their opinion, an expert witness is basing their opinion on something like the policies and procedures manual or an article or a text or something, then those can be used to impeach them, but they're not themselves admissible as evidence. So is anyone intending to place a policy and procedure of the Hamptons in front of the jury as evidence?
The only circumstance I can think of is in the video, Mr. Red does discuss what he was taught to do with difficult patients. So it's his own statements regarding that. That's the only circumstances I can specifically think of.
Yeah, and that raises different issues there. I mean, that state of mind, motive, et cetera.
Exactly, which is why the state intends to use that portion.
But that wouldn't implicate like an employee handbook or a manual for policies and procedures on how to deal with people in their care. Doesn't seem.
It's close, but because it's how was he taught at this facility to do that falls under arguably some policies and procedures, but it also goes to a state of mind. So I think it would be admissible for that.
For sure. If he were to say, this is how I was taught to do it, it's in the book, you could certainly impeach him with the book. That doesn't implicate its admissibility. That's impeachment of his opinion, theoretically or hypothetically. So, I mean, does that answer for you, Ms. Capone, as to what you're interested in?
Your Honor, I would just argue that I don't feel that it's relevant to whether or not an assault occurred in the shower, but I can leave it at that.
Yeah, I mean, I think I agree. It wouldn't be, but yeah, I mean, if you're talking strictly about the admissibility of a handbook or a training manual or something like that, I think you're correct.
My concern is just a witness testifying to what the general practices for nurses or nursing assistants in dealing with a certain situation, and the general practice that the Hampton employs in dealing in a situation, and comparing those practices, procedures, and standards with the conduct that occurred. I don't think that there's anybody that is qualified to relay what the standard practices and procedures are, and then to compare conduct to those things.
And we'll have to see. They may be, they may not be. And again, that isn't going to be determinative of whether there was an assault. And it's also not going to constitute an excuse for one, or a defense to one, I should say, if that makes any sense, right?
Yes,
because clearly an employer can't write a manual that gives their employees permission to assault people.
Was this employee on employee or employee on resident?
Like I said, my concern is that the jury substituting policies and procedures for the law.
Yeah, and I agree that is potentially a problem. And I see that as potentially a problem more if such a policy manual were admitted into evidence, as opposed to, like what we're talking about, you using it more in the vein of impeachment, or, qualifying someone to have an opinion on an issue.
Understand.
Yeah. I mean, this is very much like, this strikes me very much like when counsel cross-examine police officers as to the administration of field sobriety tests, and they use a state patrol training manual to illustrate differences between what the officer actually did in the event versus what's written in the procedures manual. It doesn't do anything to make the actual field sobriety tests that were administered inadmissible. It's just impeachment.
Right, yeah.
Does that make any sense?
Yes, Your Honor.
Okay. All right, anything else?
I guess maybe one last thing is some 404B statements that I don't anticipate the state trying to elicit, but I don't know what their witness may want to testify to. Things like why Mr. Red was terminated, or why witnesses perceive the reason that he was terminated, I don't think is relevant. Also, a prior allegation that was investigated and ultimately found unfounded, I don't think is going to be relevant to this case. And I don't think that any of the witnesses should be able to talk about those things.
Well, it doesn't sound relevant, and I guess I'll ask you, Mr. Thompson.
Frankly, I didn't know that he was terminated. And I don't know if the state's primary witness is necessarily aware of that fact, nor did we have any intention of asking her about that. I imagine that if she knows it, it's more likely to come up in the course of cross-examination than from the state.
Yeah. I mean, it might be wise to just caution the witness that they shouldn't go into the sort of internal disciplinary issues that happen in the course of employment.
Understood. I think that those things would be extremely prejudicial.
Could be.
Especially the nature of the allegations.
I didn't know before, but now I do.
I would like a specific ruling that a witness cannot testify to the prior incident that was investigated of Mr. Red, that's not relevant to this and was unfounded. And then after the fact, how Mr. Red left his employment. Both of those facts and circumstances that the witness might testify to are extremely prejudicial and 404B.
Yeah, well, they do sound irrelevant. I do agree. And to the extent that They would be offered to show conformity with character. Of course, they wouldn't be admissible for that, although we'd have to take a look at 404A and see if they were admissible for any other legitimate purpose.
Right, and I don't anticipate the state trying to elicit those. I don't anticipate the state trying to elicit those statements. I just have participated in a witness interview with their main witnesses before, and I don't know how she will be on the stand.
That is endemic to trial practice. Okay.
Welcome to court.
All right.
Okay, so we're done with
anything
this.
Else in the way of motions in limine?
Nothing further, Your Honor.
The state wishes to address some of the defense's motions, Your Honor.
Sure.
Defense is number 3, prohibiting reference to, I'm sorry, it's number 2, prohibiting reference to Mr. Red as defendant.
Yeah.
That we'd object to that for obvious reasons.
I alluded to that too for the same reason. The same discussion we had with regard to the term assault applies there.
And I would also further add that State v. Bright does not stand for the contention that Mr. Red can't be referred to as the defendant. He's referred to the defendant in the verdict form. So it's an appropriate title given the circumstances. I would ask that number 6 apply to all witnesses, not just Ms. Duplessis.
Yeah, that's a good example of what I was talking about initially, where it's really difficult to have a preliminary ruling on something like that because it's heavily dependent on what the witness actually says in the circumstances. And so if this witness were to do this, then you would deal with that with an objection. We would just, in the normal course of the trial, address it. Maybe even take, if it were to be that extreme, take a moment to kind of caution the witness about how they need to answer questions.
In similarly, number 7, I think would apply to the defendant as well. Defendant elects to take the stand. I think defense anticipates that Ms. Duplessis may want to testify about her child who has special needs. That similarly, the defendant in his interview with law enforcement indicated that he cares for a child that has some special assistance needs. I think that would equally apply under the defense's request here.
Yeah, I mean, none of it sounds relevant at all.
Agreed.
Unless I'm missing something.
Your Honor, I don't think many of these things in motions have relevance. I think we were looking for some preliminary ruling so that way we can avoid them accidentally coming in, because once that bell is rung, lots of juries can't unring it.
We'd object to number 11.
Yeah, any custodial statements that are subject to constitutional protection should have been determined prior to today. This is really a good example of what is not a motion in limine.
Right, Your Honor. We would just ask that, and I will go through and point out what sections that defense feels are not admissible of that hour and 15-minute video. But we'd ask that the court go through those before the whole video is admitted to the jury.
Obviously, there's some exceptions to number 12. There's exception to hearsay rules and Crawford.
Confrontation and hearsay. But again, you would make these as contemporaneous objections.
Yes, Your Honor. Obviously, the state would object to 15. I think we've already discussed that, though. I just want to make the record clear.
Yeah, and I know what this one is. I saw this come up several years ago, and now it sort of always comes up. And at one point, there was a notion that police officers could be trained to detect lies and then testify about that. And that of course is not allowed. That commenting about the veracity of another witness is just not allowed.
Okay. Number 17, we'd ask that it applies to all parties.
Yeah, that's something you got to watch yourselves on, especially since I think for both of you, this is your first trial, right? So, I mean, it's just it's a good thing for your own trial practice to
two brand new attorneys again.
Phrasing your arguments, especially to the jury in terms of, I believe, or I think that's just something your own personal training it's good to keep in mind and to avoid. You'll draw objections from that sort of thing. And at some point, that sort of thing can actually be error. Okay. Anything else, Mr. Thompson?
No, I have a kind of the blanket argument that the jury instruction or the motions limited or any pretrial rulings apply obviously to all parties. We would also object at this time to defense witness of Janelle Reardon. No statements or subject of her testimony has ever been provided to the state.
Who is she?
I have no idea, Your Honor, other than she was born on April 27th, 19. No, we'll leave it at that. Her date of birth and a telephone number.
When was she disclosed?
2 weeks ago, Your Honor. Her name was, but not the subject of her testimony. Specifically, it was articulated no statements to disclose at this time. So I'm not sure who she is or what her purpose of her testimony would be.
Welcome, uncivilians. Kurt?
Your Honor, on
well.
Sunday, February 11th at 5:28 p.m., I emailed Mr. Thompson and CC'd Mr. Kale a interview recording with Ms. Reardon. We interviewed her that same week, so it was a quick turnaround for us as well. And I did disclose an interview recording of Ms. Reardon with myself and in my investigator. Also, Your Honor, Ms. Reardon's statements do come up in the police report. So I think that is relevant. She's the one who conducted the inspection of Miss Wood, the patient that's involved here. So I think it's extremely relevant for her to be able to say, this is the incident report and these were my findings.
Findings? You want to explain that to me?
Yes, Your Honor. So after the alleged incident, Ms. Reardon is the nurse that oversees that floor. And as part of the investigation, she did a full body inspection of the patient that was involved. She produced an incident report that is part of the police report that was provided to Defense and Discovery. She's the one who conducted it, and she gave her findings as to what evidence was left on the patient, if any. And there were no findings. So I think Ms. Reardon is very relevant for that purpose alone and being able to testify to whether or not any injuries were available or perceived on the patient. And again, a recording was provided on the 11th to counsel of Ms. Reardon's statement with defense.
Okay. All right. All right, let me process that, Mr. Thompson.
Let me process that.
That is correct. She did provide an initial record of incident, but I would not say that those are necessarily medical findings. It sounds like defense wishes to use her as a medical expert or a treating expert without having disclosed any of that until 48 hours ago, which is incredibly concerning. And while the state may have had some tangential information regarding her, obviously the state had no intention of calling her because the level of injury is not necessary for an assault 4. There can be no injury. In fact, one of the jury instructions that no injury has to occur. But so I'm not really sure how her testifying that no injury occurred is relevant. The defense still has to provide us the information, or at least the nature of her testimony, or substance, I think is the word that 4.7 uses. Regardless of whether or not we gave them that information, they still have an obligation to provide it. I don't know what they intend to call her for. I don't know if I need to send out an officer to investigate further or to get additional information. For example, was she seen by a physician later? So the defense still has an obligation to tell us that, and they had not. They confirmed a trial without conducting an interview of a witness. They confirmed a trial with a witness on their list that they had no information of what they were going to testify about until 48 hours before trial, in which I'm sorry, you said 5 o'clock on Sunday night?
That's right.
So 5 o'clock on Sunday night, they informed the state. So presumably we didn't see it till Monday. The state didn't receive said email till Monday morning.
Maybe
So
they're either really
if you're
confident
offering this witness's
or really
testimony, you
reckless.
anticipate that testimony to be that she did a exam of some kind and didn't find anything.
That's right, Your Honor. We're not asking that she's a medical expert. I think anyone can look at a human body and say, are there bruises, are there scratches?
Sure.
So, and Mr. Thompson is right that there doesn't need to be a showing of injury in an assault case, but I think that it is often relevant evidence whether or not there are injuries. Ms. Rudin looked Miss Wood over and didn't see any scratches or any evidence that she was hit or touched, and that's an aspect of the assault.
So it sounds like the city is willing to stipulate to that. So do you need a witness?
Your Honor,
I would say yes.
I do think that Ms. Rudin does have some relevant things that were provided to counsel in the recording on the 11th.
Kurt, wait till you get to
and
see
defense does have a right
jury
to
selection.
present our
We all get
case.
to watch. It's really fun. They sit back there in those chairs.
All right. Well, I see a couple of issues here. One is the late disclosure, which I don't like. I mean, I don't want anybody to be, I don't want either side ever to be confronted with witnesses or other evidence without proper notice. That's why we have the discovery rules and other rules that we have. And I don't like to encourage that kind of practice. Sometimes, though, these things come up for reasons that aren't anybody's fault. In fact, sometimes witnesses present themselves unexpectedly. So there's that. The second is having a witness testify that they didn't see anything is not really necessarily relevant. Now, it might be relevant if a witness went to examine something where a result would be expected to be seen and its absence is probative of something. But is this a case like that? When there's no need, for example, for the state to prove any, or the city to prove any level of injury or, damage or anything like that. It would be a different matter if, for example, this were a charge like assault in the first degree, where grievous bodily injury would need to be proved. And if a witness examined somebody and found no injuries or damage, that would certainly be relevant. So here, you're going to offer a witness at this sort of late stage who's going to confirm what everybody apparently already agrees to, which is that there aren't any injuries. And this isn't a situation where the events would lead a reasonable person to believe that there would be an injury.
You're right. I do believe the events would lead, at least as I anticipate them to come out, an individual to think that there was an injury. There's allegations of slapping, hitting. If those things happened, typically there's a mark. And I think that being able to present that there was no mark weighs on the veracity of a witness's statement and whether or not that event happened.
But nobody's, correct me if I'm wrong here, but nobody's claiming that there was a mark or an injury.
To the best of my knowledge, no, Your Honor.
And it's not needed to be proved. In other words, the presence or absence of that isn't something that has to be proved in this case. I mean, it's one thing if the allegation is, for example, that the defendant put a knife through somebody's skin, right? And then an examination by a medical person,
we call that
showed
perforate,
that there was no puncturing of the skin. Certainly, highly relevant, right?
Ms. Reardon gives us the opportunity to, because I don't know who else would, to show that there were no injuries after the fact. Ms. Reardon's the only one who talked to Ms. Wood.
What
so
about Ms.
that
Wood? Is Ms. Wood testifying?
No, Your Honor. She has significant, she wouldn't be deemed competent to testify, Your Honor.
So Ms. Reardon's the only individual that we can use to say that there were no injuries. And I think if there are marks and there are allegations of hitting and slapping, it makes it more likely or not that that happened if there are injuries.
Stephen, did you learn from your mistake?
All right, Mr. Thompson, I'll give you the last word.
I think the only thing that I have beyond what I've already stated, Your Honor, and I think what the court has already alluded to is the relevancy of this is what's relevant to this part of the conversation is the defense anticipated defense that they provided to the state is not exclusively general denial. They also included self-defense. So the state's, I guess, unclear of if they want to have someone testify about no marks on the victim, which again is not an element of a crime. It's not relevant, makes no fact more or less true. Why would that witness need to testify if you're claiming self-defense? Because self-defense is you're already stipulating that an assault has happened. It's the nature of a self-defense. You're agreeing that your client assaulted somebody. However, that assault was pursuant to self-defense. So I'll leave it at that at this point, Your Honor.
Well, I don't want to deny someone the right to present a defense. That's a major issue to be considered. But here, I'm relatively certain that this wouldn't be relevant evidence. I mean, I could be persuaded and I could change my mind depending on what the exact allegations of assault were, or how that comes out. But it's not necessary for the city to prove any injuries, marks, damage, anything like that. There's no contention that they were present. So testimony that they were not present wouldn't disprove anything either. And then when you couple that with this late disclosure, which I really don't want to encourage anybody, any side, I think it's,
Your Honor, if I may.
At this point, I don't see that Ms. Reardon's testimony is relevant to any issue.
If I may, even if we were to preclude the recording, which is considered a late disclosure, the things that were in the police report have been there all along. Both parties have known about that. I think that Ms. Reardon's testimony may become relevant depending on the severity of the allegations that come out on the stand.
That's what I mean by being willing to be persuaded, because if the actual testimony as to what constituted the assault was acts that a reasonable person would believe would produce marks or damage, then evidence that the person upon examination didn't have them.
I'm worried if they're going to be Zoom bombed. That's not the worst thing that could be put up on the screen.
That sounds to me that that's not what the city's offering.
Do they have a public Zoom that people are joining? Oh my goodness.
Your Honor, I do think that it would also be relevant to
I've got a
the
cutaway shot just in case. I'm going to keep my hand.
aspect of reasonable use of force.
So
The amount of force someone responds with is.
So let me paraphrase and you tell me if I'm wrong, because I think Mr. Thompson alluded to this, that if there's any claim of self-defense, does it come up in the context of alleging that Ms. Wood, is that her name?
Correct.
Was aggressive against the defendant and he responded with physical force?
That's correct, Your Honor. And I think that the absence of injuries would show that the force responded with would be reasonable.
I'm just trying to see what that picture was.
All right. What do you think of that, Mr. Thompson?
To a degree, I don't disagree with Ms. Capone.
Then could we do this? Can we do this? If Ms. Reardon's going to testify, can we keep it focused and narrow in the sense that she could testify, who she is, of course, what her role is, and then that she looked at Ms. Wood, if I'm saying her name right.
Wood is a tough one to pronounce, Judge.
Pursuant to that, didn't find any cuts, bruises, breaks, whatever.
Yes, Your Honor, that should be fine. And then we would reserve on the issue of whether or not she could serve as an impeachment witness.
Well, like I said, I'm sensitive to the idea of interfering with someone's ability to present a defense. I don't want to do that, but clearly I can't do that. All right, if we can limit her testimony in that regard, I think that doesn't stray too far into being an unfair late disclosure and surprise on the
I've got a screen grab of Mr. Noah Neal.
It's not ideal.
We'll leave this going. This was just back a little bit. Hang on just one second.
I think it will take
minimum time and it's minimum subject matter.
Does look like a bathroom selfie.
And these things that we're going to have her testifying to, these facts have been in discovery this whole time. These are not anything to do with the recording. This would be to that incident report that's been in discovery this whole time. This doesn't have anything to do with a late disclosure, in my opinion.
Well, this seems like a fairly balanced way to deal with this. But I don't want to go off and have her testifying about other matters, or if there's something more in-depth medically speaking than what I'm anticipating here, that's a different matter as well.
Understood.
Makes sense, Mr. Thompson?
Yes, Your Honor. And then I have one last objection to defense witness Deshauna Sinclair. Based off Ms. Capone's statement that Deshauna Sinclair did not medically review the victim, I'm unsure of the purpose of her testimony. I have this, I was given a recording of her interview and we fairly well summarized it. I don't believe she has personal knowledge of any fact relevant to this trial. My understanding is she has character evidence of both the initial complaining witness and the defendant, but that's the limit of my understanding of her testimony, which is character evidence.
Okay. Ms. Capone, you're going to have to fill me in about Deshauna Sinclair.
That's right, Your Honor. So Ms. Sinclair has worked with Mr. Red, Ms. Wood, and Ms. Duplessis. I believe that it's proper for a witness to be able to testify to the reputation of truthfulness. And I believe Ms. Sinclair is qualified to testify to the reputation for truthfulness of Ms. Duplessis. I also think it's relevant here since there is a lawful use of force disclosure that was made and potential instruction that she be able to testify to Ms. Wood's conduct and behavior regarding her propensity or her being difficult to work with and potentially violent.
So what's the basis of her knowledge?
She worked at the facility.
She's another employee at the facility.
That's correct.
In what role?
She was I think an aide, a nursing aide. The same position, I believe, as Mr. Red and Ms. Duplessis.
Okay, and your proposal is to have her testify as to reputation for truthfulness?
That's correct.
In the workplace?
Yes.
All right, Mr. Thompson?
The state finds it hard to believe that she understands the state's witness's reputation for truthfulness, considering the incident in question happened on the witness's first day.
Miss Sinclair's first day?
No, I mispronounce her name every single time. Duplessis.
Oh.
Miss Duplessis's first day at the facility, and she no longer works there. And so how her reputation for truthfulness in the community could be perceived by Miss Sinclair. At the time, Miss Sinclair did not hold any sort of professional medical license at the time of this incident. She has subsequently obtained one. I think it was last September. So how her reputation, how she understands the reputation for truthfulness. And my understanding from the nature of her interview with defense counsel that was provided to us, it has less to do with truthfulness and more to do with the allegation from defense that she likes to spread rumors. They're two different things.
Yeah, that isn't reputation for truthfulness.
And so the state's concern is that if we waited until this witness was on the stand asking questions, the bell is going to get rung and it can't be unrung.
And is there any other purpose you want to offer her testimony for besides testifying about various people's reputation for truthfulness?
Miss Woods, I believe because there has been a disclosure that we intend to use a lawful use of force instruction, or we're hoping to. I think it is very relevant that Miss Wood had conduct that was potentially violent or extreme that would inform the way that Mr. Red lawfully may have used force. I think that his experience working with Miss Wood is relevant.
And Your Honor, the defendant would have to know that stuff, not the witness. If the defendant would have to know about any propensity for violence, and he would have to testify that he knew about that prior to defending himself.
Not only know it, he would have to experience it. Just the knowledge about a reputation for being difficult, whatever doesn't even mean anything unless in the actual event something happened that would justify the use of force.
If we can get through this, we're going to be watching the jury selection, which is always a
Reputation
blast.
for truthfulness. I always am concerned about that because that really tends to intrude into the province of the jury. The other thing, it's always questionable whether the person really is objectively relaying a community reputation for truthfulness or just their own opinion on somebody, whether or not they like them or prefer them. Their opinion about their reputation for truthfulness is invariably colored by things like that. And then the witness's own basis of knowledge, which here sounds pretty thin. I'm struggling with how much good Miss Sinclair is really going to do. How important testimony like that could possibly be in determining the issues in this case.
Everyone's buffering. They're thinking.
Your Honor, as to a potential issue of Ms. Wood being a first aggressor, it seems like in State v. Adamo, the victim's character need not have been known to the defendant to be admissible on the issue as to who was the first aggressor.
Case law.
So I think that it is relevant, one, to whether or not Ms. Wood was potentially the first aggressor in this instance. And I also think it is relevant to what Donnie would have known at the time. And that would have informed his use of force.
She's been hitting the books.
If he did.
Which again, the state would put to the court, has to come from him. The defense cannot introduce someone else's as a witness to testify as to what the defendant said. That is not party opponent.
I think this is a dangerous case to get him up on the stand to testify in.
But aren't you talking about reputation for truthfulness?
Oh, I was saying as to the issue of being able to testify to Betty's or Miss Wood's reputation. As to truthfulness, I think that it is relevant. The state's case hinges on whether or not the one witness there is being honest. As far as the workplace goes, it sounds like Miss Sinclair has worked closely with Miss Duplessis and can say whether or not at her employment that she was honest. She was there for a month or two, and I have reason to believe that she would make things up and lie to get out of work. And if that is true, I think it makes it more likely that she is being dishonest here if she was dishonest in other instances. And we're not offering it for specific instances, but I'm saying.
This sounds like collateral issues to me.
Your Honor, the state's case hinges on whether or not this happened, and the only person that they have to present that is Ms. Duplessis.
So they have a witness, and they presumably have circumstantial evidence and inferences. That's what all cases are like. The determination of cases doesn't come down to sorting out the reputation in the community for truthfulness.
If Ms. Duplessis is untruthful, then that makes her account less likely to have happened.
Right, and that's the sort of thing that would come out in cross-examination, not by reference to an external standard, which is another coworker who says her reputation for truthfulness is good or bad, which would be the limit of that allowable testimony under that rule.
Understood.
And I think the court's already gotten to where the state was going to, or city was going to articulate, which is that's one coworker's opinion about the city's witness. And while I think the witness might try to couch as well, her reputation at the facility was blah.
Alicia, thank you for the gifted membership.
Pretty clear from the state's understanding of the recording, and obviously I don't want to get too far into the collateral aspect here, but that this was Miss Sinclair's opinion, not her conclusion of her reputation.
Yeah, and that's what I'm concerned about, because the jury is going to have to listen to the witnesses and evaluate the evidence and make a determination as to how persuaded they are by any of this. And having another person from the workplace take the stand and say this person's reputation for truthfulness is collateral. In fact, and it's also a kind of thing that I think to a large degree needs to be avoided, because it is the jury's obligation to make those determinations about veracity based on evidence, not based on reputation. And I mean, from what I'm hearing, Ms. Sinclair's basis of knowledge is probably pretty thin if she was a short-term employee there.
Your Honor, Ms. Sinclair wasn't short-term. It was, but I will say
her familiarity would be based on a short amount of time.
I will say I disagree. I do think it is relevant, and I think that she should be able to testify to character for truthfulness. But even if that's not admissible, I do believe Ms. Sinclair's testimony should still be admitted on the basis of whether or not Betty was the first aggressor and whether or not Ms. Wood had a reputation for being violent.
Now it's just the late disclosure issue.
I don't agree about the reputation for truthfulness or untruthfulness. And like I said, I don't want the collateral issue to dominate the case. I think that it's important that the case be decided on the testimony of witnesses with knowledge, with personal knowledge, and expert, if there are any experts, and the other evidence in the case. Under these circumstances, reputation for truthfulness would have minimal to no probative value, and I don't think it's admissible.
And Your Honor, I'm asking you to rule on a different basis of admissibility as well.
For the alleged victim's propensity for violence?
Yes, Your Honor. So, Mr. Red doesn't have to have personal knowledge of conduct.
Tell me, as an offer of proof, what Ms. Sinclair knows about the Ms. Wood. What is the basis of her knowledge?
Ms. Sinclair has worked with Ms. Wood.
Okay.
She's a resident
for
of the
what
facility.
period of time and in what capacity?
As a caregiver to Ms. Wood.
For what period of time?
I'd have to get the specifics. I know it was probably, Mr. Red says 4 months.
So potentially around 4 months. And then what will she say?
She can testify to the fact that when she worked with Ms. Wood would kick, bite, scratch, hit, slap. That kind of information is relevant because if that's what Ms. Wood did when people worked with her, then that makes it more or less likely that she was the initial aggressor.
Mr. Thompson?
Frankly, I don't remember if she ever talked about that in her interview with defense counsel that's recorded. So I'm not sure the state was aware that such information would be put forth, but I don't believe Miss Sinclair had the same employment position as either the defendant or the state's witness. And I'm not sure about her level of knowledge being sufficient for this testimony. I think at best, at this point, the state would need to ascertain that from her prior to her taking the stand, or at least a proffer be provided to this court prior to her testifying in front of the jury about any of that. Like I said, at the time of the incident, Miss Sinclair was not a medical professional. She has since become one, but she's been one for approximately 4 months.
Your Honor, I don't think someone needs to be a medical professional to say whether or not they were bitten, scratched, slapped, or punched.
No, but a prior incident or a prior transaction between, say, Miss Sinclair and Miss Woods, by itself isn't really relevant about the subject transaction that led to the criminal charges here between the defendant and Miss Woods. Those two events are just entirely separate and different, unless you established that there's a connection in the sense of a reputation for violence.
If they don't get this witness in, they'll have to put the defendants on the stand.
I also think it's important that we distinguish behavior after the fact, because she is a dementia patient with diminishing returns. She very well could have become more violent after the fact without having a propensity for violence at the time. I think that's an important distinction here. So if Miss Sinclair has had interactions since this incident, I don't think those are relevant because they don't talk about her reputation at the time. They talk about what she is now, which is different.
Yeah, I mean, I understand that distinction too. That's something I hadn't thought of, and I wasn't even aware that there was that much time difference between these issues. But what I was getting at before was Miss Sinclair having had her own, interactions with Miss Woods doesn't translate in the ability to directly, without more, to the ability to just say that Miss Woods has a reputation for being violent towards people, right? There's got to be a basis for reputation in the community for propensity for violence.
Right.
So I worked with her, and when I did X and Y, she was violent, she struggled, she lashed out, whatever. It doesn't mean anything by itself. So make the connection for me between what she knew and experienced as a result of her employment.
We're about to get our
to the reputation of this victim,
our bathroom viewer back
for violence.
Your Honor, it's my understanding that Ms. Sinclair worked closely with Ms. Wood to the potential frequency as how Mr. Red worked with Ms. Wood. Mr. Red trained Ms. Sinclair. They both worked with Ms. Wood on multiple occasions, and if it is consistently the case that Ms. Wood lashes out, I think it makes it more relevant. It makes it more likely that she was the first aggressor, and that Mr. Red's account that may come in through the video is accurate. And if Your Honor wants to potentially have Ms. Sinclair testify without the jury present to see what that testimony might look like maybe that would be.
Well, I think at a minimum, we're talking about that. I mean, before I would let her go into that kind of material in front of the jury, it would have to be established that there is a sufficient basis to allow her to offer an opinion testimony like that.
And Your Honor, if this court doesn't think that Ms. Sinclair is a good fit, I think that Ms. Reardon would maybe be a good fit to make that statement too. She was the floor manager at the time. She should know the residents better than anybody else.
You were going to say, Mr. Thompson?
Well, I was going to point out that Ms. Capone just indicated specific instances, not reputation, that Ms. Sinclair would testify about. That's her experiences with this particular person, not reputation. I don't disagree that Ms. Reardon would probably be a more appropriate fit to testify to such information. However, none of that was disclosed either to the state. And I don't know if defense counsel knows that she can testify to that.
Yeah, that does kind of sound like a theory that kind of came up here as we were discussing it, rather than a trial strategy that was put together in advance.
I mean, Your Honor, in having conducted and been present for both interviews, I do think both witnesses would be a good fit for that. Mr. Thompson does have the recording that provided, albeit late, was provided. And I don't think that the remedy for a late disclosure is a complete exclusion of that information or that testimony. I believe it's a continuance.
Yeah, it may be, but only if it's going to be admissible anyway, which I'm not convinced of yet. Yeah, like I said, this case isn't going to be decided by, reference to external people who are going to vouch and say, this person has a reputation for telling the truth or not telling the truth. And, this person has a reputation for being a violent and aggressive person. That those may be attractive areas to go to and attempt to establish in evidence, but those are collateral issues, generally speaking, especially the individual facts or transactions are collateral issues. And you can quickly have a trial that becomes about that as opposed to about the incident that's the subject of this case. And I'm going to prevent it from going that direction. We're not going to go very far down that collateral direction on any of those issues. And I'm again concerned about taking, essentially taking away from the jury their responsibility here for making those determinations about witness veracity.
He'll be back.
We cannot substitute reputation evidence for that.
Your Honor, I would just reiterate that I do think that it is reputation for violence is relevant as to whether or not Ms. Wood was the first aggressor.
Yeah, I agree. It might be, especially because I didn't know this in the beginning, that Ms. Woods was a dementia patient, and not everybody fully appreciates how a dementia patient may act. In other words, that their actions and reactions might be, completely irrational and not proportionate to stimuli, things like that. I mean, an explanation for why a dementia patient might behave the way they do in a specific circumstance could be important information.
I think he's a defendant that Mrs. Rowe was representing in another matter.
Ms. Woods was a person who did not suffer from dementia, then her actions would have entirely different meaning. I get that. So to the extent you want to, provide information to the jury that she's a dementia patient and her behavior has to be explained in those terms, then I think it's appropriate for you to do that. But classifying that as, reputation, or propensity for truthfulness or not I don't think that's the appropriate way to do it. I mean, I think anyone can understand if it's explained to them that a dementia patient behaves differently than someone who doesn't suffer from dementia, and that they may in fact be physical or aggressive. That isn't the same thing as a reputation. That's a medical condition.
And to be clear, Your Honor, I may have misspoke. It might be Alzheimer's, but she has some sort of obviously degenerative brain issue.
Yeah, you said she wouldn't be competent to testify.
Yes.
But I mean, does that distinction make some sense to you?
Yes, Your Honor. At this point, I'm not offering for truthfulness. It is really whether or not her reputation made her more likely to have been the first aggressor. That would be what we would want to offer that testimony for.
Yeah, in the overall context of this, it seems like you're maybe doing more work than you need to do. I mean, shoehorning all of that into the sort of pre-existing category about reputation and propensity for violence is probably not even necessary if what you're really doing is trying to say to the jury, this person behaved the way they did under these circumstances because of their mental condition, their dementia, where you might not expect a person who didn't suffer from dementia to behave that way. That it would be unreasonable. It would be interpreted as
we're a couple minutes behind,
aggression.
And I'm going to speed this up just a little bit.
If she were not suffering from dementia, her actions have a different meaning than if she is suffering from dementia.
Right.
Yeah. So it's a little bit troubling to cast her as, if you're offering evidence so that another person can testify that Ms. Woods has a reputation for violence. I don't think that's really what you're trying to do. I don't really think you need to do that. If you have instead medical people or people who are responsible for the care of dementia patients who can tell you they behave like this.
I think in real time they're in a break. We're just trying to catch up.
Without the ability of either witness to testify to that, my concern is that Ms. Duplessis would get on the stand and frame Ms. Wood's conduct as not typical as her trying to fight Mr. Red because of his conduct. I think the way Mr. Red handled the situation is relevant to whether or not is what he knew about Ms. Wood at the time. And I think that being able to explain that this was conduct that was normal for Ms. Wood makes her more likely to have been the initial aggressor, and it would negate anything that the state's witness had to say about that not being normal for Ms. Wood, because she wouldn't know it was her first day.
Judge is not going to allow it in. I think he's made up his mind. He's mulling it over.
So your witness is, what, remind me her name again?
Reagan and Duplessis.
Duplessis. Okay. You going to offer anything in her testimony besides just direct evidence of the senses?
Arguably her training and experience, and potentially in something to the effect of in the nursing profession, was this conduct permitted or something to that effect? Yeah, is appropriate. You know, what sort of actions are you treated or taught as a nurse to do? Potentially that.
Defense witnesses may have information on that subject matter as well.
I would agree with that. Miss Reardon arguably could testify similar to that. She has, I think, would consider sufficient experience. I would not agree that Miss Sinclair has sufficient experience. She's had her license, like I said, approximately 4 months. She does not have
obtained after these events.
Correct.
And Your Honor, I would just reiterate my concern of going into policies, practices, and what it should and should not be done. I fear that the jury will substitute what should and should not be done in certain situations as the standard when they should be analyzing it under the criminal law.
To be clear, Your Honor, the state intends to introduce that because defense has claimed self-defense. And one of the instructions is what a reasonable person would do in a similar situation. That means what would a reasonable person, being a nurse assisting a Alzheimer or dementia patient, do in a similar situation, not what I would do as an attorney.
Yeah, I understand that.
So that is why the state intends to introduce that information. Defense has put the state on notice that they intended to use self-defense. So we intend to introduce that as the state's obligation to affirmatively disprove self-defense. Now, if defense is withdrawing that, I don't believe it's necessary to articulate that, but that would also preclude defense from arguing that what his behavior was done is appropriate in the field.
Yeah, I don't think they're withdrawing that. And I don't, you correct me if I'm wrong, but I also don't think that the fact that Ms. Woods is a dementia patient would interfere with defense's ability to claim self-defense.
I agree.
But explaining the circumstances in light of the information about this alleged victim being a dementia patient is, that's important. I agree that the witnesses who have sufficient training and experience in, what dementia patients are like can certainly testify about that. There might be differing interpretations about what that means, but certainly the person has to be understood in that regard. The alleged victim has to be understood in that regard. But if, for example, Ms. Sinclair doesn't have that level of experience and training, then she shouldn't be allowed to testify in the form of an opinion. She should be able to testify as to what she saw, what she heard, and so forth, but not to offer an opinion as to whether that would be typical of a dementia patient like Ms. Woods.
And to be clear, Your Honor, she has no personal knowledge as far as the state knows. She was not present at the time of the incident.
Okay, so that would, again, minimize what she would have to offer in this case.
I think that she can offer reputation for violence, and that makes it more or less likely that Ms. Wood was the primary aggressor. We're not asking that she be brought here to talk about policies and procedures and practice. In fact, it's our contention that shouldn't be discussed at all. Whether or not an assault occurred has nothing to do with what the CNA world or what the Hampton would like people to do, and whether or not force was reasonable.
We already covered that.
But I think that was the topic of Mr. Thompson's concern.
No, that has everything to do with self-defense, though.
Yeah.
Because it's what a reasonable person would do in that situation. That includes people in that profession in that situation. They're the standard, not what a Joe person, a random Joe off the street would do. It's what a nurse would do in that situation.
Yeah. Yes, and also he's entitled to behave as a reasonable person as well, because one of the reasons that self-defense exists is for a person to be able to prevent harm to themselves under those circumstances. And that's true regardless of why the person may be attacking them. So, the policy behind a self-defense law goes beyond just expecting someone to use proper judgment for a professional. And it'd be the same thing with law enforcement. They have their training experience, their background, et cetera, but they're as entitled as anyone else to defend themselves, to prevent themselves from being harmed.
And Your Honor, this is not a malpractice case. So that's another reason I don't want the jury to hold Mr. Red to a standard that maybe the CNA world does or the Hampton would. This is self-defense of his person.
Yeah, agreed. And I'm not going to allow the trial to go down that path for sure. But, we still are talking about whether or not these other witnesses that you're offering can offer anything relevant and useful to the jury.
I mean, I think Ms. Reardon, as we discussed before, can testify to whether or not she can testify to the incident report that's in the police report. And if the state does not want it, or it's not admissible to hear from Ms. Sinclair, then I think Ms. Reardon is also qualified to talk about Ms. Wood's conduct and her reputation for violence, which is relevant to whether or not Ms. Wood was the first aggressor. I think Ms. Sinclair also has sufficient basis, knowledge, and experience to be able to testify to Ms. Wood's conduct in similar circumstances, not specific instances, but reputation generally, which makes it more likely that Ms. Wood was the initial aggressor.
Yeah, and it sounds to me like if that were to happen, especially if Ms. Reardon were to testify about that, it would be in the context of Ms. Woods' status as a dementia patient. In other words, unlike a person who is, violent and aggressive because it's the personality of that person.
We're not asking her to weigh in on medical information, just lay observations. What was Ms. Wood like at that time? It's collateral. I mean, her Alzheimer's or dementia obviously caused that condition, but we're not asking people to have a medical opinion or present a medical, it's simply observations and experience working with her.
I understand what you're saying. All right.
To be clear, Your Honor, I don't think the state can, from the state's perspective, it doesn't seem like you can necessarily separate the two. Like, while I understand that the state wholeheartedly objects to Ms. Sinclair testifying at all, that Ms. Reardon testifying about Ms. Wood's reputation at the facility, arguably the only objection the state has to that is the late disclosure of it. I think she's sufficiently qualified to testify about it with sufficient amount of experience to testify about it. However, I think to not contextualize it would be similar to the state introducing half of a sentence of a defendant's statement without introducing the end of the sentence. There has to be context to such a statement. I think the context being Ms. Wood's at our facility because she has the following diagnosis. It's perfectly permissible from the state's perspective. I think she also has I think you described her as the nursing supervisor for the floor, would have more than a sufficient basis of knowledge to make such a statement.
And then it sounds like we've already sort of discussed this, but Ms. Sinclair doesn't have that same basis of knowledge. And in any event, if she were to testify about the same subject matter, that reputation, that would be cumulative to Ms. Reardon anyway.
Correct.
Then, Your Honor, if the court is inclined to exclude Ms. Sinclair's testimony, we would ask that Ms. Reardon be able to present that testimony. Absent, the objection over the late disclosure, as I previously stated, exclusion would not be the remedy for that, would be continuance. So we would ask that information be able to come through Ms. Reardon, who also has experience working with Ms. Wood. And I don't think that Ms. Wood's diagnosis is all that relevant to whether or not she was more likely to be the initial aggressor. I understand that it's caused her. I agree with you there. I understand that it's caused her to be the way she is. But at the end of the day, if she swings on people, then she swings on people.
Right. Yeah, you're not wrong, but the context is important. It sounds like Ms. Reardon can get you there. Yeah.
Then we would ask that Ms. Reardon be permitted to testify to that.
Yeah, and like I said before, as long as we aren't going to be going too far down the road on these collateral issues, if you wanted to establish, what Ms. Woods is like in the facility, that she has a basis for her knowledge of that.
This is not SA.
Sounds like she can also maybe, given her profession, give some information that generally about past behavior being consistent with dementia patient. Then I think that is fine.
Who was that in the bathroom with him?
I don't think any more than that is necessary or relevant. And I think that gives the state or the city the opportunity to cross-examine her as to any of those qualifications or basis of knowledge, without that being too much of a disadvantage for the late disclosure.
Is he in like a holding
cell? Can we keep Ms. Reardon's testimony within those confines?
I believe so, yeah.
Right. So you know what you're dealing with.
You know what you're dealing with.
Yeah.
All right.
Ms. Sinclair. Okay. I think Ms. Rowe has been waiting to get her client's case heard this whole time.
Ms. Rowe has been.
Your Honor, with that, we could recess this matter until after lunch, I believe. That way, counsel and the client don't need to stick around.
And before we go, I do anticipate you each delivering opening statements today after we select the jury. Mr. Thompson and I have discussed that before, but you haven't been here with me before. From a time management point of view, and for the sake of you all being able to present both of your cases in front of the jury tomorrow, I think that's the way we need to do it. Okay. Let me know if anything else.
Commissioner Will knows that it's not my personal preference.
I understand that.
But yes.
But we only have so much time. So
Mathis says, that's why I don't buy Apple. You want peace, and then your smart toilet locks you into a Zoom call when you're doing business before.
It's like you have a little bit more floor time until Miss Rowe comes back if you have anything else.
These two attorneys, they're brand new. This is their first trial each, both prosecution and defense. Both of them have backup second chair. In the case of the prosecution, Mr. Thompson, I believe his name is, we've seen him before. He's a bigwig. He knows his way around there. He was arguing all the motion in limine stuff, but the defense side, the new girl, the new attorney, handled everything, and with no input whatsoever that I could see from her second chair, which is awesome. So she's very capable. We'll see how prosecution does on that and how much Mr. Thompson has to prompt. We've seen varying degrees of readiness from new lawyers in Thurston. We do like watching new attorneys, though. So I don't know why he's connecting from the bathroom, but that is Miss Rowe's client, and Miss Rowe's going to be joining us here shortly. Let me see if I can skip ahead to where she is. Let's see. We're going to skip ahead. She takes, oh, there we go. Right there.
Office upstairs. You just let us know that so we don't walk in on you.
You ready to dive in with Mr. Neal?
I am, and he's been so patient. Thank you so much for Mr. Neal. I appreciate that.
All right, so Mr. Neal is here today for a disposition on his matters 2A 203 257 and 258. Ms. Rowe, I know you've been over an SOC agreement with Mr. Neal. You want to put that on the record?
Yes, Your Honor. Mr. Neal and I have reviewed the entire SOC form. Mr. Neal understands that this is an agreement between he and the state. The agreement is that the state will continue his case for 2 years, 24 months. He understands he's entering into this stipulated order of continuance on 1 count of assault 4. In exchange for entering into this agreement, the state will be dismissing the 2nd count of obstruction and the driving while license suspended case. Mr. Neal understands that entering into this agreement is a opportunity for him to ultimately have this case dismissed. We've reviewed the conditions that he has to complete and abide by during the next 2 years. Those conditions are that he commit no new law violations, that he not drive without valid license and insurance, that he abide by the existing no contact order, and that he participate in and show proof of an 8-hour online anger management class. Mr. Neal also understands that by entering into this agreement, he is at the same time giving up his right to take his case to a jury trial. We have reviewed every one of those rights that would attach had he gone to trial, and he is knowingly, voluntarily, and willingly giving up those rights to take advantage of this agreement. He also understands that were he to violate the conditions of this agreement, then the state would set a hearing, and at that hearing, the court would determine whether or not a violation has occurred or not. If the court determines that a violation has occurred, then he would be left with a stipulated facts trial on this charge. He understands that the stipulated facts trial would consist of the court simply reading the police report and the statements attached and decide whether he is guilty or innocent of that charge. He stipulates to the admissibility of those materials, and he is agreeing to keep the court apprised of any change of address during the next 2 years. He understands that if he does complete all of these conditions, and then at the end of the 2-year period, this case will be dismissed. I believe he is entering into this agreement freely, voluntarily, and knowingly, and we are asking the court to accept this agreement. Thank you, and we are ready to proceed.
Okay. All right, Mr. Neal, did you hear all that?
Yes, sir.
All right, Ms. Rowe made several representations to me about your level of understanding about the rights involved here and the rights that you give up in order to take advantage of this agreement with the prosecutor. Is all of that accurate as far as you're concerned?
Yes, sir.
All right, and do you have any last minute questions for me about how this works or what rights you do give up?
No, sir.
Okay, so your case will be continued. Case number 258 will be continued for the next 24 months on the conditions that were outlined by Ms. Rowe and that are written in this agreement. You comply with the conditions. At the end of the 2 years, the prosecutor will dismiss the assault charge. The charge of obstructing under 257 will be dismissed now. And then, Ms. Rowe, I believe you were referring to 3A 802167, which is a state case, driving while suspended 3rd degree. Was it the state's intention to dismiss that charge as well?
It is, Your Honor.
Okay, and that driving while suspended charge is dismissed as well.
And, Your Honor, it was the state's intention to also dismiss the tracking infraction of 3A 802168. So we would ask that that be dismissed also. I am able to represent to the court that Mr. Neal has passed the written part of his driving test. He's looking forward to passing the driving portion. Mr. Neal also is assuring the court that he actually has not been driving, has been obeying the orders of the court. I think Mr. Neal has turned a new leaf and is committed to going forth and obeying all of the court's orders. So I just wanted to let the court know that he is working on getting licensed.
All right, well, good job there, Mr. Neal. It sounds like you're doing it right.
Thank you.
Okay, so then the state's motion to dismiss for the infraction as well. Looks like those two got separated in a finding committed was entered. So just reverse that finding of committed and dismiss that infraction. Okay, Mr. Neal, unless you have any questions for me, you're good to go.
No, sir. I appreciate you guys. Thank you.
All right. You take care, Mr. Neal.
Thanks, Mr. Neal. Thanks for your patience, Your Honor.
Yeah, you as well, Ms. Rao.
Bye.
Okay.
Mr. Neal is going to try to turn off his camera before he picks it up and shows the rest of the background. No, just kidding. They're done. They're done. They're done until after lunch. And let's see. It is 2:16. We have a dilemma. We have a dilemma. Ready? Let me share my dilemma with you. Oops.
Oh, okay.
I don't want Judge Boyd right now. Sorry, Judge Boyd. My apologies. We have a couple things. There was a fun video, a fun exchange we'd like to watch with Judge Simpson, and I don't think that's very long. I have to edit this video for my son and get it on the internet so people can vote on it and let him win. And I don't know who won. And my kids actually for one of my children's birthdays have selected that they would like to spend time with their dad at a trampoline park, which I think is like an invitation for injury is what it is. So we're going in a little less than 2 hours to go. Are we able to vote on your son's video? Yes, Ashley, but it requires you to log in, create an account, which is free on the piano website. But if you guys wanted to vote on his video, I would tell you he would win because it doesn't get a lot of traffic over on that website. I'll at least get you a link so you can watch it. How about that? I'm not going to tell you have to vote for it. I don't know. Is it fair for me to say go vote for my son's video? Okay, let me finish the video because I've got a little. I showed you a little bit, right? I showed you just this part.
Of the safety.
Oops, I don't want that part. I need camera 8 instead. Here we go. There. I showed you just a tiny bit of the video, which is right here. Where's that play button? Right there. I need audio. Show me audio. Anyway, so that's him playing. I'm really proud of him. He does a great job. But I shot using, obviously I use 3 cameras and I'm layering things and using effects and things so you get this mood. So it's not just plain, it would look bad if it was just a one shot. So anyway, so I have to finish the editing on that part. And it's a beautiful song. I think it's actually a video game song. He did not write that. He's written some other ones, but this one is someone else's piece. So I'll finish the editing there, and we'll share a link. Let's see. I forgot what I was saying. I completely forgot. He doesn't need our votes to win. He is up against a guy who's playing like Tchaikovsky's 40th whatever, and the guy's just like all over the piano. And the guy's incredible at how fast he plays the piano, but I like my son's better just because my son's is expressive, and the other guy just plays every note the same. It's very fast, but he just plays everything the same. So, anyway, we bought that keyboard for this is. Let me show you. We bought this keyboard for him. Anyway, he's clapping for syncing cameras and stuff. 3, 2, 1, clap. Yep, gets everything together. We bought that keyboard for him, or for our whole family, and he's the only one that's really taken off and playing it. I can tell you to go watch the videos and make your own choices. I have to edit and post it first. That's what I have to do. I am proud. I'm very proud of him. We're the GoPro at the trampoline park. I think I could go live. I've never been able to make it up the warped wall. Do you guys know what a warped wall is at the trampoline park? First of all, trampoline park, if you know what a trampoline is, take those and put them all over in a big warehouse. And just all next to each other, everything. And just like have a room full of trampolines. And then insert about 150 kids just running squampus, anything we want, jumping and throwing dodgeballs at each other. And then for supervision, have a couple teenagers at minimum wage, and then just have the ambulance on standby. That's basically what a trampoline park is. But can we record jury selection? I believe this is the one thing I hate about Thurston County. Every time they take a break, they stop their live feed, and I have not yet found a tool that will automatically play their live feed when it starts. If there's one out there, I will pay for it if you guys can find it. If there's a tool where it will automatically start playing a video on the live feed, that would be amazing. Any of you programmers out there who want to build a little tool, please let me know what. Anyway, so I'm that tool, says Adam. So I can record it because while I'm out like in the trampoline park, I cannot start and stop the recordings or bring in a new video to record. I've got all the gear to record everything. It's all right here. But if the judge takes a break like right before they start, then we miss the whole thing, which is no good. Trampoline park is what I call job security. That particular son, the one that plays the piano, is also a ninja warrior gymnast and coach. He coaches. That's his job. He coaches people who are trying to learn how to do those tricks where you hang by your fingertips from swinging trapezes and jump to the next one and catch and all that. That's what he likes to do. Plus, he plays the piano. It's a fun combination. All right. Let's see. I think that's it. I think we're gonna wrap up. Is that fair? I'm gonna try to get as much of. I'm gonna try to record as much of Thurston County as I can tonight. We're gonna show Judge. Let's show Judge Simpson before we go. Is that okay? I think you guys would not mind if we did that. Let's see. Judge Cedric Simpson. Okay. Let's see. We just had. I want to see how long this one was. Okay, stopped about half an hour ago. Was this a trial? We might have time for this. We might have time for this. Here we go. All right, we're gonna do it. Let's do Judge first.
Yeah.
I need to slow it down though. It's a little too fast. Oh, that's normal speed. Never mind.
Do you want one?
Yes, ma'am. Hey, Patricia. Prosecutor. Attorney Joshua Van Laan, also present.
All rise. The 14A District Court. 14A District Court, State of Michigan.
County of Washington.
Now in session. Judge J. Cedric Simpson.
The Honorable Judge J. Cedric Simpson preside.
The bailiff messed up the intro.
I don't know what happened. Don't even look at me. Just kind of lost me. All right. Let's see here. We're all on. All right. Court does call the case of the people of the state of Michigan versus John Torres.
Good afternoon, Your Honor. Patricia Reiser on behalf of the people.
Good afternoon, Judge Joshua Van Laan on behalf of Mr. Torres, who's present in your courtroom.
Can you state your name, sir?
John Torres.
All right. This is the date of the adjourned sentencing date. There was statements given by the mothers of the two young ladies to the court. They asked the court to look at additional information, which the 911 the recordings of 911 were sent to the court. The court had reviewed them. Was there anything else from either side before the court goes into its decision? Anything from the people?
No, thank you, Your Honor.
Anything from the defense?
So this is
No,
sentencing.
Judge, you've given
Right?
us ample time. Thank you.
Let me just say that, and I guess there isn't an easy way for me to say this. And I guess, I don't know, I know the mothers gave their statements at the last hearing. I don't know, was there anything additional you wanted to tell the court? No, or neither, okay. There isn't an easy way for the court to say this, except for to say that, well, first of all, and I'll give everyone another opportunity to speak after I say what I'm going to say and what the court looks at, what the court has at least surmised. The defense's position is that certainly the defendant ought to be sentenced on the charge that he pled to. Much of that, frankly, I guess bears on the concept, or at least what has been said, that the defendant, Mr. Torres, was not in a position to see the accident. And that he was someplace else, which led to the plea. And again, it's not the court's province to get involved in what the particulars of the charge are, but to try to do its best to mete out a just sentence. Part of the reason also that the court had made a determination to at least hear the 911 tapes, I have a copy of the police report as well as Mr. Torres' statements, was because I was going, and I said to the parents that there may not be anything that the court could do, but you were going to be heard by this court. And in doing that, some things, as I saw them, were a bit disturbing to me. And, you know, I'm not in, nor should I be, in a position necessarily to do some investigation to try to figure out what transpired entirely. But ultimately, the issue became, and I will make no bones about it, that if this court believed, despite the charges, that the defendant was indeed basically present when the vehicle went off the road and the accident occurred, that changes the court's perspective on what would be a proper sentence in this case. So initially, in listening to the 911 calls, particularly, there were a few other calls, but I listened to Mr. Torres' call to 911. And that initially caused me some concern about whether or not the defendant saw this accident. And here's why. And again, I will give an opportunity to respond, but Mr. Torres initially contacts 911, and what was said to the court by Mr. Torres and what he had maintained to probation is that he didn't see this accident. I'm having a very difficult time believing that. And let me explain my reasons why. Defense counsel, I think, properly stated before that that Mr. Torres had called from someplace else. Mr. Torres contacts 911, and it's an odd call because of the way that I think the dispatcher was responding to Mr. Torres. But one of the things that was said is Mr. Torres put himself at First Street off of Superior. The dispatcher says, that's not where we have you. Put a pin in that, because that becomes important in the court's mind. At some point, Mr. Torres then says, I'm at First Street. He's then headed back to the location of the initial contact between the vehicles. tag. All of that makes sense. I then review the police report and Mr. Torres' statement. And if everyone can recall, one of the things that the court was looking at was, did Mr. Torres chase these individuals and cause this accident? One of the things that was said in counter to that is that he's not near the accident, doesn't see the accident. Again, I'm having a difficult time believing that. And part of the reason I'm having a difficult time believing that is because there is an EMU security camera that's referred to in the police report that has these vehicles traveling down Huron River Drive, both at a high rate of speed, because Mr. Torres is in an equinox, I do believe, and there's a truck. At some point, they get to the corner of Huron River Drive and Superior. According to Mr. Torres, it is a red light. The truck stops. He stops at some point. The truck continues through the red light. Mr. Torres indicates from the report, at least as I read it, that he then turns on a green light. Now, how that certainly all could happen. Bottom line is that there's then, Mr. Torres indicates in the police report that at some point on Superior, he disengages from, as he puts, following the vehicle. As best the court's able to determine, the distance from that corner of Superior where the turn is made to the railroad tracks is approximately 1,000 feet. Mr. Torres is then, if he is correct, and he is saying where he is to the dispatcher, this is where we take the pen out of that he's at first, but the dispatcher is saying, that's not where we have you. Mr. Torres is further up that road. But even if I give the defendant the benefit of the doubt that as far as he went was first, the railroad tracks are approximately 100 feet from that location. It is a clear shot from that location to see those railroad tracks and that intersection. It is not as though there is a crest. It is as though there is something that from first would obstruct one's view. The other thing,
Judge has personal knowledge of this intersection.
Of Mr. Torres is he made it very clear that he did not go over the railroad tracks, but the additional thing that was asked is whether or not he crossed a bridge. Mr. Torres says he did not cross a bridge. That can't be true, because as you're going up Superior, to get to First, you have to cross the bridge. Moreover, when Mr. Torres is later questioned and talking to the dispatcher, he had to not only cross that bridge once, he had to cross it twice, because he had to go over the bridge and he had to come back to get to the location where it occurred.
Can I say something, Your Honor?
In a moment.
No.
Moreover, when you listen to the other 911 calls that are called in, two vehicles that are traveling to the south, so they're traveling the opposite direction from the Getty's roundabout. They see the vehicle go in off, well, basically off the railroad tracks and have the accident. From really, and honestly, I mean, I don't know exactly where they are, but from putting again the defendant where he says he is, they are at a much further distance from those tracks than would be Mr. Torres. He's much further. Let me preface this by saying, through the other hearings, it was stated to the court that he is nowhere near the tracks and that he is further from the tracks where this occurred. That can't be true and everything else be true. It just can't be. He is within 100 feet, really between 80 to 100 feet of that intersection when that vehicle goes off the road. Certainly. And it also is perplexing from the court standpoint. I thought I understood it initially. When Mr. Torres is telling the dispatcher that he has the license plate of the other vehicle, one is thinking, or at least I was thinking, that he is getting that license plate by following the vehicle. That's not the case. He actually had the license plate of the vehicle prior to it turning onto Superior. Hence, realistically, there is no reason whatsoever for him to have continued.
There is no reason whatsoever for him to have continued up Superior behind that truck. Now, if somebody, and counsel, I will give you an opportunity to address the court on that. And like I said, I'm not here, and I explained to Mom, it's not my province regarding the charge. My province is to mete out the sentence with what's in front of me. And again, I will give an opportunity for a response, but I can tell you where the court is at this point. The court at this point is of the opinion, and that Mr. Torres saw this happen. When he talks about the kicking up of dust and other things, the only place in that area that's going to happen is basically at those tracks. It's not going to happen on the turn off of Huron River Drive onto Superior. You're not paid. And, you know, and I'll just say it, when I look at all of this, I'm having a hard time believing that he's telling me the truth about this. So Ayden, can you just put that GPS up?
Yes, I can.
Overhead.
Here we go. We get a map.
I'll let you, if your counsel believes that you should speak, then I will let you speak, but I'm ready. Can you blow that up, or you're loud?
Enhance. Enhance
yeah,
image.
I just need it closer to the...
Recenter.
Right, yep, right there.
There we go.
At the very bottom of the screen, you're going to see the turn from Huron River Drive onto Superior. Up top of the screen, sir, you will not disrupt these proceedings. I do not want to kick you out, but you are not going to disrupt these proceedings.
Whoa.
Up at the top of the screen,
hang on. Let's go back just a minute there. Hang on.
You're going to see the turn from Huron River Drive
we don't get to see who it is.
Onto Superior. Up top of the screen, sir, you will not disrupt these proceedings. I do not want to kick you out, but you are not going to disrupt these proceedings.
It's a family member that came up to the bar, talked to the bailiff or to the judge, stayed on the other side of the swinging door, though.
Up at the top of the screen, you'll see the railroad tracks. And if you look at, I think the first, if you look down from the railroad tracks off of Superior, that first street coming off, which would be as you're looking at the screen to the left.
That's First Street.
That's First Street. From there, you can see that there is a clear shot to that intersection with the railroad tracks. If Mr. Torres is there, he has a clear shot to that whole area. When you also look at it just in terms of his timing of the calls, the other calls that are coming in, he can't not be in that area and see what happens, because the other calls come in shortly thereafter, and they're traveling north from the Gettys area, traveling southbound on Superior. They see it.
I've heard this gets really spicy. That's why we're watching this. It's about an hour long. We've skipped ahead through, 10, 15 minutes of it.
So again, I'm not here, I don't.
I get the feel that the judge doesn't like doing what he's about to do.
Here to worry about what's charged, what's not charged. I have to mete out the best sentence I can with what I have. And I will let you know, and counsel, I will give you an opportunity if you want to somehow or another speak with your client prior to the court imposing sentence. But I do believe that jail time is appropriate given what I see. I can't, in giving that, I can't bring back these young ladies. I told the parents, I can't do that. But I certainly can do the best that I can to make sure something occurs. If I believed that Mr. Torres was not present, that it was, as it was portrayed to this court, a circumstance where he could not have seen it, that he would have been so far down on Superior that he wouldn't have seen the railroad tracks, then that's where I would land. And I would have no problem landing with that and justifying it. I can't, based upon his own statements, justify that as being true. He had to see it. He's telling me he's 2 to 3 cars behind them, that he's following them, and that he's at first, and it's a clear shot to those railroad tracks. If somebody wants to tell me how I can come to a different conclusion, then please tell me that. But I can take into account in terms of sentencing whether or not a defendant is being truthful with the court in terms of what they're saying. And I will be blunt. I'm just a plain talker. I don't believe that he is. Counsel, if prior to Mr. Torres is, I don't know that you can see him or not, he really wants to make a statement, I will arrange, counsel, I know you don't want him to. If you want, because since you're not here, if you want to talk to him, I will arrange to get him on a Zoom and get you guys into a breakout room so you can talk.
No, Judge, that's fine. I'm ready to make a comment when you're ready to hear it. I don't need.
Go ahead, sir.
Judge, with all due respect, this is wildly inappropriate. For you to be doing an investigation on your own, for you to be pulling up.
Counsel,
go ahead, Judge. You're the boss.
Counsel,
yes,
Judge. Stop a moment. I think I acknowledged that I'm not here doing an investigation. The question is what was represented to this court is that he could not have seen it, that he was not following them. Anything that I have here is not an investigation. All I did was listen to the 911 and read the police report. So in that case, if you think that's inappropriate, then fine, you can go ahead with your statement. And then I will proceed to my sentence.
Right. In addition, Judge, you pulled up a map and you said that it's impossible to see, where the accident was without actually being at the scene viewing it. There was no trial. There was no any opportunity for the defense to present you with counter evidence or anything like that, Judge.
Counsel, what do you want to give me? What do you want to give me?
I don't want to give you anything.
What do you want to give me? No, Judge, counsel, if you're going to say I'm being unfair, what do you want to give me?
Judge, I want to tell you that I don't believe you should be considering anything that will occur after that.
What you represented to this court, and I realize you're advocating for your client about him being someplace further from that scene, it's not true. It's his own statements. These are not anything where I went out there and I'm looking at something or I'm doing whatever. It's just placement. He's saying he's at first. I just listened to the tape. I didn't do anything. I didn't go out there and investigate, talk to any witnesses, do anything like that. I did that and looked at a map. That's all I did.
Right, Judge.
So if you want to give me something, counsel, you can come here 2 hours late. Give me what you want to give me.
Judge, I don't believe you should be considering anything after the fact of the initial accident. He's being sentenced for failure to stop at a PD exit. It has nothing to do with what he did afterwards. It's completely inappropriate for the court to be.
What he did afterwards?
After the accident, when he was initially rear-ended, that's what he pled to, failing to stop at that accident. It's not failing to stop at the accident that the girls were involved in. It's failure to stop at the accident where he was rear-ended. Ms. Reiser agrees.
If your client, knowing what I'm going to do, wishes to withdraw his plea, I will consider that motion.
Judge, I would also ask that you recuse yourself at this point.
Boom.
Denied.
Understood. And I can, if you wouldn't mind allowing me to speak with Mr. Torres, my guess is he's going to withdraw his plea.
I'm sorry?
If you wouldn't mind allowing me to speak with Mr. Torres to make sure this is going to happen, but my guess is he will withdraw his plea.
Can we set up a breakout room for Mr. Torres in signing on to Zoom in one of the conference rooms? Mr. Torres, we're going to put you into one of the conference rooms out there. We're going to put that machine into a breakout room and put your counsel into a breakout room so you guys can talk. Court will stand in recess.
All right.
Whoa. Wow. So that happened. I'm gonna just take a quick peek and see if we come back here. Let's see. Recess. Still in recess. Oh, they're back. Hang on. Hold tight. Okay. They just barely got back. Just trying to find the moment where they turn the camera back on. Let's cut to right here. There we go. The rare shot of the judge's chambers. Did you see this? Let's go back just a couple seconds. Okay, watch his spinning chair. He must have just gotten up. So we've got like 30 seconds or so to catch up. I wonder if defense is right here. The ominous spinning chair. What if defense is right here? We've got the judge seems to be taking information that's known to him outside the evidence that was presented in court into account as he. There's the spinning chair. Attorneys are getting back on. What in the world? Wow. Defense attorney is back. He might consider moving to a new jurisdiction so he doesn't have to practice in front of this judge anymore. Let's see.
All right. 14A District Court is now back in session. The Honorable Judge Ayden.
All right, we're back on the record in the, is everybody here? Yes, they are. We're back on the record in the Torres matter. Had an opportunity, well, first of all, that counsel had an opportunity to speak with his client. It's been also an opportunity for the court to speak with counsel. They are going to consider a motion to withdraw the plea, or the other end alike. The court is going to give the opportunity for them to file the written motion to do so if necessary. I'm not saying that that's what they're going to do, but give that opportunity. So I'm going to adjourn these proceedings for the motion as well as sentencing. I'll set both at the same time to March, my next sentencing, March 13th.
I'll put that on the calendar.
And I want a special time so that
I want a special time too.
3 p.m.
All right, March 13th at 3 p.m. for a continuation of the proceedings. I have directed counsel that everybody needs to be in person at that proceeding.
Understood.
All right, bond will continue. Thank you.
All right, thank you.
3 p.m. All right. That's how it ends. So we've got that added to our docket now. Wow. So here, what happened? What I can gather from this case is that we have a defendant who pled guilty to leaving the scene of an accident. There was an accident where he was struck, possibly, or he struck the other vehicle. I don't know what happened, but the accident occurred. There was another vehicle that had two, I believe, teenagers in it, younger girls. And that accident, he left that scene and he was chasing, in theory, the other vehicle. And it ended up in a accident where the other vehicle crashed and the kids rear-ended him, 3 teens, but two, at least two, possibly 3, lost their lives in that accident. That secondary accident by the railroad tracks. And now the judge, there was a plea where he took a plea to leaving the scene of the accident. The judge is saying, well, now because I know what happened and because I know the area, I'm going to sentence you to, I'm not going to accept the terms of the plea. I'm going to add some jail time to him, which means that he has the right to withdraw his plea. And now this may go to court in front of the judge. Anyway, March 13th. Wow, it's going to be a spicy one. We're going to add this to our little calendar. March 13th. I don't know the defendant's name. We'll have to find that later. This is... We'll put spicy and bold on that one. Wow. All right, Torres. Torres is his name, Defendant Torres. Thank you for that. Ann Arbor, Michigan. Okay, so that's going to be right before Robert Tellis's trial, accused of killing an investigative journalist, and shortly after Robert Crimo's trial, 4th of July parade shooting in Illinois. Let's see what else is happening there in March. We've got Bridget Williams, a cop car theft. That's also with Cedric Simpson on the February 22nd. Let's see, not a ton. Anything else? We missed one. Hey, I've got an outside call coming. Hang on. Mattis, it's been a while since we've talked. How are you doing?
Yeah, it's been a while. I've been partying a little bit because I have a lot of family birthdays in February.
Do you need me to sing to them?
What? I did mention my dad, but so Stefan had his birthday on the 2nd, and then on the 12th, my aunt Karin and also the family dog Ronja. I'm actually named after a Swedish children's book, great author Astrid Lindgren. The book is Ronja Räubertochter.
Anya or
yeah, Ronja.
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 Ronja the robber's daughter?
So the English, yeah, Ronja the robber's daughter. And there's a great, very faithful adaptation of that book as a movie. And it's a very great movie. There are the Mattes Räuber, the Mattesburg, the Matteswald.
I envision this is how you live.
Great fantasy.
I've seen the movie. I envision that's how you live. Yeah. That's your home. What it looks like.
Yeah, it's fantastic.
It's a good book.
Yeah, and also, so I also have an uncle that's so the husband of my aunt has a birthday on the 22nd.
Wow.
So I might
nonstop party.
Think to them.
Oh, okay.
Yeah. So we're going to celebrate that next week on Saturday.
Yeah.
So that's the big family party.
Make sure you put their name in chat, that you give me a pronunciation guide.
Yeah, I will.
And maybe write it in crayon so I can understand, because I don't want to mess up the pronunciation. But it sounds good. Well, what's on your mind? Did you see this last little bit with Cedric Simpson?
Yeah. So I tried to understand what happened here in this case, and it looks like there was. So I see an article that's like Fox 2 Detroit. This was published August 2, 2021. Mm-hmm. And so it says there was a violent crash in Superior Township. car hit a railroad crossing and rolled over. And apparently, what happened is there was this crash happened after the sheriff's office received a call about a hit and run involving that car. So from what I reconstructed here is that car hit the car of Mr. Torres and did a hit and run.
Yeah.
And then Mr. Torres chased them. And the charge against Mr. Torres is he left the scene of the accident where he was rear-ended. But because he left the scene of that accident, he followed the car that hit him. And apparently, because of the chase, I'm guessing that's the insinuation that the judge or the state might be bringing. Because of the chase, worst case scenario, is that the car that hit him earlier hit this rail crossing and tumbled over, and the two teenage girls died. So that seems to be how you would get a big sentence against the defendant.
Yeah.
But I am very much in the boat of the defense attorney that when you they had a plea deal, they say, okay, I'm pleading guilty to leaving the scene of the accident where I was rear-ended. And then the judge says, okay, he reads what's in the record, like he listens to the call and reads the police report, and then he looks at the map. And I guess the implication is, well, because he left the scene of the accident, he followed he did that because he wanted to follow that car. And based on the way that things played out, I'm sure there's going to be stuff in the police report. The car that hit him initially then crashed, and I guess the insinuation is the reason he did nothing to say save these girls is because he didn't see them. And now the judge says, well, based on this map, I think he should have called the police about something. Hey, the car that hit me earlier and I chased has now crashed into like this train barrier, whatever you want to call it, and maybe two teenagers died because that's what you would find immediately. And so the judge is angry because the plea deal before him leaves out a lot of circumstances that make the defendant look bad. But I think the defense attorney made a lot of good points. Like, well, he had a guilty plea, so there's no trial, and so it's not like he has a chance to prevent the defense. So when the judge now looks at this map, it's not like there's an avenue the defense has to now argue against the circumstances of the map. They could maybe call, what is he supposed to do? Call a witness and explain why the judge is wrong? They're in sentencing.
Yeah.
And I think it's improper for I guess the argument I would make is, well, you weren't allowed to do research in the form of looking at the map. So any reasoning you have as a result is basically, let's call it fruit of the poisonous tree, and you're not allowed to consider that. So if I misrepresented something to you because on what my client told you, you're not allowed to believe that my client lied to you because you weren't allowed to look at the map. So everything, basically, we go backward in your argument and throw everything out.
Yeah.
And I think that's how you should do it.
I think the defense attorney is right in this case. I don't like the idea of the judge bringing in outside information into the court and saying, well, because of this, because of what I know, even though this wasn't brought up, this wasn't, and honestly, it wasn't charged. Okay. He can be mad at this, but prosecutors did not charge him with. Yeah.
It's the state's job to go further if the judge thinks it's appropriate. And so the judge can reject the plea deal, but he can't say he rejects the plea deal because the charges are inappropriate, because when the prosecution says we charge with this and he pleads guilty, he can't reject the guilty plea. He can only give a different sentence. And because when he pleads guilty, well, it's not like you can go after him for everything else because of double jeopardy. And the judge doesn't like this, but the problem here is, I guess, the research issue. if the facts are accurate and if he was allowed to think about it.
I think the judge has tied his hands as well because he showed so much emotion and got so involved in this that now if this goes to court, he's going to have to recuse himself. I just can't see that this would be able to go forward with Judge Simpson, and him being able to. He's already said he doesn't believe the defendant is telling the truth, based on outside knowledge that was not brought in, and now with him withdrawing the plea and going to trial. And it might be a risk. The prosecutors might change the charges. They might charge him with more next time around. I think they can still do that. But I think I like Judge Simpson. I like him a lot, but I think here he overstepped.
Yeah, I think his reaction is totally understandable from an emotional standpoint, but from a procedural standpoint, he can't do it. I think the defense is. I
think what was happening is you've got somebody who probably I don't know about prior convictions. It's probably a first conviction. Okay, this isn't like a criminal that was just rear-ended. Happened to be a repeat offender who got in a car accident and caused this whole chain of events. So you've got somebody who's a first-time offense who is charged with leaving the scene of a crime, and there is no. By the book, that's a slap on the wrist. Okay. There's a small fine. It's like, oh yeah, you might be arrested, 3 days in jail, time served, 60 days probation. And so the judge is looking at, I just pulled those numbers out of the air. It could be different. But the judge is looking at that, and then he's looking up and he's seeing the family members of the dead girls. And they're saying, we want justice for our kids. And he's trying to find the balance in between. And the way that the state charged this, it left him almost nothing. I think even had he gone through with this and the defense had not made any statement, I think the families would still be very frustrated with the resulting sentence because it would be very light, even with jail time. 60 days in jail. Leaving the scene of an accident, it's not one of those serious crimes that we like lock people up for lengthy times. So interesting. We'll see what happens. I guess we've got a few more days. Mattis, thank you very much for the call. It's always great to talk to you.
This actually seems like it could be, if you want to go really serious, it could be an involuntary manslaughter case resulting from a car chase. But they'd have to charge that. This and said the facts aren't there.
They'd have to charge it, and they'd have to be able to prove that he followed them, and the girls were fleeing for their lives, and that's where they were speeding because they were worried about what he was going to do, and it's a difficult thing to prove. So.
Yeah, the only thing they seem to have is based on the map. He, I guess, saw the girls, but there's not evidence to get a chain of causation going.
And also, just the whole Google Maps, it looks really clear on Google Maps. But if you got 3 cars ahead of you, as he testified, he could have not seen the accident whatsoever. He could have been checking his rearview mirror and not seen the accident just because it happened ahead of him. I've had an accident happen ahead of me and I didn't see it. I just was like, oh, why is all that dust up there? Well, I should have seen it. There was nothing between me and it, but I was checking something else. I was looking in my rearview mirror at the time. I didn't see the accident. But anyway, what a note to end on. With that, we have to call it a quits for the day, and I'm going to go try not to injure myself at a trampoline park. Fingers crossed.
So. I hope you have great fun there.
I hope so as well. Mattis, thank you very much. It's great to talk to you again. Talk to you again soon, all right?
All right.
We'll see you.
Okay. Bye.
All right, we are going to wrap up right there and end for the day. I still have some editing to do. Once I get the video edited, I'm going to share the link of my son's little piano piece with you. We'll do that. I'm not saying you have to go out and vote for it because a few hundred people going and voting for it could very well swing the whole competition. Could swing the competition. All right. Yeah, we did have a car chase this morning and then Spicy Simpson to end. Wow. All right. We're good. Did you get the links to the burner? Were you able to access those? Some of them, yes, there's a... Josh, you sent the one from Twitch, right? Twitch. I have to look into that one a little bit. It's one of those that's only live when it's live. You can't rewind. You have to catch it in the moment. It's a tough trial to follow for that reason, but I'd like to watch that in the future and see if something important's coming up there that we can follow. All right. Happy Valentine's Day. we're going to give you guys a little bit of break. Go, if you're able, go do something special or say something nice to your Valentine, or just to anybody, even if they're not your Valentine. Tonight, when you go home, please hug the people you love. Smile at someone. Make that day just a little bit better. And please stay safe till we go live again, which will be tomorrow morning. We're going to continue. I'm going to record Thurston County jury selection tonight. And then we're going to continue with the court case up in Thurston County tomorrow. So we're going to get to watch jury selection, and then we're going to go through the court case, which is always good because they have brand new lawyers. Again, it's wonderful. So thank you all. Thank you all. We're going to wish me luck as far as the trampoline park. I will try very hard not to get injured. But worst case scenario, I'll be on crutches tomorrow. So you guys be good to each other. We'll see you. Bye-bye.
When are we going to break for lunch, Judge?